lordship list directed the list today. So scan agot late aitu. Request for 2:30 emerge. 31st is the last date of these shops.
2:30.
Yesterday I tried to move a matter, did not insist, my lord, because the lordship said it will come in usual course. What has happened is yesterday afternoon the PDO has come to the solar plant and threatened to shut the plants in 2 days for recovery of tax. Which is why, my lord, I am told that on regular auto list will come tomorrow, but just out of abundant caution going for tomorrow, my lords. Yes.
Inna vacation agilla, summer vacation.
I'm very sorry.
Totally regular course.
President of a panchayat is now removed and disqualified from the membership. Now defamatory statements are being made on the on his disqualification in the newspaper, local newspapers and the local news channels. It will be taken up tomorrow, my lord.
What are you moving before us for? Defamation is not before us.
No, it is he's removed by the actions of the panchayat. So it comes under the classification of LB itself.
Removal challenge ಮಾಡಿದೀರಾ?
ಹೌದು.
ಅದು ಕೊಡಿ ಮಾಡಿ ಡಿಫಾಮೇಷನ್ ಏನಕ್ಕೆ ಹೇಳ್ತೀರಾ?
It will be taken up tomorrow, my lord.
Saturday. We can only ask them to do as per law. A na we can't convert to B. We can't direct a mandamus like that, Shashidhara. We can't even do that. We can do only as per the law. I produce money. Release madamala. ಮತ್ತೆ ಯಾಕೆ ಹೇಳಿಲ್ಲ? Next week ಯಾವ ತರ ಅನ್ಕೊಂಡು. Nothing will happen. Saturday it will come. Saturday it will come, Mr. Counsel. Yes.
Adjournments. Number 1, page number 2, serial number 8. Page number 3, serial number 9 to 13.
Then we are ready, my lordship. 2017 matter, you're opposing. No adjournment. Next.
Page number 4, serial number 14 to 17.
1 week's time, my lords. I'll inform Nayak also. Some judgments I have to accumulate, and finally it was heard by your lordships regarding STRR, my lords, whether the property can be acquired without that. But he said the rules are not challenged.
Counsel for the petitioner released on 4th February. It is made clear that no further adjournment would be granted if arguments are not advanced on that date. Petition will be liable to be dismissed for non-prosecution. Cell number? 17 at the request of counsel for the petitioner released on 5th February. It is made clear that no further adjournment will be granted if arguments are not advanced on that date. Dismissal.
Page number 5, serial number 18 to 20.
My lord, serial number 20, my lord. I also informed the respondents, my lord. I am for the petitioner seeking for adjournment, my lord.
ಏನಕ್ಕೆ 2018 ಮಾಡಿ ಯಾರು ಕೇಳ್ತಾ ಇಲ್ಲ ಅಂದ್ರೆ adjournment
ಫೈಲ್ ಇಲ್ಲ. Kindly adjournment may be
4th February if arguments are not advanced dismissal. ಇದೆಲ್ಲ ಇವಾಗ dismissal ಏನು ಹೇಳ್ತಾ ಇದೀವೋ under the caption dismissal. So ಮಧ್ಯದಲ್ಲಿ ಎಲ್ಲೋ ಬಂದ್ಬಿಡತ್ತೆ, you won't escape ಅಂತಿಲ್ಲ.
Page number 6, serial number 21 to 25.
26, my lord. In this
21 to
petition,
25.
26, my lord.
26 ಕರ್ದಿಲ್ಲ. 21 to 25 anything?
I need to change some amendment.
The council 21 to 25 ಕರ್ದಿರೋದು, please.
Page number 7.
ಯಾರಾದ್ರೂ ಇದಾರಾ ಅಂತ ಕೇಳ್ತಾ ಇದೀವಿ. 21 to 25. Yes.
Other side inform, my lord.
ಆಯ್ತು ಕೂಗ್ತಾರೆ ರೀ ಸರ್.
Page number 7, serial number 26 to 28.
ಇವಾಗ ಹೇಳಿ 26.
26, my lord. In that 1 week time, I need to some carry.
ಮಾಡಿದೀರಾ respondent ಗೆ?
Respondent in government, I inform.
Inform ಮಾಡ್ಕೊಂಡು ಕೂತ್ಕೊಳ್ಳಿ, ನಾವು adjourn ಮಾಡಲ್ಲ. There are 2 other councils there, not adjourned.
Page number 10,
Hey,
number 29 to 31.
29 to 31.
Page number 11, serial number 32 to 34.
My lord, serial number 32, my lord, become infructious, my lords. With respect to it, I've also filed a memo.
Petitioner, you filed a memo?
I've already filed it on 23rd of Jan.
Petitioner is
2026.
before this court seeking for the following relief. Memo has been filed, dismissed as infructuous.
Please, my lords. Great.
Page number 12, serial number 35 to 39. Page number 13, serial number 40 to 46. Page number 14, serial number 47 to 51.
Serial number 49, my lords.
Yes.
Your short accommodation. The counsel.
Have you informed the respondent?
Yes. Yes.
Sure.
Will
Yako doubt agtade.
no, sir, will
You are not informed.
will
If you're not informed, please don't mention. Next.
Page number 15, serial number 52 to 56. Page number 16, serial number 57 to 61. Page number 17, serial number 62 and 63. Page number 18, serial number 64 and 65. Page number 19, serial number 66 to 70. Page number 20, serial number 71. Page number 21, serial number 72 and 73.
73, my lords. 73, my lords. I am for respondent number 58. my lords. I have informed
Respondent
the
number?
petitioner. Respondent number 58, my lords.
Uh,
I have informed the petitioner. I will file statement of objections, my lord, in a couple of weeks' time.
73. Counsel for respond number 6 to 8 seeks fund is granted 2 weeks' time to file a statement of objection. Objections, if any, by 16th February, released on 19th February. Interim order ಏನಾದ್ರು ಇದ್ರೆ ನೋಡಿ
ಇಲ್ಲ
extend.
sir. That's all, my lord.
Page number 22, serial number 74 to 78. Page number 23, serial number 79 to 82.
Lords, 81. I've informed the respondents, my lords. Fourth,
All
your
of them?
lordship. All of them, yes. Fourth, your lordship.
At the request of counsel for the petitioner, released on 4th.
81.
Page number 24, serial number 83 to 86. Page number 25, serial number 87 and 88. Number 2, page number 2, serial number 7 to 9.
Ninety-three. 94. Memo for withdrawal. Dismissed as withdrawn.
My lords, serial number 113, filing a memo for withdrawal.
113.
Yes, my lords.
Have you filed the memo?
No, my lords, I've just handed over. Dismissed as withdrawn, my lords.
Dismissed as withdrawn. Memo is filed.
Submission, my lord. First of all, my apology, my lord. Serial number, list 1, serial number 2, my lord.
List number?
List number 1, serial number 2, my lord.
Serial number 2.
Yes, my lord. Last date of hearing, I am not aware, my lord.
ಇಲ್ಲೆಲ್ಲ dismissal ಗೆ ಇದೆ ಕರೆದವಾಗ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ.
Senior today is not feeling, other side also inform, my lord. Inform ಮಾಡಿದ್ದೀನಿ son, other side. I inform, my lord.
Any objection?
Tomorrow ಇಲ್ಲ, I will argue.
Not well ಅಂತ. It's submitted, list 1, serial number 2. It's submitted, arguing counsel for the petitioner is
Serial number.
released on 11th. It made clear that no further adjournment will be granted if arguments are not advanced, dismissed.
Serial number 113, my lords. Serial number 113. Your lordship has pleased to appoint me as a court commissioner.
113 ಇವಾಗ
A withdrawal file ಮಾಡಿದೆ. I filed my spot inspection report.
113 ಏನೋ withdraw ಮಾಡಿದ್ರೆ.
Withdraw ಮಾಡ್ತಿದ್ದೆ, ನನ್ನ court commissioner ಅಪಾಯಿಂಟ್ ಮಾಡಿದ್ದೆ. So report file ಮಾಡಿದ್ದೀನಿ.
ಇದು ಆಗಿದೆಯಾ?
I received my fees.
You received your remuneration. Grateful. The 113 ಅಲ್ಲಿ court commissioner has filed his report, the same is taken on record. Filed a memo, dismissed as withdrawn.
ಸೀರಿಯಲ್ ನಂಬರ್ 6 ನಮ್ಮ ಲಾಯರ್ ತೀರೋಗ್ಬಿಟ್ಟಿದ್ದಾರೆ ಸರ್, ನಮ್ಗೆ ಒಂದು ತಿಂಗಳು ಟೈಮ್ ಕೊಡಿ.
ಲಿಸ್ಟ್ 1 ಲಿಸ್ಟ್ 2 ನಂಬರ್ ಏನು, ಕೇಸ್ ನಂಬರ್ ಏನು?
1806. List 1. List 1.
6068.
List 1.
ರಹಮತುಲ್ಲಾ ಶರೀಫ್ ಇರೋದು. ಏನ್ ಬೇರೆ ಕೌನ್ಸಿಲ್ ಎಂಗೇಜ್ ಮಾಡ್ತೀರಾ? ಸೇಲ್ ನಂಬರ್
ಒಂದು ತಿಂಗಳು ಟೈಮ್ ಕೊಟ್ರೆ ನಾವು ಲಾಯರ್ ಬೇರೆ.
List 1, serial number 6. It's submitted that the counsel for the petitioner is expired. ನಿಮ್ಮ ಹೆಸರೇನು?
ಅಖಿಲ್ ಪಾಷಾ ಸರ್.
Shri Akhil Pasha, the petitioner is before this court. He submits that his counsel is expired. He seeks for and is granted 2 weeks' time to engage a new counsel. Relist on 25th February.
25th and 26th, I have inconvenience.
24th February?
Please.
24th. 24th ಒಳಗೆ ಹೊಸ ಕೌನ್ಸಿಲ್ ಕರ್.
List number 2, fresh matter, serial number 1. Nagamosha Nayak.
Lords, I am for the petitioner, my lords. Lords, I am seeking quashing of the endorsements.
Washing of the endorsements.
Yes, my lords. They issue the contradictory notices and also endorsement, my lords, by saying that I am constructing the building. Lords, I have constructed the building in the year 1990 itself. From then, I am in the possession of the property. Lords, kindly come to page number 22, my lords. Endorsement issued.
Where's the photographs of the building?
Sorry, my lords. Photos produced Madila Swami. It is in the year 1990 itself I have constructed.
Taxpayer and produced Madidira?
Yes, my lords, I have. It is at page number 19 to.
Page number?
19, my lords. 19 to 21, my lords.
ಅದು 23, 24 ಅಪ್ಪ.
Kindly come to
20 ವರ್ಷ ಅಂದ್ರೆ ಹಳೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೀರಾ?
ಅಲ್ಲ ಹಳೇದಿಲ್ಲ ಸ್ವಾಮಿ. 22, kindly come to page number 22, my lords. Endorsement issued by Corporation City Bangalore. At that time itself I have been given Khata certificate and also.
ಅದು ಹೌಸ್ ಸೈಟ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಅಲ್ಲ. ನೀವು ಕನ್ಸ್ಟ್ರಕ್ಷನ್ 90 ಅಲ್ಲಿ ಮಾಡಿದೀರಾ ಅಂತ ಏನಾದ್ರು ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೀರಾ? Photographs produce ಮಾಡಿ, earlier tax paid produce ಮಾಡಿ.
Please, my lords. My lords, kindly come to page number 53, my lords.
23.
53.
53.
Yes, my lords. Order dated 2/12/2022 by this honorable court, my lords. Wherein I have produced the original sanction plan. At that time, by considering that sanction plan, this honorable court has granted me the stay.
ಎಲ್ಲಿ sanction plan ಎಲ್ಲಿದೆ? Where have you produced it? You have produced it here?
No, my lords, not in this petition. In the earlier petition, I have produced, my lords.
Counsel, ನೀವು ಈ petition ಯಾವಾಗ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾ ಇದೀರೋ ಇದ್ರಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಬೇಕೆಲ್ಲ.
I will produce it tomorrow itself.
Tomorrow.
Please.
Lord Counsel for the petitioner seeks for
till such time, my lords, letter not issue any.
To place on record the photographs of the property in question, to tax paid receipts. ಯಾವ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಅಂತ ಹೇಳಿದ್ರಿ ನೀವು?
1990, my lord.
From the year 1990, the sanction plan in respect to the said construction released on Saturday 31st.
Till such time, my lords, letter not issue any notices, my lords, because, my lord, I am producing one document. She wants to disconnect the electricity. Respondent number 4.
It's only an endorsement that they have given.
No, my lords, now I have produced, my lords, along with memo.
It's a case where directions are issued to both the complainant and respondent to take action. Like
In person of WA 112 and 1301.
It's a neighboring property when both have given
Lords,
complaint.
only the point that was considered was AEE cannot issue the notice. My lords have quashed the order, my lords. Quashed for 248A. It was set aside.
Zonal commissioner.
Yes, my lords.
Yes.
It was set aside, my lords. Now my contention is my building was constructed in the year 1990 and I am in the possession.
Carry out an inspection. As to what it is. We'll carry out, the entire thing indicates you got a sanction plan recently.
Yes,
and
my
you have constructed contrary to the sanction plan.
No, my lords, I have obtained sanction plan in the year 1990 itself, my lords, because I have produced that in the last petition, my lords.
Have you constructed as per the sanction plan?
Yes, my lords, I have constructed as per the sanction plan.
And AG accepts notice for respond number 1.
But still such time let there be.
Yes. Pawan Kumar accepts notice for respond number 2, 3 and 4. Respond number 4 along with the jurisdictional additional director town planning shall cause inspection of the property of the petitioner. So and so. Since the order is passed in the presence of the counsel for the petitioner, inspection to be carried out commencing from 10:30 AM on 2nd February 2026. Report to be submitted by 6th February, released on 10th February. Until then, respondents are restrained from taking any coercive steps against the property of the petitioner. If the construction is...
No, my lords. My lords, one submission, my lords. ಇದಾದ್ಮೇಲೆ ನಾನು ಏನಾದ್ರೂ ಒಂದೇ ಒಂದು ಇಟ್ಟಿಗೆಯನ್ನು ತಿರುಗಿಸಿಲ್ಲ ಸ್ವಾಮಿ. If they file a report, my lords, I am ready to withdraw the petition. Yes, my lord, I am ready to withdraw.
ವಿಡ್ರಾ ಮಾಡಿದ್ರೆ ಆಗಲ್ಲಪ್ಪ, ಇವಾಗ ಬಂದ್ಮೇಲೆ ಕಷ್ಟ ಆಗತ್ತೆ. ಅದಕ್ಕೆ ಕೇಳ್ತಾ ಇರೋದು.
ಇಲ್ಲ, ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡ್ಲಿಲ್ಲ ಸ್ವಾಮಿ.
ಆರ್ಡರ್ ಮಾಡಕ್ ಮುಂಚೆ ಕೇಳ್ತೀವಿ, ಆಮೇಲೆ ಡೆಮಾಲಿಷ್ ಮಾಡ್ಸಕ್ ನಮ್ಗೂನು ಬೇಜಾರು, ಬಟ್ ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ. That's the problem.
Great.
M. Shivaprakash.
Yes.
Land in Mysore Kasba, Bogade, an extent of 4 acres, 20 guntas was acquired by this Railway Employees House Building Society. And after acquisition, they formed a layout. And after forming layout, the sites are also allotted to the members. Now I am the owner of that land, where I have been given incentive site as well as one site. Annexure A is the land losers site. Way back in the 1997, my lord. After giving this, my grandfather, who has also gifted this property to children. I am one of the person purchased from this one of the children and made an application with the Bogadi Gram Panchayat to issue Khata as well as sanctioning of the plan. My lord, the Panchayat has granted Khata to me at page number 42 at annexure E, my lord. E they have issued. And again, I paid up-to-date tax also. Then I applied for sanction of the plan for the construction of my dwelling house. My lord, annexure is at page number 47G. They have sanctioned the plan.
Asking for quashing of a notice.
My lord, some busybodies, it is their busy.
Notice, you reply to it.
I replied and also given all the documents and all the.
Have you replied?
My lord,
Where is the reply? Where's your reply?
Annexure J.
J is a notice.
K ಹಾಕಿಲ್ಲ ಇದು ಹಾಕಿಲ್ಲ.
K ಹಾಕಿಲ್ಲ.
My lord,
ಇವಾಗ reply ಮಾಡಿದ್ರೆ they will pass orders.
Reply ಮಾಡಿದ್ದಾರೆ. May I request my lord to call it tomorrow because it's inadvertent mistake. My colleague has
28/4/25 notice.
Correct. I placed all the document as well
Orders
as
ಆಗಿಲ್ವಾ ಇನ್ನ?
reply also.
Orders ಆಗಿಲ್ವಾ ನಿಮ್ reply?
Orders ಮಾಡು ಇಲ್ಲ, ಆಮೇಲೆ unnecessarily are causing obstruction and also causing stoppage of my dwelling house.
Mysore ಯಾರಮ್ಮ?
ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ ಚಂದ್ರಕಾಂತ್ ಅರ್ಗೌಳೆ.
ಪಟ್ಟಣ ಪಂಚಾಯತ್ ಬೋಗಾಡಿ. ಯಾರು ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲರ್?
ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್ ಮೊದಲು ಸೋಮ್ಯಾಜ್ ಇದ್ರು, ಇವಾಗ ಯಾರಿದ್ರು?
ತಾಲೂಕ್ ಪಂಚಾಯತಿ ಅಂತ ಮಾತಾಡೋದು.
ಪಟ್ಟಣ ಪಂಚಾಯತ್ ಬೋಗಾಡಿ.
ಬೋಗಾದಿ.
ಮೈಸೂರು. ಹೇಳ್ಬೇಕು.
ಅಲ್ಲಿ ಮೈಸೂರು ತಾಲೂಕ್ ಪಂಚಾಯತಿ ಮಾತ್ರ ತಗೊಂಡಿದ್ರು.
ಮುಂಚೆ ಸೋಮ್ಯಾಜಿ ಅವರಿದ್ರ?
ಮೊದಲಿದ್ರು.
ಅವರಿದ್ರೆ ನೀವೇ ತಗೊಂಡ್ಬೋದು. The MS Devraj is directed to accept notice for respond number 2 and 3. Notice to respond number 4 is deferred for now. Counsel for the petitioner submit that he has replied, the petitioner has replied to the notice dated 28/4/2025 at annexure J. He seeks for and is granted a week's time to place the same on record. Counsel for respond number 2 and 3 is direct, counsel for the petitioner is direct furnish 2 sets of the petition along with annexures on Shri MS Devraj and counsel for respond number 2 and 3, who is called upon to make his enquiry as to whether any orders are passed on the reply submitted by the petitioner. Relist on 5th February. Mysore. Relist on 10th February.
After 17th
action ತಗೊಂಡ್ರೆ.
Construction of my dwelling house are available loan also. They have stopped.
Then ನೀವು ಜಾಸ್ತಿ ಟೈಮ್ ತಗೊಂಡ್ರೆ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಕೊಡ್ಬೇಕಾಗತ್ತೆ.
10th ಆದ್ಮೇಲೆ
Relist on 10th. IA 1 of 26 is allowed.
Serial number 3, Venkatesh here.
Waiting for the petitioner in this case, my lord. In this case, my lord, the petitioner challenged the impugned order passed by the first respondent, my lord, that is appeal. My lord, before that, my lord, we purchased the property in the year of 2022.
248.
Please, my lord. My lord, in the annexure B, before passing the order, my lord, they have not issued any notice, and there is no mention the date of the impugned order also, my lord. The first initially, my lord, when Rama has filed application before the respondent number 2 and 3, stating that, my lord, the petitioner have encroached the property. Then,
You
my lord,
filed an appeal. Appeal has been considered. Appeal has been dismissed.
please, my lord. But there is a B Khata, my lord, that is not a Khata, my lord. There is a, as per the.
You'll have to do something about this A B Khata.
There is a government notification, my lords, they can apply for B to A Khata.
Allah, they have not received the application from the petitioner, my lord. If court permit, today itself I'll file, but they have not received.
Online application, offline application?
Online, I believe, my lords. But there is a government.
How can they refuse?
No, my lord, there is not in open, there is a B Khata online
People are
application.
applying for B to A Khata, my lords.
Is an online application?
Yes, my.
No,
Online, because now
Sure,
there's. I will just.
Sure, andre ಹೇಳಿ.
Sure, because there is no manual now, my lords. Everything is online.
If it's online, nobody can refuse.
My lord, today itself I'll file, but they have not received, there is no, they have not applied, there is no option to file B Khata to A Khata.
Yeah, it was Saturday, my lords. I will take it.
In the meantime, my lord, they have issued in legal notice on dated 13/1/2026 for demolishing the building, my lord. That is annexed H, my lord.
Kumar accepts notice to respond number 1 to 4. He seeks for granted 2 days time to place a notification which would enable the petitioner to file an online application for conversion of B Khata to A Khata.
There are some conditions, there are conditions in that notification.
Released on 31st. Until then, the respondents are restrained from taking any coercive steps against the petitioner.
But because they are issued a notice to demolishing the building dated 13/1/2026.
Until then, not
Please,
to take
please,
coercive steps in theory.
please.
Bedwa adu.
That is very important. Please, move.
Serial number 4, Vasanta Lakshmi.
I appear for the petitioner, ma'am.
Yes.
Section 144(15) demand notices and orders, my lords. I am not issued with the show cause notice. I have not filed objections, my lords. No opportunity of hearing is granted.
Lot of matters of this kind coming.
Recently, again, it has started, my lords, but we are doing inspection and notices. Show cause notice must have been issued, but without which demand notice
Not
cannot
even
be issued.
Tell them.
They might not have issued it.
140.
Tell show cause notice dated 29/1/25 was issued.
I am not. It is not issued personally to me, my lords. I have gone to the office and collected those notices. Nanik demand notice bandmel ho collect madkondirani.
You produce the acknowledgement of show cause notice.
Yes, ma'am. How it is served.
How were you serving the show cause notice? Now you got all their email ID.
Email ID. Yes.
Email ID ಇದೆ, mobile number ಇದೆ, ಎಲ್ಲ ಇದೆ.
Yes,
You
mobile.
can serve it on them. That is what we are directed in the matter, that you have to collect everybody's.
Yes, ma'am.
You can send it by email or this.
Yeah, even SMSs are going on. Some people have received SMS also.
SMS notice ಹೋಗಲ್ವೇ?
A notice.
You can't do notice by SMS. Unless you do a WhatsApp integration.
By SMS, you are informing that there is some due, so you should come and. By SMS, we are notifying them that there are some dues regarding a property tax. So some link will be also there, my lords. But I understood, my lords.
If link is there to open that notice, then fine.
In this particular case, I will
But
find.
just to say that something is due is not sufficient notice under 144(15).
I will secure instruction as to how show cause notice is served.
You do a WhatsApp integration, like what we are trying to do in the High Court. All the orders, everything will come to you directly. So notices could also be issued. Lord Shri Pawan Kumar accepts notice for respond number 2 and 3, AGA for respond number 1. The contention of learned counsel for the petitioner is that the show cause notice was not served on the petitioner before the notice under section 144(15) of the VBMP Act 2020 was issued. Learned counsel for respond number 2 and 3 seeks for and is granted a week's time to place on record the show cause, the copy of the show cause notice issued to the petitioner along with acknowledgement thereof. He is also directed to place on record the manner and methodology of service of notices by the erstwhile BBMP and now the GBA, whether services are being effected by email, WhatsApp integration and SMS. Released on 12th February. Until then, the respondents are restrained from taking any coercive steps against the petitioner.
Let it be in preliminary hearing. Because if show cause notice not served, then they can file a reply from post office.
We'll treat this as show cause.
Please.
Preliminary hearing.
Serial number 5.
More particularly, we want those details so
Yes,
that
sir.
how you are serving.
Yes, sir.
Unnecessarily, everybody will be driven to court. Last time, there were some hundreds of matters.
Hundreds of matters regarding show cause notices.
And you say that you'll auction the
Yes,
property and throw bitter papa or heart attack. Don't do that. If you have served it properly, yes. The person who owns the house will have serious difficulty if something happens.
Serial number 5.
Lords, for the petitioner. Lords, the father-in-law of the petitioner, my lords, has purchased the site, my lords, in Lakur village under a registered sale deed. My lords, there is a Khata dispute, my lords, between the petitioner and the fifth respondent herein. My lords, the fifth respondent, my lords, prefers, my lords, an appeal before the second respondent, my lords, executive officer. My lords, to kindly see, my lords, page 41. My lords, the executive officer, my lords, while considering the appeal, assumes the power of the civil court. He invalidates, my lords, the sale deed of the year 1976 and passes this order, my lords. He also says that, my lords, fifth respondent is the owner of the property. Page 41, my lords, the second paragraph, third line onwards, my lords. ಅಲ್ಲದೆ ತನ್ನ ಪಿತ್ರಾರ್ಜಿತ ಆಸ್ತಿಯನ್ನು ತನ್ನ ಸಹೋದರರ ಹಾಗೂ ಕಾನೂನುಬದ್ಧ ವಾರಸುದಾರರ ಒಪ್ಪಿಗೆ ಇಲ್ಲದೆ ತಿಮ್ಮಯ್ಯನವರಿಗೆ ಕ್ರಯ ಮಾಡಿ ಕೊಟ್ಟಿರುವುದು ಕ್ರಮಬದ್ಧವಾಗಿರುವುದಿಲ್ಲ. And in the operative portion, my lords, he says that fifth respondent, my lords, is the owner. While exercising powers, my lords, under section 269, my lords, the
AGA accepts notice for respondent number 1.
1, my lord.
Malur Taluk Panchayat. Ms. Devraj for respondent number 2, 3, 4. Issue emergent notice to respondent number 5, written by 4th March 2026. The operation of the order dated 21/8/25 bearing number so and so passed by second respondent at Annexure F. He stayed till the next date of hearing. Consequently, they are restrained from taking any coercive steps against the property in question till the next date of hearing. Process fee and copies to be furnished by end of day 30th January, failing which the interim order will stand automatically vacated.
Deeply obliged. I'll do it today.
You do it. We are giving you time till tomorrow.
Yes.
Serial number 6.
Lord, I place it on the record, the documents pertaining to, along with the memo, where my tea shop was closed, my lord, by the respondent number 2. That property comes under the commercial property, and it is facing 60 feet road. I produced the photographs. It's a discom bill, my lord. Almost.
Mr. Counsel.
Please, my lord.
This is not the way that zoning is classified.
What has happened, my lord, because we have verified with the owner also, my lord. Owner also doesn't have.
You don't need to verify from the owner. You need to verify from the RMP.
Yes, my lord.
ಅದು ನಿಮ್ ಅಷ್ಟು ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡಿದೀವಿ ಅವತ್ತು.
Your lordship, sir,
ನೀವು ಬರೀ ಫೋಟೋಗ್ರಾಫ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರೆ ಕಮರ್ಷಿಯಲ್ ಝೋನ್ ಅಂತ.
Even the Westcom bills also have been produced.
There is a difference between commercial meter
Please.
and commercial zone.
Zone, yes.
So if you don't produce it, we will dismiss your petition.
No, my lord.
I will find out, take instruction.
ನೀವೇನ ಅವ್ರು ಕೊಡ್ಬೇಕು.
Is unable.
It's yours. You are the petitioner.
Yes, my lord.
RMP ನೋಡಿದೀರಾ?
Yes, my lord. Revised master plan.
ನೋಡಿದೀರಾ?
Oh, I have not seen this. I have asked, my lord.
You know how to use the RMP? You know how to refer to RMP?
Yes, Lord, I have gone through it, but I have not received the document.
ಗೊತ್ತಿಲ್ಲ ಅಂದ್ರೆ ಗೊತ್ತಿಲ್ಲ ಅಂತ ಹೇಳಿ ನಾವು ಹೇಳ್ಕೊಡ್ತೀವಿ.
Please, my lord.
ಗೊತ್ತಿದೆ ಅಂತ ಹೇಳಿದ್ರೆ we presume you will know.
No, my lord. No.
So if you don't know, take out the RMP.
Please.
Go to this particular map of this particular area.
Yes.
Identify this particular property or that road. Adardu give us a copy from the RMP. Make a photocopy. It's available on the internet. BDA website allide.
Yes, my lord. We have also obtained this.
Kodi.
This document.
BDM please.
So online only, my lord, in the website of the
This is
DBA.
DBMP. Know your ward. Idu bere.
No, yes, my lord. Please.
Explain to
I
you
will.
how it is.
I will take.
The counsel for the petitioner has filed a memo enclosing a electricity bill and photographs. The same would not suffice the requirement of identifying whether the property, identifying the zoning of the property in question. Counsel for the petitioner seeks for and is granted 3 days time to counsel for the petition submit that by 2nd February you would place the zoning map on record. Relist on 2nd February.
Preliminary.
Matters, serial number 7. Ramesh Chandra, unconnected matters.
This matter was argued last time.
Yes.
3 years' time, within which they ought to have filed a review petition. Last time you last directed, who has changed the Khata?
Karthikeyan?
My lord.
Held up in court. Pass over.
Otherwise, next week.
Party in person is here in person.
My lord.
Pass over.
Serial number 8. Sanjay Reddy.
ಇದು deemed conversion, it's
My
covered
lord,
by
your
the
lordship may kindly pass out. Yogesh Naik will be coming. Pass out.
Yogesh Naik under 230. Pass over.
Serial number 9. Rajay Kumar.
Actually, my lord. The trade license has been cancelled, my lord, without issuing any prior notice. And my lord, in the trade license, my lord, a sentence, my lord, in the page number 24, my lord, Annexure C, my lord, is the trade license issued by the city corporation for running, my lord, say saloon, my lord, unisex saloon. In that, my lord, Annexure A is the, my lord, mentioning in the very same, my lord, trade license that, my lord, your trade license is cancelled on date 9/8/2025 ಅಂತ ಒಂದು ಲೈನ್ ಬರ್ದಿದ್ದಾರೆ ಅಷ್ಟೇ. ನಮಗೆ ನೋಟಿಸ್ ಕೊಡ್ಲಿಲ್ಲ, ಕ್ಯಾನ್ಸಲೇಷನ್ ಆರ್ಡರ್ ಇಲ್ಲ.
ಯಾವ್ದ್ರಲ್ಲಿ
ಪೇಜ್ ನಂಬರ್ 15 Annexure A
15
ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಇದೆ. ದಿನಾಂಕ 9/8/25 ಕೆಳಗಡೆ ದಿಸ್ ಟ್ರೇಡ್ ಲೈಸೆನ್ಸ್ ಈಸ್ ಕ್ಯಾನ್ಸಲ್ಡ್ ಆನ್ ಡೇಟ್ 9/8/2025. ಇದಕ್ಕೆ ನೋಟಿಸ್ ಕೊಡ್ಲಿಲ್ಲ, ಯಾವುದೇ ಒಂದು.
The reason is this, my lord. FIR
issued him a notice.
That's right. 26, page 26, may I just request, my lord. There is a FIR, my lord, that is registered against this petitioner on an extremely serious allegation, my lord. At column number 10. I don't have the.
Yes.
These see the allegations, my lord, that have been made against him.
Really?
ಸ್ಟಾಫ್ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ.
ಈ ಪ್ರಕರಣದ ಸಾರಾಂಶವೆಂದರೆ ಫಿರ್ಯಾದುದಾರರು ಅತ್ತೆ, ಗಂಡ ಹಾಗೂ 3 ವರ್ಷದ ಮಗುವಿನ ಜೊತೆ ವಾಸವಾಗಿದ್ದು, ಫಿರ್ಯಾದುದಾರರು ಬ್ಯೂಟಿಷಿಯನ್ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದ ಸುಮಾರು 1 ತಿಂಗಳ ಹಿಂದೆ ಮಂಗಳೂರು ಡೋನ್ ಬಾಸ್ಕೋ ಹಾಲ್ ಬಳಿ ಇರುವ ಸೋ ಅಂಡ್ ಸೋ ಸಲೂನ್ ನಲ್ಲಿ ಬ್ಯೂಟಿಷಿಯನ್ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದು, ಹೀಗಿರುವಾಗ ದಿನಾಂಕ 4/8/2025 ಇದರ ಮಾಲೀಕರಾದ ವಿಪಿನ್ ಭಂಡಾರಿ ಮತ್ತು ತೃಪ್ತಿ ಭಂಡಾರಿ ಅವರು ಫಿರ್ಯಾದುದಾರರ ಪರಿಚಯದ ಪುರುಷ ಗಿರಾಕಿಯನ್ನು ಕಳುಹಿಸಿ ಅವರಿಗೆ ಮಸಾಜ್ ಮಾಡುವಂತೆ ಒತ್ತಾಯಿಸುತ್ತಿದ್ದರು. ಫಿರ್ಯಾದುದಾರರು ಬೇರೆ ದಾರಿ ಇಲ್ಲದೆ ಎಣ್ಣೆ ಹಾಕಿ ಮಸಾಜ್ ಮಾಡುವುದಾಗಿ ಸಲೂನ್ ನ ಒಳಗೆ ಹೋದಾಗ ಆ ವ್ಯಕ್ತಿ ಭಂಡಾರಿಯವರ ಕೆನ್ನೆಗೆ ಬಲವಾಗಿ ಹೊಡೆದು ಹಲ್ಲೆ ಮಾಡುತ್ತಿರುತ್ತಾರೆ. ಅಲ್ಲದೆ ಫಿರ್ಯಾದುದಾರರ ಟಿ ಶರ್ಟ್ ಕಳಿಸಿ ಅವರ ಮೊಬೈಲ್ ನಲ್ಲಿ ಫೋಟೋ ತೆಗೆದು ನೀನು ಯಾವ ಕೆಲಸ ಮಾಡಬೇಕೆಂದು ನನಗೆ ತಿಳಿಸಿಕೊಡುತ್ತೇನೆ ಎಂದು ಬಲವಂತವಾಗಿ ಫಿರ್ಯಾದುದಾರರನ್ನು ಅರಬೆತ್ತಲೆಗೊಳಿಸಿ ಫೋಟೋ ತೆಗೆದಿರುತ್ತಾರೆ. ಫಿರ್ಯಾದುದಾರರು ಜೋರಾಗಿ ಬೊಬ್ಬೆ ಹೊಡೆದರು. ಆ ವ್ಯಕ್ತಿಯೊಂದಿಗೆ ಸೇರಿ ಬಲವಂತದ ಅನೈತಿಕ ಕೆಲಸಕ್ಕೆ ಒತ್ತಾಯ ಮಾಡುತ್ತಿದ್ದು, ಅವಾಚ್ಯ ಶಬ್ದಗಳಿಂದ ನಿಲ್ಲಿಸಿ ನೀನು ಕೆಲಸ ಮಾಡದಿದ್ದಲ್ಲಿ ನಿನಗೆ ಪುಕ್ಸಟ್ಟೆ ಸಂಬಳ ಕೊಡಬೇಕಾ ಎಂದು ಬೆದರಿಸುತ್ತಾರೆ. ಫಿರ್ಯಾದುದಾರರ ಮೂಗಿನಲ್ಲಿ ರಕ್ತ ಬರುತ್ತಿದ್ದು ಅಲ್ಲಿಂದ ತಪ್ಪಿಸಿಕೊಂಡು ಫಿರ್ಯಾದುದಾರರು ಬಂದಿರುತ್ತಾರೆ ಎಂಬುದರ ಸಾರಾಂಶ. This is the FIR, my lord, that was registered. We received, my lord, a requisition from the police in this regard. I just pass on. I just got this. Place it on record formally by filing a memo. Where, my lord, the police authorities made this requisition and said it is under investigation and we were directed.
Straight away they have cancelled, my lord, without issuing any notice, my lord. They have closed my shop, my lord, since 7 months, my lord. The original complaint is at page number 30, my lord. We have removed that lady, my lord, from our saloon since she was doing some illegal activities in the saloon without the knowledge of the, my lord, the owner. It is, my lord, completely covered under the CCTV, and also, my lord, she has sent, my lord, a apology also video. That is also we have submitted before the police. Page number 30, we have filed a complaint against her, my lord.
Is the jurisdiction of the police to ask you to cancel the trade license?
They said, my lord, that it is under investigation and that is the requisition
So
based on this FIR, my lord, that they.
You have to discharge your duties as per the act. If somebody asks you to do something, you will do it.
Having regard to the serious allegations, my lord, that were made and FIR was brought.
These are still at allegations.
Counter case is also registered.
They're still at allegations. Allegations can be made aplenty. Any complaint filed, you will take action. ಇದು ಯಾವ್ದು? Mangalore City Corporation not discharging its duties properly. Therefore, close Mangalore City Corporation. ಮಾಡ್ತೀರಾ? ಒಂದು police complaint ಕೊಡ್ತಾರೆ ಅವರು. You have to follow law. If there's a serious allegation, no doubt. You issue them a notice, ask for their explanation, consider the matter and pass orders. Instead of 7 months here, you could have done it in 7 days there.
I have given explanation also, my lords. Page annexure F, page number 32 ಅಲ್ಲಿ explanation ಕೊಟ್ಟಿದ್ದೀನಿ. ನಾವು counter complaint ಕೊಟ್ಟಿದ್ದೀವಿ ಅಂತ ಇನ್ಸಿಡೆಂಟ್ ಆಗಿಲ್ಲ, CCTV ಅಲ್ಲಿ ಕವರ್ ಆಗಿದೆ ಅಪೂರ್.
That they will examine.
That is also not
on
been,
the
please.
decision making process. The decision making process is not proper.
ಅದು ಆರ್ಡರ್ ಕೂಡ ಮಾಡ್ಲಿಲ್ಲ, ಅದ್ರಲ್ಲಿ ಒಂದು ಲೈನ್ ಎಂಟ್ರಿ ಮಾಡಿದ್ದಾರೆ ಅಷ್ಟೇ. ನಾವು ಹೋಗಿ ಶಾಪ್ ಕ್ಲೋಸ್ ಮಾಡಿ 6 ತಿಂಗಳಾಯ್ತು.
Petitioner is before this court seeking for the following items. The petitioner claims to the proprietor of a beauty salon and wellness center and operating on name and style of VYBZ Unisex Salon and Wellness Center situated at Crystal Arc Building, Balmatta Road, Mangalore. After obtaining a trade license from the second respondent, Mangalore City Corporation, on 1/4/2025, which is valid until 31/3/2026. The petitioner is before this court aggrieved by the cancellation of the said trade license on 9/8/2025. The submission of learned counsel for the petitioner is that before such cancellation, there was no notice which had been issued to the petitioner, nor is a reasoned order passed as to why the trade license has been cancelled. Notice having been issued, respondent number 2 has entered appearance. Shri K.V. Nitish, learned counsel for the petitioner, respondent, submits that there is a FIR in crime number 89 of 2025 filed against the petitioner and the manager of the petitioner and manager of the salon, making allegations and for as regards offences under section 74, 75, 76, 115(2), 352, 126(2), read with 33(5) of the Bharatiya Nyaya Sanhita 2023, in pursuance of which the SHO stroke investigating officer had written to the respondent number 2, informing about the said FIR and calling upon the respondent to take action. His submission is that it is in pursuance of said correspondence of the investigating officer that the trade license has been cancelled. And as such, no fault can be found there. Heard, Shri Dhananjay Kumar, learned counsel for the petitioner, Shri Nitin, learned counsel for respondent number 2, peruse papers. The short question that would arise for consideration in the present matter is whether respondent number 2 could have acted on a correspondence issued by the investigating officer and cancelled the trade license issued to the petitioner. There is substance in the submission of learned counsel for respondent number 2 that there are serious allegations which have been made against the petitioner in the FIR in crime number 89 of 2025, which has been registered. The investigating officer has called upon respondent number 2, has informed the same to respondent number 2 and called upon respondent number 2 to take action in accordance with law. The same would not mean that the respondent number 2 cancels the trade license without following the due process of law, inasmuch as for the purpose of cancellation of any license issued by the respondent number 2, it is required that a show cause notice is issued, the say of the noticee considered, and thereafter orders passed by following the principles of natural justice and the procedure contemplated under the Karnataka Municipal Corporation Act 1976. None of these having been done, I am of the considered opinion that however good the reasons may be, the decision-making process is required to follow the applicable law and procedure, which has not been so followed. As such, I pass the following order. Writ petition is allowed. Certiorari mandamus ಕೇಳ್ತಾ ಇದೀರಲ್ರಿ?
ಅವ್ರು ಆರ್ಡರ್ ಮಾಡ್ಲಿಲ್ಲ ಸ್ವಾಮಿ ಕ್ಯಾನ್ಸಲೇಷನ್. ಎಂಟ್ರಿ ಮಾತ್ರ
Cancellation
ಮಾಡಿದ್ರು.
ಅಂತಿದೆಯಲ್ಲ.
ಲೈಸೆನ್ಸ್ ಅಲ್ಲಿ ಎಂಟ್ರಿ ಮಾತ್ರ ಇರೋದು, ಅದು ಆರ್ಡರ್ ಇಲ್ಲ.
ಅದೇ ಆರ್ಡರ್. Circular is issued. The cancellation of the trade license bearing number so and so is quashed. Liberty is reserved to respond number 2 to initiate appropriate proceedings in accordance with law.
Hearing on IA, serial number 10.
I am for the petitioner, my lord.
For weeks are contested.
Objection. 23 matter.
Objections.
The IA ಬೇಡ main ಹೇಳಿ 23
ಅಲ್ಲ ನಾನು ಮೇನ್ ಕಾಲ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದೀನಿ. ಐಎ ಹಾಕಿದ್ರು. ಐಎ ನಲ್ಲಿ ಸ್ಟೇ
IA ಬಿಟ್ಬಿಡಿ. Main
Building, my lord, in my petitioner.
Just a moment. Are you ready on the main arguments, main petition?
Ready, my lord, ready, my lord.
ನಿಮ್ಗೆಲ್ಲ ಕೇಳಿದ ಅವ್ರು ಕೇಳಿದ್ರು.
ಮೇನ್ ಮೇಲೂ ಕೂಡ ಸಮ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಅಡಿಷನಲ್ ಬೇಕಾಗಿದೆ. ಯಾಕಂದ್ರೆ ಐಎ ಹಾಕಿದ್ರು ಅದಕ್ಕೋಸ್ಕರ ಪಿಡಿಒ ಬರಕ್ ಹೇಳಿದ್ರು. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಏನಿದೆ
ಎಲ್ಲ ಬಿಟ್ಬಿಡಿ. Argument on IA 1 or 26 will be taken up along with the main. Counsel for respond number 1 to 4 seeks for a week's time to get ready and address his arguments, released on 5th February.
My lord, they may be stayed, my lord. They are constructing the buildings.
5th we'll hear them.
Building ಕಟ್ತಾ ಇದ್ದಾರೆ ಸ್ವಾಮಿ ಅವರ ಒಂದಿಷ್ಟು.
Building if it is unauthorized, we'll demolish it. Don't worry.
ಅಲ್ಲ ನಮ್ ಬಿಲ್ಡಿಂಗ್ ನಾವು ಪಂಚಾಯತಿಲಿ ಗೌರ್ಮೆಂಟ್ ಬಿಲ್ಡಿಂಗ್ ಕಟ್ತಾರೆ ಅದನ್ನ ಇಷ್ಟೇ ಕೇಳ್ತಾ ಇದ್ದಾರೆ.
5th you argue the matter. It's made clear that no further adjournment would be granted.
ಸ್ಟೇ ಕೊಡಿ ಕಟ್ತಾ ಇದ್ದಾರೆ ಸ್ವಾಮಿ.
ಒಂದ್ ವಾರದಲ್ಲಿ ಏನಾಗುತ್ತೆ ಮಿಸ್ಟರ್ ಅಜರ? 23 ಮ್ಯಾಟರ್.
ಫೋಟೋದಲ್ಲಿ ಬಿಲ್ಡಿಂಗ್ ಫೋಟೋ ಹಾಕಿದ್ರು.
ಆಯ್ತು, ಒಂದ್ ವಾರದಲ್ಲಿ 2 ವರ್ಷದಿಂದ ಇದ್ದೀರಾ. ಒಂದ್ ವಾರ ಅವ್ರು ರೆಡಿ ಆಗಕ್ ಕೇಳ್ತಾ ಇದ್ದಾರೆ ಟೈಮ್. Let him get his instructions.
ಫೋಟೋ ಹಾಕಿದ್ದೇವೆ ಸ್ವಾಮಿ ಅವರು.
Next.
Serial number 11. Ramesha GP.
Including.
11 I am for that.
Apply for the petition, no?
Applicant for him.
230, madam. Yes.
If to appear for the application.
Apply for the
applicant
petition, no?
Pleading. Objections are not filed. If that application
There
is.
is no objection.
Let us make my oral submission.
He has no objection.
No, I'll make my oral submission on this, on the application.
You have objections?
Please, madam.
Yes. ಹೇಳಿ.
My lord,
First let him argue his application.
My objection is also ready, hoping that my friend will concede for coming on.
ಗೊತ್ತಿಲ್ಲ, ನಿಮ್ಮ IML argument ಮಾಡಿ,
Yes.
Mr. Bhatt.
Please, my lords, the petitioner is one of the residents of the area in which the respondent number 3, I refer to as respondent number 3. My lord, taking it that my lords have been pleased to allow my application. Respondent number 3.
You can take whatever, we'll see that.
Because the grounds I will narrate.
Yes.
Respondent number 3. For the
Impleading applicant for now.
Impleading applicant, my lord, is the resident of the area. Along with several others of the residents of the area. Objections were filed before the BBMP, GBA now, and also the excise department. However, the trade license was granted, and after noticing that the building is unauthorized, no sanction plan, no building license, it was made prepared only for the purpose of illegally taking Form CL7 license. I am referring to it, Form CL7 license, which is, my lord, more in use nowadays. Then, my lord, the order granting the license.
Who have been set up by another.
No, I have verified.
license holder.
We will be, my lord, the first verification done by the council is, it will be there. I do concede, and very well I think.
ನೀವು appear ಆಗ್ತಾ ಇದ್ದೀರಾ ಅಂದ್ರೆ it must be some other license.
ಇಲ್ಲ, ಅದು ಅಲ್ವಾನಾಗೆ ಎಲ್ಲ 3 ಜನ ಎಕ್ಸೈಸ್ ನವರೇ ಅಪಿಯರ್ ಆಗಿದ್ದಾರೆ.
Yes.
So now, my lord, my humble submission is.
ನಿಮ್ಮ ಲೈಸೆನ್ಸ್ ಎಲ್ಲಿದೆ ಪ್ರಾಪರ್ಟಿ ತೋರಿಸಿ, ಅದರದ್ದು will check it up.
Please, my lord. Hello, we are with you. I have verified more than once, my lord. I can, if that's, my lord, inference can be drawn.
But everybody is trying to use the court for their business.
I have verified C aspect now. Normally, the third party setting up will be accompanied by one license. It is not so in this case. And I have more.
So you are the complainant?
I am the complainant.
At the most?
At the most, yes. Now, the application for impleading has been filed with documents. My humble submission is those documents are, there is no water supply connection. There is no.
Mr. Pawan Kumar is perfectly capable of
That's what.
before us.
My
You
friend,
give him
he is
all the
per-
documents.
He is very much, only it is an additional hand, my lord, assisting the
Additional
honorable
hand
court.
ಬೇಕಾಗಿಲ್ಲ, ಎಲ್ಲ ಕೊಡಿ ಪವನ್
And,
ಕುಮಾರ್ಗೆ will
my lord, you
place.
kindly see, now his entire petition is depending upon one license granted by the excise. That has been.
We haven't still allowed you to come on record. You only argue your impleading application.
Yes, that's why, my lord, impleading is, I am a proper and necessary
Your
party.
complaint, ashte.
Having been a party before the authority below, my lord, if I am
Party
heard.
before, party ಅಂದ್ರೆ ಏನ್ proceedings ಆಯ್ತಾ?
ಅಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ ಅವರು, ನಮ್ಗೆ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಎಲ್ರಿಗೂ ನೋಟಿಸ್ ಕೊಟ್ಟು ಹಿಯರಿಂಗ್ ಮಾಡಿದ್ದಾರೆ ಅವರು.
Where the proceedings?
That's what. The proceedings, the record will disclose either in the granting of license or in the revocation. I do not come reasoning. Even the license, if it is seen, it is undated. My lords are pleased to see the license.
Mr. But we are
It is
asking you a very simple question.
I may limit my contention, submission to what I can be permitted.
Were you a party to any proceedings? If
Yes.
you are a party, we'll allow your application. If you are not party, you are a mere complainant.
Yes, it is, my lord, final.
If there is a proceeding, give us the proceedings.
Notice issued to me by the health officer. I can make available, my lord, it is there. And notice issued to me, I was thinking of filing my reply in the registry, and after
So
that.
first you are still to enter the
I can only pass
door.
on one notice, my lord may not mistake me, it is not very legible. Notice issued to the parties on 28.
But we are asking you again a simple question. Were you a party in any proceedings, then we'll allow you.
My objection before the authority was considered.
That objection is a complainant. That's different.
Yes, if the learned counsel, my appearance will be only 10 minutes extra supporting the case of the, otherwise I am very confident that the GBA will take care of its case. So.
Out of confidence.
And added to that, only one submission, how things play. But for the CL7 license, my lord, I would not have made, because if the license in form CL7 granted for last 2 years is verified by a very competent person, like one of the former commissioners or anybody, my lord, several things can come out, several things.
That will be the case in almost all.
It is so. And only one submission.
Next time when you appear here, you
anyway,
please give the name of one commissioner, we'll ask them to examine.
My lords have, my lord, indicated that my other side is quite enough to take care. Only as a responsible person, only one submission not connected to this case. As a responsible person and nowadays having experience. The corruption in the rural areas much more, which I came to know after I inherited from my father the estate left behind by him. ಊರಲ್ಲಿ ಹೋದ್ರು ಅವ್ನು ಏನ್ ಮಾಡ್ತಾರೆ ಲೆಕ್ಕಿಲ್ಲ. 85 lakhs, my auditor said you invest on a property. I invested, guidance value 85,000 suppressed. This is the shocking affair in the state of Karnataka now.
You should file a complaint.
My lord said-
See, problem is if complaints, you
Yes, it is
go
done.
through it and
I brought it to the notice of the Registrar General also.
that won't help unless you file a written complaint.
Yes. This is what only, sorry that I have made this.
Please file a complaint.
Every area if we go, and because it is CL7, I know what is CL7. My friend is seeing at least 10 persons visiting the office, complaining about the highest person in the administration.
Yes.
My lord, first instance, the petitioner, the impleading applicant has no locus standi. In fact, the allegation is that
he is a complainant.
No, this name is not found in the notice issued or in the order passed. Notice is at Annexure C.
Annexure C.
Annexure C. There's a show cause notice issued to the petitioner, which has been duly replied. In that it only states that ದೊಡ್ಡ ಬಿದರಕಲ್ಲು ತಿಪ್ಪೇನಹಳ್ಳಿ ಗ್ರಾಮ ಬೃಂದಾವನ ಬಡಾವಣೆ ನಿವಾಸಿಗಳು ನೀಡಿದ ದೂರಿನ ಮೇರೆಗೆ ನೋಟಿಸ್ ನೀಡುತ್ತಿರೋ ಬಗ್ಗೆ.
ಅವರು ನಿವಾಸಿ ತಾನೆ?
ಅಲ್ಲ, we do not know. I mean, his name is not found here. Apart from that, the notice contemplates cancelling of the notice for violation of section 307 and 308 of BBMP Act.
BBMP Act.
This notice has been duly replied as per Annexure D.
307.
Power of the zonal commissioner to stop use of premises used in contravention of licenses. May I read it? If the zonal commissioner is of the opinion that any eating house, lodging house, hotel, boarding house, tea shop, coffee shop, cafe, restaurant, refreshment room or other place where the public are admitted for repose or for consumption of any food or drink or where food is sold or prepared for sale or any theater, circus, cinema house, dancing hall or similar other place of public resort, recreation or amusement is kept open without a license or otherwise than in conformity with the terms of a license granted in respect thereof, he may stop the use of any such premises for any such purpose for a specified period by such means as he may consider necessary. Now, there is no specific allegation as to what is the violation of the license that has been committed by the petitioner herein, my lord. And apart from this, my lord, I request your lordship to kindly refer to Annexure B, my lord.
You have a license, trade license?
Please, my lord.
Where is the trade license?
Trade license is at Annexure A, my lord.
This license is for what purpose?
For running a boarding and lodging along with the bar and restaurant, my lord.
Undated.
Dated 31/3, it's dated 16/5/25, my lord. Trade license valid up to 31/3/26 and receipt fees of rupees so and so.
Yes.
White receipt dated 16/5/26. Thereafter, a similar representation was given to the excise authorities also by the public of the said locality. The same has been duly considered and an endorsement has been issued as per Annexure B at page 12, my lord. And it's found that the place where the business is to be carried on is in conformity with Rule 5 of the General Condition Rules, my lord. There's no violation of Rule 5, my lord. And this endorsement has been issued on 11/12/2025, which has not been challenged. And suppressing this endorsement, they again approach the respondent authorities on the very same allegations. And this honorable court also in similar matters has held that it's for the excise authorities to consider whether there's any violation of Rule 5 or not. And only if there's any violation of Rule 5 or contravention of Rule 5, then in such places license cannot be granted, my lord. Now the respondent corporation, lord, they cannot transgress into the authority vested under the conferred under the provisions of Excise Act and issue the impugned notice, my lord. Yes.
Take instruction. Copies not available.
It's been served, my lord.
And only for one interruption is that, my lord.
It was listed 2-3 days back on the request of petitioner's counsel.
27/1. How come it's been listed?
But since they filed the application on the very same day, it was not that application was not listed.
Last date application was not filed.
For purpose of impleading application. Yes, yes, Mr. Bhatt.
Excise license, my lord, my friend himself has produced. It is notice is issued for withdrawal of license, Annexure G.
Based on the Annexure.
Page number 33. 30 days. Under section 30 of the Karnataka Excise, the deputy commissioner.
ದೂರು ಬಂದು ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಹಾಗೂ ಅಬಕಾರಿ ಇಲಾಖೆಯಿಂದ ಇನ್ನೂ ಪರವಾನಿಗೆ ಮಂಜೂರಾಗಿರೆ ಇರೋದರಿಂದ.
But the license is granted on the same day, on 31/12.
Parvanagi means the transport permit and other things they are referring to. Now it's a notice of withdrawal of the license.
No, man.
Let him participate there. 30 days time is given to him.
What has been withdrawn? Is it
The license of CL7.
No, it's a notice, my lord. As to why the notice or why the license issued on CL7
He has not
should
filed
not
any-
be withdrawn in view of the impugned order passed by the respondent
So, my
corporation.
lord,
my
my
lord.
humble submission, it may be heard, my lord, after the learned come. Even if records are necessary,
We
building
get
plan
that.
is not there.
Please, that's it. That's not the notice which has been issued, Mr. Bhatt. You are making all kinds of submission without it being on record.
It is a notice of
This
withdrawal.
is a notice which has been issued saying that the no license under the excise license has been taken. Without that, you are operating it and ಹೇಳ್ತಾ ಇದ್ದಾರೆ. That's all.
Last paragraph,
Nodi.
as to why it should not be withdrawn.
The trade license should not be withdrawn
No,
because there is
my
no
submission,
license.
Excise license. It's not
How
referred
can
to.
the BBMP withdraw the excise license?
BBMP, it is deputy commissioner of the district. Licensing authority.
My lord, my learned friend is referring to Annexure H, my lord. Where the show cause notice is issued to the
Annexure
petition.
You just refer to Annexure G.
No, Annexure H, man. I'm sorry that I am interrupted.
Annexure G ಅಲ್ಲಿ ಏನ್ ಕೇಳ್ತಾ ಅದರಿಂದ
Annexure G is the order passed by the respondent corporation which is impugned herein. No? Annexure H, based on Annexure G, Now the excise department has also issued a show cause notice as to why this license should not be cancelled because the trade license is cancelled.
That is not subject matter of our
Please,
challenge.
No, not subject. It's subject
We
matter
are
of Deputy
concerned only
Commissioner.
with Annexure
Annexure G,
G.
my lord.
Annexure, so if Annexure H has been issued,
Yes,
the
Annexure H is
excise-
questioned in this writ petition.
the excise authorities will take action on
Yes,
that.
that's what my submission.
Annexure G, GBA cannot take action.
GBA cannot.
But why is this been issued by you?
No, when it is there, entire.
Rest of the complaints and follow-up.
Give him a copy, he doesn't even have a copy.
But the copy has been furnished and furnished again. my lord. Well, now that the annexure G is passed,
It's been furnished to your GBA special cell.
please, my lord.
Give him one more copy.
I'll share it.
Counsel for the petitioner undertakes to furnish one more set of the petition along with annexures on Sri Pawan Kumar, learned counsel for
Furnish,
respondent number 1. As today furnished one more set. Counsel for respondent number 1 seeks for and is granted a week's time to obtain instruction, make his submission.
My lord, till then, let them not precipitate.
Expression of annexure G, which has been issued by the GBA in respect of a excise license, is stayed till the next date of hearing.
Much of them.
It's however made clear that proceedings under annexure H shall continue.
Yes, my lords, not concerning annexure G is withdrawal of the trade license. Trade, yes,
Please read
yes,
it.
I have read it. G.
Please read it. Trade license on the account of
Yes,
excise license not issued.
Not issued.
yes,
There's excise license issued.
issued.
Annexure H is for cancellation of the excise license.
Please, it can be independent.
That means that there's an excise license issued. That is your own submission.
Independently dealt with. My
Annexure G,
applications,
they have no authority.
please,
They can't get into excise department shoes.
if my application is allowed and I may have,
You find out and do that. You can't get into excise department shoes.
my application may not be rejected or it's,
Date 10th February.
it is kept open, my lord, my impleading.
Your application is kept open still. Whatever documents you want, give it to Mr. Pawan Kumar.
If my objection was ready, I would have filed it in the registry if it is allowed.
For all complainants, if we allow, then it will be a problem. Next.
Please.
Orders, serial number 12, P. N. Nanjareddy.
Filed application.
Okay, for the fourth respondent, my lords.
Application blood not to,
My lords, last occasion I made a
not to put up
submission, my
further
lord.
construction and also blood.
I'm appearing for the BBMP. Respondent number 1 to 3. I have one submission. I'm appearing for BBMP, respondent number 1 to 3. The only thing is, the allegation made by the petitioner is that the respondent number 4 is putting up an illegal construction, for which there's already been a complaint filed before the commissioner. That notice has been issued to the respondent number 4 to come forward and furnish documents, which has not yet happened as on date. If they cooperate, the commissioner can pass a detailed order and then pursuant to which my lords could deal with the matter.
Who has to give what?
My lords,
Who has to give what to you?
they have to provide documents to the commissioner for him to inspect or conduct a survey.
What documents?
For the, to verify whether there is any building irregularity.
ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ just
Why do you need them to give it to you?
My lords, because there is a notice that has been issued. If my lords could take their own document, they have filed an application on 21/2026. Along with that annexure P, page 5.
Page 5, yes.
This is the notice that we have issued, my lords, asking them to come forward to furnish documents. Because we are not aware whether as of now, there is already a plan sanction issued in favor of respondent number 4.
You're
To
not
construct.
aware whether there's a plan sanction issue.
No. We are aware that, I mean,
So is the construction as per the plan sanction?
to verify that, we need to conduct a survey.
Yes,
And
Keshav,
for the
but
parties to cooperate.
them. You are supposed to be the custodian of all these documents.
My lords, they have not given us any documents with respect to the ownership of the land or anything of that sort. So which is why we are finding it difficult. These are my instructions.
how can license can be granted? That is so.
You have issued a plan sanction to respond number 4.
Please, my lords.
The allegation is that they are constructing it in violation of the plan sanction.
Plan sanction.
And also.
What more do you need from them? You have to go there, find out if the plan, you have the plan sanction with you? If the
We have the
construction is
plan
as per the plan sanction or not?
My lords, for us to do that, we need some time, my lords, to.
Time will give you,
Please,
but
that-
what documents shall the Can the petitioner?
If they were, if they would cooperate, if
Lord, you
if my
lost
lords
my
would
kindly
fix a date
endorsement
for them
issue.
to,
We'll fix a date, you
Please.
carry out the inspection.
Please.
Tell you what to carry out also. If
Yes,
your
ma'am.
officers don't know.
Please.
There is a run of the mill regular, this one, there are, every day there are around 30 petitions before this court on illegal construction or violations.
Please.
If your officers still don't know how to do it, then it's a problem.
If that report can be placed
At
before my
page 5,
lords,
last-
then
Ask Pawan, he'll tell you what are all the things to be done.
please, ma'am.
Don't go by these instructions which they are trying to mislead you.
Please.
Don't. They want the petitioner to give the details of the plan sanction, violation for BBMP to carry inspection.
That is a part of the record, my lords, as annexure.
Annexure P, mirror
Last
page
occasion, I
5.
had made a undertaking, my lords.
Ayyadalli.
There is a no.
Yes, Mr. Ajit?
Last occasion, my lords, I had made a submission, my lords, that there is a no further putting up any construction. I had to give an undertaking, my lords. After
You're not
that, my
putting
lord-
up any construction.
No, my lords, it has been
What
stopped.
about the construction which has already been put up? Is it in accordance with the plan sanction?
It's there, my lords, there is a small variation of deviation is there, which is a less than 5% what the instructions are.
Less than 5%, it can be compounded.
And also, Millard, they have put up Millard, the construction in my property. That is the main ground that on which Millard I have challenged.
In your property, there is setback violation.
Setback. ಅಲ್ಲ ಅವರು
Setback violation.
ಅಲ್ಲ ಸೇಲ್ ಡೀಡ್ ಪ್ರಕಾರನೇ ಇವು ಲಾಸ್ಟ್ ಮೈ ಕೈಡ್ಸ್ ದೇರ್ ಓನ್ ಸೇಲ್ ಡೀಡ್ ಪ್ರಕಾರ 18/1 ಸರ್ವೆ ನಂಬರ್ ಅಂತ ಇದೆ 17/1 ನಲ್ಲಿ ಕಟ್ತಾ ಇದ್ದಾರೆ ಯು ಲಾಸ್ಟ್ ಮೈ ಕೈಂಡ್ಲಿ ಸಿ ಪೇಜ್ annexure F Millard page 25.
The allegation made by the petitioner is that not only respondent number 4 is putting up construction in violation of the plan sanction, but also in the property of the petitioner.
Yes.
That would clearly, if that be so, it would clearly indicate that the setback would be violated. In that view of the matter, respondent number 2 with the, along with the jurisdictional assistant executive engineer is directed to carry out the inspection of the property of respondent number 4 bearing number
Survey number Millard
18/1.
18/1 survey number.
Illi, where are the details?
Millard at page
18/1
measuring 5,500 square.
of ಯಾವ village ಇದು? Property details ಅಲ್ಲಿ Mr. Anjali.
Millard annexure F ಅಲ್ಲಿದೆ.
Page 34, my lords, is a schedule of.
Page
the-
34 ವಿಜಯಪುರ
Vijinapura village, Mahadevpura Obli, Bangalore East, to ascertain so and so. This order is
ಅಲ್ಲ ಅದ್ರ
passed.
ಜೊತೆಗೆ annexure P along with my application I filed. They have already issued notice in the on 11/6/2025 they are taking action. I think they have filed objections also for section under section
248 ಆಗಿದೆಯಾ?
ಹೌದು
248 proceedings.
Has been issued?
ಅವ್ರು ಹೇಳಿದ್ದಾರೆ but again
Annexure
there's
P, I took my lords to that.
page annexure P page 5 annex
248 1 and 2.
ಹಾಗೂ
They'll
ಕಚೇರಿ
have to cooperate with the investigation that, of the,
ತೆರವುಗೊಳಿಸಲು BBMP ಕಾಯ್ದೆ ನೋಟಿಸ್ ನೀಡ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. They have stated also. Further action they have not taken.
What is the site measurement, Ajit?
5,500.
5,500.
5,500.
Measurement in 5,500.
My lords, 50
five
feet.
width.
My lords, 50 into 110, my lords. North to south is, east to west is 50 feet, north to south is 110 feet.
Millard survey also conducted by the Millard survey department.
5 floors,
It's 4 floors.
6th floor under construction.
Correct.
As per annexure Q2. 1, 2, 3, 4, 5, 6 floors. Including ground plus 5.
no, 4 floors. ma'am.
4 floors. my lords.
If my lords would take Q2 itself, this is ground floor, 1, 2, 3, 4, G plus
Which is
4.
ground?
This one,
Below, above that is
1, 2, 3, 4, 4.
ground
G
plus 4. That is on Q2. See Q3 now. One more floor is built on top of that.
Six floors.
Can't be built on a 50
This-
by 90 plot.
I'll verify, Manoj. I'll ask them to.
Your assistant engineer is misleading you and trying to mislead us. He'll be in trouble. He doesn't require any assistance from anybody. He has to do his job.
Yes, ma'am. I am.
If he doesn't know how to do his job, we'll have to ask somebody else to do it. And if he's allowing this kind of construction to happen and supporting it by this way, then there's collusion. If he had done his job on the right time, then see, we don't like to demolish. Lot of
That I
demolition.
understand, but
This demolition cost will come from his salary.
I'll seek instructions.
We have already ordered in another matter that it comes from that person's salary. Your matter will be another one.
I'll seek instructions.
Carry out inspection of so and so. And make a submission of so. Since the order is passed in the presence of counsel for the petitioner, counsel for respond number 4 and respond number 1 to 3, the inspection to be carried out commencing from 10:30 AM on 3rd February. Report to be submitted by 9th February, released on 12th February. God bless.
Grateful.
Keshav is appearing for the first, very recently in BBMP matters. Guide him.
Yes, ma'am.
These kind of matters.
In
just
this,
guide
yes,
him
ma'am.
as to what it is. How BBMP officers can, he knows better.
Serial number 13, TP Rajendra Kumar Singh.
Wait for petitioner, my lord. Petitioner, my lord, having supplied water, my lord, for the Chikbalapura town during COVID period, has not been paid the amount.
Have
my
not
lord.
been paid.
Yes, my lord. It's an admitted fact that
Representation, consider the representation.
This is the amount covered under tender, that which cannot be claimed through writ petition.
So refuse that, pass an order of rejecting, then he can do, he can go for a
We'll
proceeding.
consider his
If representation consider Madlila, he doesn't know what to do.
please.
my submission is this, my lord. It is an admitted fact that, my lord, they owe the money. I produced all those documents, my lord.
We cannot decide that in a writ petition, Mr. O'Leary. We cannot decide how much money is due, what is the difference.
No, how much money? They themselves admit here. They admit we are due so and so, we'll pay in installment and they ಹೇಳಿದ್ರು ಕೊಟ್ಟಿಲ್ಲ.
Where is that?
Yes, my lord. That's what, my lord, I am making. Letter, communication, by which, my lord, next page, my lord, is a statement is there. My lord, there are 3 packages we have supplied. Then below, my lord, ಈ ಮೇಲೆ ವಿವರಿಸಿದಂತೆ ಪ್ಯಾಕೇಜ್ 1ರ ಮೊತ್ತ 35,85,000, ಪ್ಯಾಕೇಜ್ 2ರ ಮೊತ್ತ 25,77,000, ಪ್ಯಾಕೇಜ್ 4ರ ಮೊತ್ತ 32, ಒಟ್ಟು ಬಿಲ್ಲು ಮೊತ್ತ 93,77,000 ಬಿಡುಗಡೆ ಮಾಡಲು ಜಿಲ್ಲಾಧಿಕಾರಿಗಳಿಗೆ ದಿನಾಂಕ 12/22 ಪ್ರಸ್ತಾವನೆ ಸಲ್ಲಿಸಲಾಗಿದೆ. ಈ ಮೇರೆಗೆ ಒಟ್ಟು 93,77,544 ರೂಗಳಲ್ಲಿ ಈಗಾಗಲೇ ಸಿಆರ್ಪಿ ನಿಧಿಯಿಂದ 46,57,000 ಮೊತ್ತವನ್ನು ಪಾವತಿಸಲಾಗಿದ್ದು, ಉಳಿದಂತೆ 47,20,000 ಅನುದಾನ ಬಿಡುಗಡೆ ಮಾಡಲು ಬಾಕಿ ಉಳಿದಿರುತ್ತದೆ. ದಿನಾಂಕ 11/10/22 ನಡೆದ ಸಾಮಾನ್ಯ ಸಭೆಯಲ್ಲಿ ಬಾಕಿ ಇರುವ ಮೊತ್ತವನ್ನು ನಗರಸಭೆ ಆರ್ಥಿಕ ಪರಿಸ್ಥಿತಿ ಅನುಗುಣವಾಗಿ ಪಾವತಿಸಲು ತೀರ್ಮಾನಿಸಿರುವುದಾಗಿ ವರದಿಯಲ್ಲಿ ತಿಳಿಸಿರುತ್ತಾರೆ. ಆದ್ದರಿಂದ ಪ್ರಕರಣದ ಬಗ್ಗೆ ತನಿಖಾ ವರದಿ ರೀತಿಯ ಬಾಕಿ ಮೊತ್ತವನ್ನು ಗುತ್ತಿಗೆದಾರರಿಗೆ ಪಾವತಿ ಮಾಡಿಸುವ ಕುರಿತಂತೆ ಸರ್ಕಾರ ಸುತ್ತೋಲೆ ಆದೇಶಗಳನ್ನು ಪರಿಶೀಲಿಸಿ ನಿಯಮಿಸಲು ಕ್ರಮವಹಿಸಲು. Then, my lord, there is another document, Annexure D also.
You have already admitted them.
Though it is an admitted fact, my lord.
After admission, then why delaying it? Then we can issue a mandamus.
But the
not admitted amount, we would not.
tender was called for the funds which were under NDRF and SDRF. No, my lord, those funds are not available. No, my lord, we have requested the district administration to grant the funds. But as and when, my lord, the funds are available, we will release them.
When will the funds be available?
But we had
You
made
got
request,
the work done
we had made request to the district administration.
So you got the work done without money being with you.
ಅಲ್ಲ, ವಾಟರ್ ಸಪ್ಲೈ ಮಾಡಿರೋದು ಕೋವಿಡ್ ಪೀರಿಯಡ್ ಅಲ್ಲಿ ಪಾಪ ಜನಗಳು ಬದುಕಿದ್ದಾರೆ.
Can't be doing that way. ಕೆಲಸ ಮಾಡಿಸ್ಕೊಂಡು ದುಡ್ಡು ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ?
The tender was called under the funds of SDRF and
When are you
NDRF.
going to pay this money?
I need to get instructions to that effect.
Next annexure also, my lord, they have
Of
admitted.
the specific admission made by the respondents in the letter dated 25/2/2025
And next
that
one
there is
is
a balance amount of rupees 47,20,198. It would be required for the respondents to make payment of said monies.
even in next annexure also there is an admission.
Similar admission.
Annexure D,
has
yes,
also
my lord,
been
same
made.
amount, 47 lakh. 20.
Annexure D dated 37/2022.
Yes.
Learned counsel for respondents, respondent number
Four,
4
my lord.
submits that since funds were not available, the payments could not be made. He seeks fund is granted 10 days time to obtain
4 weeks
instruction and
time.
make a
Blood, we need to,
days time to obtain
blood,
instruction
even
and make a
blood, we have
submission
requested the
as
district
to by
administration.
when the payments could be made. 10 days ಅಲ್ಲಿ ನೀವು ಹೇಳಿ ಯಾವಾಗ, we'll give you that much time. But that time should be reasonable.
Please.
Should not say 6 months ಅಂತೆಲ್ಲ ಹೇಳಂಗಿಲ್ಲ.
He's a senior citizen, 81 years old.
Released on 11th February.
That is.
Number 14.
For the petitioner. On the last occasion, a liberty was given. Find the ground and as well as the prayer. I made an application, maybe order to be allowed.
Documents stated in the affidavit.
Annexure stated in the affidavit is not forthcoming. There's an office objection.
The regulation is not made as an annexure, my lords.
Then why have you mentioned it as annexure?
But that may be overruled. The copy was given by the other side. Based on that, I made an application.
You have to comply with this office objection before we deal with it. Counsel for the petitioner seeks fund is granted a week's time to comply with the office objection raised on IA 1 of 26, relist on 11th February.
Great.
List number 1 for dismissal, serial number 1, Abhinavar.
Lord, my apologies. Last time somehow the matter was not noticed, my lord.
Not once, several times ಇಲ್ಲ ಅಂದ್ಮೇಲೆ ಇದು ಬರುತ್ತೆ.
ಅಲ್ಲ ನಮ್ಮ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ನಾವು ನೋಟಿಸ್ ಮಾಡಿದ್ದಿಲ್ಲ. My apologies.
Yes. Who is for the rest? Mr. Mohan Kumar. Paso.
Serial number
Everybody
2.
Mohan Kumar Barak.
Great.
Serial number 2, adjourned. Serial number 3, NS Bhatt.
Despite the order dated 6/1/2026, none appears for the petitioner today also. It appears that the petitioner is not interested in prosecuting matter. Petition is dismissed for non-prosecution. Shri Mallikarjun Reddy KS has entered appearance for respondent number 1 and 2. Delete the name of Shri Manjunath Rayappa as that appearing for respondent number 1 and 2.
Serial number 4.
(2019) matter. Despite the order dated 14/1/26, dismissed.
Serial number 5, HC Sundresh.
Despite the order dated so and so, dismissed.
Serial number 6, adjourned. Serial number 7, AN Gangadharaya.
Appearing for the petitioner, filing memo for withdrawal.
Memo for withdrawal. Petitioner is before this court. Memo for withdrawal dismissed as withdrawn.
Great.
Final hearing, serial number 8. AV Gangadharappa.
ಏನು ಬರ್ತಾ ಇದಾರೆ ಪಾಸು
Serial number 9, CM Nagabhushana.
My lordship, in this R6, the BG Somyaji's, it is sub-register Ramnagar, that government will take, my lordship. It is not a panchayat.
MG Ravisha ಅಂತಾನು ಇದೆ
Ravisha, but sub-register usually government.
ಅಲ್ಲ MG Ravisha ಅಂತ ಏನಕ್ಕೆ Six is Panchayat Development Officer. 5 is Sub-Registrar.
Ravisha.
Yeah, BJ, MG Ravisha, Mr. Devraj.
5 Wakalat.
ಇವಾಗ ರೀಸೆಂಟ್ ಆಗಿ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ.
26/9/2025.
Shri NG Ravisha has filed wakalatnama for respondent number 6, delete the name of Shri BJ Somyaji as that appearing for respondent number 6. None appears for the petitioner. If none were to appear for the petitioner on the next date of hearing, petitioner will be liable to dismiss for non-prosecution. Released on 10th February under the caption dismissal for non-prosecution.
Moot Matters, serial number 10. Diane and this party.
Appearing for the petitioner, kindly pass on.
Pass over.
On submission, respondent counsel adjournment ಬೆಳಿಗ್ಗೆ ತಗೊಂಡ್ಬಂದು ನೋ ಅಬ್ಜೆಕ್ಷನ್ ಹೇಳಿದ್ರು. ಅದಕ್ಕೆ ಕೇಳಿದಕ್ಕೆ ಬೆಳಿಗ್ಗೆ
ನಿಮ್
ಪರ್ಸನಲ್ ಇನ್ಕೂರೆನ್ಸ್ ಇದೆ ಅಂತ ಮಧ್ಯಾಹ್ನ ಮೇಲೆ ಸೀನಿಯರ್ಗು ಅದಕ್ಕೋಸ್ಕರ ಎನಿ ಡೇಟ್ ಮೇ ಬಿ ಫಿಕ್ಸ್ ಮಾಡಿ.
ಯಾರು ಕೇಳಿದ್ದು ಅಡ್ಜರ್ನ್ಮೆಂಟ್?
ನಾವೇ ಕೇಳಿದ್ವಿ ಸರ್.
ಅವ್ರು ಅಪೋಸ್ ಮಾಡಿದ್ರ?
ಗೌರ್ಮೆಂಟ್ ಅಂದ್ರೆ ಕಂಟೆಸ್ಟಿಂಗ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅವ್ರು ನೋ ಅಬ್ಜೆಕ್ಷನ್ ಹೇಳಿದ್ರು.
ಗೌರ್ಮೆಂಟ್ ಅಪೋಸ್ ಮಾಡಿದ್ರು.
My lords, this is a case in which it's a town club, my lords, where the land has been leased in their favor by the municipality.
Any short date, without fail next week.
17 matter.
Senior counsel argument. ಅದೇ ಪರ್ಸನಲ್ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಇದೆ ಅನ್ಸುತ್ತೆ. ಅದಕ್ಕೋಸ್ಕರ ಎನಿ ಡೇಟ್ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ ವಿತೌಟ್ ಫೇಲ್ಡ್ ಆಗಲ್ಲ.
My lords, they have an interim order at least that may. The stay of
interim order ಏನಿಲ್ಲ ಇಲ್ಲಿ.
DC's order has been.
There is no interim order.
Interim order ಏನಿರಲ್ಲ.
It has not been extended at all, if at all it is there. Unless it's been granted till further orders.
My lords, on 28/6/2017.
28?
28/6/2017. The operation of Annexure A shall remain stayed during the pendency of the writ petition.
And the
Next
further
week any
orders.
date, my lord, without failed I will argue. I will inform senior counsel.
You just glanced ಮಾಡಿದಾಗ 4 times it been adjourned.
Please.
Saying that it will be dismissed if arguments are not advanced.
Sorry, my lord.
Preemptory orders have been passed 4 times. You've been successful in getting adjournment on those occasions also.
Next time without failed.
At the request of, though no adjournment is required to be granted, at the request of counsel for the petitioner released on 2nd February, if arguments are not advanced on that date, petition will be liable to be dismissed for non-prosecution considering that the matter is of the year 2017 and peremptory orders have been passed several times earlier.
Please, oblige.
Great. Serial number 11. Mamata Rai.
What kindly pass on, my lord. Since the thing is in other court, kindly pass on, my lord.
Where is the petitioner? ಬರ್ತಾ ಇದಾರೆ?
Last time also they did.
Last time also not there.
They are taking time.
None appears for the petitioner. If none were to appear for the petitioner on the next date, dismissal released on 10th under the caption dismissal for non-prosecution.
Serial number 12. Naveen Jayan.
For the petitioner in this case.
Yes.
And for the respondent number 6.
6. Narayan Reddy, M. Narayan Reddy for R1 to R5.
Subsequently, Mr. Somyaji filed a wakalat.
ಅಲ್ಲ ಅವರು ವಕಾಲತ್ ನಾಟ್ ಫೈಲ್ಡ್ ಅಂತಿದೆ. ನೀವೇ ಯಾರಿಗೆ?
ಇಲ್ಲ, he is my colleague.
ಎಂ ನಾರಾಯಣ್ ರೆಡ್ಡಿ ಯಾರಪ್ಪ? ಅವ್ರು ಬರಲ್ವಾ? MS Devraj is directed to accept notice for respondent number 1 to 5. Since the earlier counsel, Shri BJ Somyaji is expired. Registry is direct print the name of Shri MS Devraj as that appearing for respondent number 1 to 5. Delete the name of Shri M. Narayan Reddy as that appearing for respondent number 1 to 5. As also the name of Shri B.J. Somyaji is that appearing for respondent number 1 to 5. Give him a call. Counsel for the petitioner undertakes to furnish 2 sets of the petition along with annexures on Shri M.S. Devraj by end of day 3rd February 2026. Shri M.S. Devraj is granted 2 weeks time thereafter to obtain instruction, make a submission, released on 19th February.
Interim order.
Interim order earlier granted is extended.
Copy is furnished. Statement of objection.
ನೀವು ಕೊಟ್ಬಿಡಿ
ಅವ್ರು ಕೊಟ್ಟಿದ್ದೀವಿ ಇವ್ರು.
ನಿಮ್ದು ಕೊಟ್ಬಿಡಿ ಅವ್ರು ಕೊಟ್ಟು
ಪ್ಲೀಸ್ ಪ್ಲೀಸ್
ಕೇಳಿ ಅವ್ರು ಬರಂಗಿದ್ರೆ ಬರ್ಲಿ, ಇಲ್ಲ ನೀವು
ಬಂದಿರಲಿಲ್ಲ.
13. Mohammed Muzassir.
Date 3rd February.
19th February. Serial number 13.
Yes, madam.
My lord's requesting to have it next week. Senior is not here. We have filed the statement of objections already. Readings is complete.
None appears for the petitioner. Favor of the order sheet indicates that none has been appearing for the petitioner on several earlier occasions. Counsel for respondent number 1 and 2 seeks for and is granted 2 weeks time to file a statement of objection.
My lords, we have filed the.
You filed. Then why did you want time?
For arguments, my lord, senior is not here.
If none were to appear for the petitioner on the next date of hearing, interim order earlier granted has also lapsed. If none were to appear for the petitioner on the next date of hearing, dismissal released on 11th February under the caption.
Serial number 14 adjourned. Serial number 15.
In this, they have challenged the circular, my lordship, the government circular.
Circular speech.
Which I have
Circular in
to
the
file
sense
my
that we
objection.
have purchased the property in 2005. This layout was approved on 31/8/2004, but some restrictions.
Not applicable to schedule. They have not challenged this, sir. Only applicability.
Applicability test, because that has come in the year 2005. I have 30, that was 26/5/2005. Those circulars were coming to.
You are ready.
Please, madam.
Applicability is not.
Applicability.
Ready na everyone?
I am formal party, Gram.
Formal.
Planning authority is
The contesting party.
planning authority.
Planning authority.
Planning authority.
Yelmangala planning authority.
Yelmangala planning authority.
Who appears for planning authority?
He himself.
Respond number 2.
He
Mr.
appeared.
Gurumurthy, you appear.
Please.
Ready? Hear it.
Please. But this layout, my lord, at annexure D, my lord, layout plan is there. Page 48.
Page 48.
Please, my lord, the layout plan is there. That is annexure E, my lord. ಅನುಮೋದನೆ ಪತ್ರ ಮತ್ತೆ ಬಾಟಮ್ ಅಲ್ಲಿ in the this signature approved on 31/8/2004. My date is very relevant.
One ನಿಮಿಷ. (31/8/2004).
Please, ma'am. That is the date on which it was approved.
Yelmangala Planning Authority.
Please, ma'am. Yelmangala Planning Authority. And at the time of approval, these were the conditions at page number 45 and 46. There is no need to read this because the restriction on sale.
Just one minute, just one. This page number? Where are the conditions?
Page number 45 and 46.
Yes.
There was no restriction on the sale of there was no restriction on the sale of sites in this condition. Some conditions were imposed by the government saying that 30%, 40%.
Release order,
Release order will have to be there.
Yes.
My lord, those circular, my lord, I have produced, my lord, at annexure J series. J1 to J5. Please, my lord, annexure J page 73 will be relevant. Because that is the one under which 30% restriction has come into force.
Yes.
I will type it copy your last my kind. Page number
73.
73, my lord. Yes. I will read entire, my lord. This is very relevant.
Yes.
ಸರ್ಕಾರದ ಉಲ್ಲೇಖಿತ 1ರಿಂದ 4 ಸುತ್ತೋಲೆಗಳಲ್ಲಿ ಖಾಸಗಿ ವಿನ್ಯಾಸಗಳನ್ನು ಯೋಜನೆ ಅಭಿವೃದ್ಧಿಪಡಿಸುವಿಕೆ ಮತ್ತು ಅನುಮೋದಿತ ವಿನ್ಯಾಸಗಳನ್ನು ಬಿಡುಗಡೆ ಮಾಡುವ ಕುರಿತು ವಿಧಾನವನ್ನು ವಿವರಿಸಲಾಗಿದೆ. ಸರ್ಕಾರದ ಉಲ್ಲೇಖ 5ರ ಅಧಿಸೂಚನೆಯನ್ನು ಹೊರಡಿಸಿ ರಾಜ್ಯದಲ್ಲಿ ನಿವೇಶನಗಳನ್ನು ನೋಂದಾವಣೆ ಮಾಡಲು ಅನುಸರಿಸಬೇಕಾದ ಕ್ರಮ ಮತ್ತು ನೋಂದಾವಣೆ ಸಮಯದಲ್ಲಿ ನೋಂದಾವಣಾಧಿಕಾರಿಗಳು ಪಡೆಯಬೇಕಾದ ದಾಖಲೆಗಳ ಕುರಿತು ಸಹ ನಿರ್ದೇಶನ ನೀಡಲಾಗಿದೆ. ಇದೇ ಸುತ್ತೋಲೆಯಲ್ಲಿ ವಿನ್ಯಾಸ ಅನುಮೋದನೆಯಾದ ನಂತರ ನಿವೇಶನ ಬಿಡುಗಡೆ ಕುರಿತು ಸಹ ನಿರ್ದೇಶನ ನೀಡಲಾಗಿದೆ. ಇದೇ ಸುತ್ತೋಲೆಯಲ್ಲಿ ವಿನ್ಯಾಸ
ಸುತ್ತೋಲೆ ಡೇಟ್ ಏನದು?
26/5/2005.
ಅಲ್ಲ, ಇದೇ ಸುತ್ತೋಲೆಯಲ್ಲಿ ಇದೇ ಸುತ್ತೋಲೆ
ಇದೆ.
ಎಸ್, ಇದೇ ಸುತ್ತೋಲೆ
ವಿನ್ಯಾಸ ಅನುಮೋದನೆ ಜಾರಿಯಾದ ನಂತರ ನಿವೇಶನಗಳನ್ನು ಬಿಡುಗಡೆ ಕುರಿತು ಸ್ಥಳೀಯ ಯೋಜನಾ ಪ್ರಾಧಿಕಾರಗಳಿಂದ ದಾಖಲೆಗಳನ್ನು ಪಡೆದು ನಿವೇಶನಗಳನ್ನು ನೋಂದಾಯಿಸುವ ಬಗ್ಗೆ ಸೂಚನೆ ನೀಡಲಾಗಿದೆ. ಸರ್ಕಾರದ ಉಲ್ಲೇಖ 1ರಿಂದ 4 ಸುತ್ತೋಲೆಗಳ ನಿರ್ದೇಶನಗಳನ್ನು ಪುನರುಚ್ಚರಿಸುತ್ತಾ ನಿವೇಶನಗಳನ್ನು ಬಿಡುಗಡೆಗೊಳಿಸುವ ಪ್ರಯುಕ್ತ ಈ ಕೆಳಗಿನ ಮಾರ್ಗಸೂಚಿಯನ್ನು ಅನುಸರಿಸಲು ನಗರಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರಗಳು, ಯೋಜನಾ ಪ್ರಾಧಿಕಾರಗಳು ಮತ್ತು ರಾಜ್ಯದಲ್ಲಿನ ಎಲ್ಲಾ ಸ್ಥಳೀಯ ಸಂಸ್ಥೆಗಳಿಗೆ ನಿರ್ದೇಶನ ನೀಡಲಾಗಿದೆ. ವಿನ್ಯಾಸಗಳನ್ನು ಬಿಡುಗಡೆ ಮಾಡುವಾಗ ವಿನ್ಯಾಸಕದ ಬೇರೆ ಬೇರೆ ಭಾಗಗಳಲ್ಲಿ ಜರುಗಿಸಿದಂತೆ 60% ನಿವೇಶನಗಳನ್ನು ಬಿಡುಗಡೆ ಮಾಡತಕ್ಕದ್ದು. ಈ ರೀತಿ ಬಿಡುಗಡೆ ಮಾಡುವಾಗ ಅರ್ಜಿದಾರರಿಂದ ವಿನ್ಯಾಸವನ್ನು 2 ವರ್ಷದೊಳಗಾಗಿ ಅಥವಾ ನಗರಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರಗಳು, ನಗರ ಯೋಜನಾ ಪ್ರಾಧಿಕಾರಗಳು, ಸ್ಥಳೀಯ ಸಂಸ್ಥೆ ನಿಗದಿಪಡಿಸಿರುವ ಯೋಜನೆ ಅವಧಿಯೊಳಗಾಗಿ 5 ವರ್ಷಕ್ಕೆ ಮೀರದಿರುವುದು ಅಭಿವೃದ್ಧಿ ಮಾಡತಕ್ಕದ್ದು. ಉಳಿದ 40% ನಿವೇಶನಗಳನ್ನು ವಿನ್ಯಾಸ ಸಂಪೂರ್ಣವಾಗಿ ಅಭಿವೃದ್ಧಿಗೊಂಡ ನಂತರ ಬಿಡುಗಡೆ ಮಾಡಬಹುದು. ಈ ನಿಗದಿತ ಅವಧಿಯೊಳಗೆ ವಿನ್ಯಾಸ ಅಭಿವೃದ್ಧಿ ಕಾಮಗಾರಿಗಳನ್ನು ವಿನ್ಯಾಸದ ಮಾಲೀಕರು ಪೂರ್ಣಗೊಳಿಸದೇ ಇದ್ದಲ್ಲಿ ಉಳಿದ ಅಭಿವೃದ್ಧಿ ಕಾರ್ಯಗಳನ್ನು ನಗರಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರ, ಯೋಜನಾ ಪ್ರಾಧಿಕಾರ, ಸ್ಥಳೀಯ ಸಂಸ್ಥೆಯೇ ಕೈಗೊಳ್ಳತಕ್ಕದ್ದು. ಇದಕ್ಕೆ ತಗುಲುವ ವೆಚ್ಚವನ್ನು ಉಳಿದ 40% ನಿವೇಶನಗಳನ್ನು ಮಾಡಿ ಬಂದ ಹಣದಿಂದ ಭರಿಸತಕ್ಕದ್ದು. ಇದಕ್ಕೆ ಅನುವಾಗಲು ವಿನ್ಯಾಸದ ಮಾಲೀಕರು ಮೇಲಿನ ಷರತ್ತನ್ನು ಅನುಸರಿಸದೇ ಇದ್ದಲ್ಲಿ ಉಳಿದ 40% ನಿವೇಶನಗಳನ್ನು ನಗರಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರ, ಯೋಜನಾ ಪ್ರಾಧಿಕಾರ, ಸ್ಥಳೀಯ ಸಂಸ್ಥೆಗೆ ಪುಕ್ಕಟೆಯಾಗಿ ಹಸ್ತಾಂತರಿಸುವ ಕುರಿತು ಮುಚ್ಚಳಿಕೆ ಪತ್ರ ಬರೆದುಕೊಡತಕ್ಕದ್ದು. ನಗರಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರ, ನಗರ ಯೋಜನಾ ಪ್ರಾಧಿಕಾರ, ಸ್ಥಳೀಯ ಸಂಸ್ಥೆ ಈ ರೀತಿಯಾಗಿ ವಿನ್ಯಾಸ ಅಭಿವೃದ್ಧಿಪಡಿಸಿದ ನಂತರ ಉಳಿಯಬಹುದಾದ ಮೊತ್ತವನ್ನು ವಿನ್ಯಾಸದ ಮಾಲೀಕರಿಗೆ ಹಿಂತಿರುಗಿಸತಕ್ಕದ್ದು. This is the condition, 60% and 40%. This was introduced on 26/5/2005. But this layout was developed by 4th respondent, and it was on 31/8/2004. And I have purchased
31/8/2004 is a plan sanction.
And he has developed it. And at that time there was no condition. And I have purchased this site on 2/5/2005.
You have purchased one site.
One site, my lord. I have purchased 2 sites. Out of this, my lord, in respect of this one site, I have sought for.
When did you purchase it?
2 to 2005, my lord. 21 to 2005 I have purchased. 21 to 2005 is the sale deed. Annexure A is the sale deed.
Page
21, my lord, page. Annexure A, my lord, page 15.
Yes.
My lord, after, my lord, at that time when I purchased it, this notification, the government GO of Annexure J was not in operation, and therefore there was no condition of release. But I have sought for from the second respondent building sanction plan, I have sought approval of building plan. Page number 84 is the building plan, and 85, my lord, is my letter to the respondent. They did not take it at the counter for approval. They say that there is a the developer has taken release order for some 65% of his layout plan, and your site is not figured in that release order. Therefore, your application for sanction of license, the building plan cannot be taken, is the oral instruction given to me. Then I have written a letter to them saying that notification has come subsequently in the month of May. I have purchased in January 2005. Therefore, that notification cannot be made applicable. Therefore, my plan has to be sanctioned. For that, they are saying that developer has taken a release order. Therefore, even though plan was sanctioned much earlier, he has developed it subsequently after notification came into force, and he has taken release order. Therefore, your plan cannot be sanctioned. In this regard, your last may kindly
Is
see
the
the
development of the layout completed? Development of the layout complete ಮಾಡಿದಾರಾ?
But that's what they say. Now they are saying that layout is not complete. Therefore, they are not.
So that
Your last time-
40% they will take over.
They have to take over. If that is the case, if this notification is to be applicable, then they have to take over and develop it in on their cost. But how them
Even till date, it's not developed?
No. You last time can see the development, how they have done it. At Annexure L, page 82. This is the release order which they have issued. ವಿಷಯ ಖಾಸಗಿ ಅನುಮೋದಿತ ವಸತಿ ವಿನ್ಯಾಸ ನಿವೇಶನವನ್ನು ಬಿಡುಗಡೆ ಮಾಡುವ ಸಂಬಂಧ ಸರ್ಕಾರದ ಸುತ್ತೋಲೆ ಸಂಖ್ಯೆ ಸೊ ದೆನ್ ನಿವೇಶನ ಬಿಡುಗಡೆ ಸಂಬಂಧಿಸಿದ ಅರ್ಜಿದಾರರು ಸಲ್ಲಿಸುವ ದಿನಾಂಕ 20/9/2005 ಮನವಿ ಪತ್ರ 20/9/2005 ರಿಲೀಸ್ ಮಾಡಿದ್ದು 22/9/2005 2 days ಅಲ್ಲಿ without looking into anything whether those sites are sold or layout has been formed or not, without anything, what the developer has done is he has taken this release order in respect of sites which were unsold, and whichever the sites which he has sold earlier, he has not done this. Therefore, exactly this is 65% as per the notification. Out of 99, 60% which covers, he has taken the release order.
Yes.
Therefore, my lord, I have in my representation I have stated that I have purchased it in the year 2005, much before this notification came into force, and that notification can be applied prospectively, not retrospectively, for the layout which were approved earlier. Hence, my plan sanction has to be approved. Their page 87 is their endorsement. I have given a representation as per Annexure N, my lord, page 85.
Now is that layout completed?
My lord, now
the amenities are completed.
He has given that release of layout. This
ಮೂರನೇ ಸತಿ ಕೇಳ್ತಾ ಇದ್ದೀವಿ ಲೇಔಟ್ ವರ್ಕ್ ಕಂಪ್ಲೀಟ್ ಆಗಿದೆಯಾ, ರೋಡ್ಸ್ ಆಗಿದೆಯಾ, ಎಲೆಕ್ಟ್ರಿಸಿಟಿ ಆಗಿದೆಯಾ, ಸ್ಯಾನಿಟೇಷನ್ ಆಗಿದೆಯಾ, ವಾಟರ್ ಆಗಿದೆಯಾ?
Roads are there, but as per them it is not fully complete.
So you won't claim that against them?
I don't claim against them. Now this
completion ಆಗಿಲ್ಲ ಮಾಡ್ಕೊಡಿ ಅಂತ you should not be claiming against.
Yes. Now this developer himself is it has gone into trouble. Kanwa Institute.
You have not made them a party.
I have made them as a. No, I have not made them, but it is not in existence also. Taken over by.
Taken over by andre, there must be somebody then.
Competent authorities appointed for distributing his assets.
KPD.
Yes, ma'am. KPD.
So you should make the competent authority a party.
But this layout, my lord, they have not attached these layout and all. only some other.
This layout is not attached.
This is not attached.
Yes, please.
And for R2, my lord. Another notification issued by the government of Karnataka on 3/12/2012, my lord.
3/12/2012.
Annexure K. Page number 77.
Page number?
77.
77.
Please.
Yes,
May I read, please?
please.
ವಿಷಯ ಖಾಸಗಿ ವಿನ್ಯಾಸ ಅನುಮೋದನೆ ಅಭಿವೃದ್ಧಿಪಡಿಸುವಿಕೆ ಮತ್ತು ವಿನ್ಯಾಸಗಳಲ್ಲಿಯ ನಿವೇಶನಗಳನ್ನು ಬಿಡುಗಡೆಗೊಳಿಸುವ ಕುರಿತು ಅನುಸರಿಸಬೇಕಾದ ವಿಧಿವಿಧಾನಗಳು. ಉಲ್ಲೇಖ ಸರ್ಕಾರದ ಸುತ್ತೋಲೆಯ ಕ್ರಮ ಸಂಖ್ಯೆ 104 ಕ್ಲಾಸ್ 1 ದಿನಾಂಕ 9/5/2005. ಸರ್ಕಾರದ ಸುತ್ತೋಲೆಯ ಕ್ರಮ ಸಂಖ್ಯೆ 104 ಕ್ಲಾಸ್ 2 2005 ದಿನಾಂಕ 9/5/2005. ಸರ್ಕಾರದ ವಿರುದ್ಧ ಸುತ್ತೋಲೆ ಕ್ರಮ ಸಂಖ್ಯೆ ಇವೆಲ್ಲ ಲಾಸ್ಟ್ ಫಸ್ಟ್ ಪೇಜ್ ಓದ್ತೀನಿ. ಸರ್ಕಾರದ ಉಲ್ಲೇಖಿತ 1ರಿಂದ 4ರ ಸುತ್ತೋಲೆಗಳಲ್ಲಿ ಖಾಸಗಿ ವಿನ್ಯಾಸಗಳ ಅನುಮೋದನೆ ಅಭಿವೃದ್ಧಿಪಡಿಸುವಿಕೆ ಮತ್ತು ಅನುಮೋದಿತ ವಿನ್ಯಾಸಗಳಲ್ಲಿನ ನಿವೇಶನಗಳನ್ನು ಬಿಡುಗಡೆ ಮಾಡುವ ಕುರಿತು ವಿಧಾನವನ್ನು ವಿವರಿಸಲಾಗಿದೆ. ಸರ್ಕಾರದ ಉಲ್ಲೇಖಿತ ಕ್ಲಾಸ್ 5 ಅಧಿಸೂಚನೆಯನ್ನು ಹೊರತುಪಡಿಸಿ ರಾಜ್ಯದಲ್ಲಿ ನಿವೇಶನಗಳನ್ನು ನೋಂದಣಿ ಮಾಡಲು ಅನುಸರಿಸಬೇಕಾದ ಕ್ರಮ ಮತ್ತು ನೋಂದಣಿ ಸಮಯದಲ್ಲಿ ನೋಂದಣಿ ಅಧಿಕಾರಿಗಳು ಪಡೆಯಬೇಕಾದ ದಾಖಲೆಗಳ ಕುರಿತು ಸಹ ನಿರ್ದೇಶನ ನೀಡಲಾಗಿದೆ. ಇದೇ ಸುತ್ತೋಲೆಯಲ್ಲಿ ವಿನ್ಯಾಸ ಅನುಮೋದನೆಯಾದ ನಂತರ ನಿವೇಶನಗಳನ್ನು ಬಿಡುಗಡೆಯ ಕುರಿತು ಸ್ಥಳೀಯ ಯೋಜನಾ ಪ್ರಾಧಿಕಾರಗಳಿಂದ ದಾಖಲೆಗಳನ್ನು ಪಡೆದು ನಿವೇಶನಗಳನ್ನು ನೋಂದಾಯಿಸುವ ಬಗ್ಗೆ ಸೂಚನೆ ನೀಡಲಾಗಿದೆ. ಸರ್ಕಾರದ ಉಲ್ಲೇಖಿತ 1ರಿಂದ 4ರ ಸುತ್ತೋಲೆಗಳ ನಿರ್ದೇಶನಗಳನ್ನು ಪುನಶ್ಚರಿಸುತ್ತಾ ನಿವೇಶನಗಳನ್ನು ಬಿಡುಗಡೆಗೊಳಿಸುವ ಪ್ರಯುಕ್ತ ಉಲ್ಲೇಖ ಕ್ಲಾಸ್ 6ರಲ್ಲಿ ಹೊರಡಿಸಲಾಗಿದ್ದ ಸರ್ಕಾರದ ಸುತ್ತೋಲೆಯಲ್ಲಿ ಕೆಲವು ಮಾರ್ಪಾಡುಗಳನ್ನು ಸೂಚಿಸಿ ಅದರನ್ವಯ ಈ ಕೆಳಕಂಡ ಮಾರ್ಗಸೂಚಿಯನ್ನು ಅನುಸರಿಸಲು ನಗರಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರಗಳು, ನಗರ ಯೋಜನಾ ಪ್ರಾಧಿಕಾರಗಳು ಮತ್ತು ರಾಜ್ಯದಲ್ಲಿ ಎಲ್ಲಾ ಸ್ಥಳೀಯ ಸಂಸ್ಥೆಗಳಿಗೆ ನಿರ್ದೇಶನ ನೀಡಲಾಗಿದೆ. ಇದರಲ್ಲಿ ನಾಲ್ಕನೇ ಪ್ಯಾರ ಕ್ರಮ ಸಂಖ್ಯೆ 1ರಲ್ಲಿ ನಿಗದಿಪಡಿಸಿದ ಅವಧಿಯೊಳಗೆ ವಿನ್ಯಾಸದ ಅಭಿವೃದ್ಧಿ ಕಾಮಗಾರಿಗಳನ್ನು ವಿನ್ಯಾಸದ ಮಾಲೀಕರು ಪೂರ್ಣಗೊಳಿಸದೇ ಇದ್ದಲ್ಲಿ ಉಳಿದ ಅಭಿವೃದ್ಧಿ ಕಾಮಗಾರಿಗಳನ್ನು ನಗರಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರ, ನಗರ ಯೋಜನಾ ಪ್ರಾಧಿಕಾರ, ಸ್ಥಳೀಯ ಸಂಸ್ಥೆ ಕೈಗೊಳ್ಳತಕ್ಕದ್ದು. ಇದಕ್ಕೆ ತಗಲುವ ವೆಚ್ಚವನ್ನು ಉಳಿದ 60% ನಿವೇಶನಗಳನ್ನು ಮಾರಾಟ ಮಾಡುವುದರಿಂದ ಬರುವ ಹಣದಿಂದ ಭರಿಸತಕ್ಕದ್ದು. ಇದಕ್ಕೆ ಅನುವಾಗಲು ವಿನ್ಯಾಸದ ಮಾಲೀಕರು ಮೇಲಿನ ಷರತ್ತನ್ನು ಅನುಸರಿಸದೇ ಇದ್ದಲ್ಲಿ ಉಳಿದ 60% ನಿವೇಶನಗಳನ್ನು ನಗರಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರ, ನಗರ ಯೋಜನಾ ಪ್ರಾಧಿಕಾರ, ಸ್ಥಳೀಯ ಸಂಸ್ಥೆಗೆ ಪುಕ್ಕಟ್ಟೆಯಾಗಿ ಹಸ್ತಾಂತರಿಸುವ ಕುರಿತು ಮುಚ್ಚೋಳಿಕೆ ಪತ್ರ ಬರೆಸಿಕೊಳ್ಳತಕ್ಕದ್ದು. ನಗರಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರದ, ನಗರ ಯೋಜನಾ ಪ್ರಾಧಿಕಾರಗಳಲ್ಲಿಯ ಸಂಸ್ಥೆಯು ಈ ರೀತಿಯಾಗಿ ವಿನ್ಯಾಸ ಅಭಿವೃದ್ಧಿಪಡಿಸಿದ ನಂತರ ಯಾವುದೇ ಮತ್ತು ಹೆಚ್ಚುವರಿಯಾಗಿ ಉಳಿದ ವಿನ್ಯಾಸ ಮಾಲೀಕರಿಗೆ ಇರ್ತದೆ. ಇದರಲ್ಲಿ ಈ 60% ಏನ್ ರಿಲೀಸ್ ಮಾಡಿದೀವೋ ಅದರಲ್ಲಿ ಇವ್ರ ಸೈಟ್ ಇಲ್ಲ ಸರ್.
ಅದು ಗೊತ್ತಾಯ್ತು. ಬಟ್ ಇವರು ತಗೊಂಡಿದ್ದು ಸುತ್ತೋಲೆ ಬರಕ್ ಮುಂಚೆ, ಸುತ್ತೋಲೆ ಬಂದಿದ್ದು 26/5/25, ಅವ್ರು ಪರ್ಚೇಸ್ ಮಾಡಿದ್ದು 21/2/25. ಸೊ ಅವ್ರು ಪರ್ಚೇಸ್ ಮಾಡಿದ ದಿನ ದೇರ್ ವಾಸ್ ನೋ ರೆಸ್ಟ್ರಿಕ್ಷನ್. ಈ ಸುತ್ತೋಲೆ ಬರುತ್ತೆ ಅಂತ ಅವ್ರಿಗೇನು ಗೊತ್ತಿರ್ಲಿಲ್ಲ. ಸೇಲ್ ಡೀಡ್ ಆಗೋಗಿದೆ. ಸೇಲ್ ಡೀಡ್ ಆದ್ಮೇಲೆ ಹೌ ಕ್ಯಾನ್ ಯು ಸೇ ಐ ವೋಂಟ್ ಗ್ರಾಂಟ್ ದ ಪ್ಲಾನ್ ಸ್ಯಾಂಕ್ಷನ್? 26/5 ಆದ್ಮೇಲೆ ಸೇಲ್ ಆಗಿದ್ರೆ ಯು ವುಡ್ ಹ್ಯಾವ್ ಬೀನ್ ರೈಟ್. ಸುತ್ತೋಲೆ ಬಂದಿತ್ತು, ಈಸ್ ಸಪೋಸ್ ಟು ಬಿ ನಾಲೆಜಬಲ್ ಅಬೌಟ್ ಇಟ್. ಅವ್ರಿಗೆ ಗೊತ್ತಿದ್ದು ತಗೊಂಡಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ಬೋದು.
ವಾಟರ್ ಸಪ್ಲೈ, ಎಲೆಕ್ಟ್ರಿಸಿಟಿ ಕಲೆಕ್ಷನ್, ರೋಡ್ಸ್ ವರ್ ಪ್ರಾಪರ್ಲಿ ನಾಟ್ ಕನ್ಸ್ಟ್ರಕ್ಟೆಡ್, ನಾಟ್ ಕಂಪ್ಲೀಟೆಡ್.
ನಿಮ್ಮ ಆಫೀಸರ್ಸ್ ಹ್ಯಾವ್ ಮೆಸ್ಡ್ ಅಪ್ ಆನ್ ದ ಹೋಲ್ ಥಿಂಗ್. ಅವ್ರು ವೆರಿಫೈ ಮಾಡ್ಬೇಕಾಗಿತ್ತು, ಸೇಲ್ ಆಗಿದೆಯೋ ಇಲ್ವೋ, ಡಿಕ್ಲರೇಷನ್ ತಗೊಂಡ್ಬೇಕಾಗಿತ್ತು. ಸೇಲ್ ಆಗಿಲ್ಲ, ಎಲ್ಲ ಹಂಗೆ ಇದೆ, ಈ 30% ನಾವು ರಿಲೀಸ್ ಮಾಡ್ತಾ ಇದೀವಿ, ಮತ್ತೆ 30% ರಿಲೀಸ್ ಮಾಡ್ತಾ ಇದೀವಿ ತಗೊಂಡ್ಬೇಕಾಗಿತ್ತು. You did not verify whether there is a sale which has happened or not. Why should he suffer because of the fraud by the developer and negligence on part of your officers? ಇವ್ರಿಗೇನು ಇಲ್ಲ, ನಿಮ್ಮಿಬ್ರು ಗಲಾಟೆಯಲ್ಲಿ ನಿಮ್ಮಿಬ್ಬರು ಫಾಲ್ಟ್ ಅಲ್ಲಿ ಅವ್ರಿಗೆ ಸಫರ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ. If you want to recover the cost of that implementation of the layout insofar as proportionally, you recover it from the developer, one. And we will record Mr. Sampath's submission that he will not insist for any amenity to be provided in this layout insofar as his site is concerned. You'll have to file an affidavit. We'll dictate the order. We'll have it on another day, file the affidavit, then we'll finalize the order. Called Kanwa Nagar. He had claimed to have developed a layout called Kanwa Nagar in 8 acres and 39 guntas of land comprised of survey number 94/7, 94/4A, 95/1A, 95/1B, 93/6, 94/5, 94/8 at Danoji Palya Hamlet, Arshinakunte Village, Kasba Obli, Nelamangala Taluk, Bangalore Rural District. After having obtained due conversion orders in relation thereto. It was claimed that the said developer had obtained a layout plan sanction on 31/8/2004 and subsequent thereto had formed a layout. The petitioner, with the intention of purchasing a site, had been approached and had purchased a site in terms of Annexure A, being a registered sale deed dated 21/2/2005. In terms of the said sale deed, the petitioner is stated to have purchased site number 38, having Kaneshwari number 65/38, measuring 30 into 40 feet, totally 1,200 feet, 200 square feet. The petitioner had applied for a plan sanction and building license. When did you apply for it?
What happened, I wanted to apply. They did not take it in the counter. Then I wrote a letter to them saying that it is not been accepted in the office. You please say that this notification of Annexure J is prospective in nature, that cannot be made applicable, and direct them to issue Annexure N, my lord, is my letter.
I had sought to apply for a plan sanction building license, which was not accepted on the ground that the petitioner's site has not been released in terms of circular dated 26/5/2005. Hence, the petitioner had sought for a clarification that the said circular would not be applicable to the petitioner, since the petitioner had purchased this site prior to the issuance of circular. In reply thereto, the respondents number 2, while letter dated 19/1, dated 21/4/2017, had indicated that only 60% of the sites had been released in favor of the developer, remaining 40% not having been released, the petitioner's site coming within that remaining 40%. No plan sanction could be granted. The layout not having been completed, the said sites would fall within the custody of respondent number 2 for the purpose of implementation of the layout, and as such rejected the contention of the petitioner. It is in that background that the petitioner is before this court seeking for the aforesaid relief. The submission of Shri Sampath Bapat, learned counsel for the petitioner, is that the circular dated 26/5/2005 can only be said to be prospective in nature and cannot be applied retrospectively to the petitioner insofar as a sale of a property of a site by the developer in favor of the petitioner under registered sale deed dated 21/2/2005. His submission is that the petitioner not being the said circular having come into force much subsequently, there having no restriction on the purchase of any site by the petitioner. The petitioner has legally, in a valid manner, under a registered sale deed, purchased the said plot, and as such, the petitioner cannot be prevented from exercising due ownership right in respect thereto by putting up a construction thereon. His further submission is that the developer has played fraud on the respondent number 2 inasmuch as the developer, having sold several sites, has not taken release of those sites but has taken release of the unsold sites which has been granted by respondent number 2. That action on part of the developer has not been verified properly by respondent number 2, resulting in injustice being caused to the petitioner in the aforesaid manner. In that background, he submits that the release which have been sought for are required to be granted. Shri N. Gurumurthy, learned counsel for respondent number 2, would submit that though the circular came into force on 26/5/2005, the developer has accepted the said circular and acted on the said circular, has made applications for release of sites in terms of the said circular. Respondent number 2, having released sites as per the application made, the layout not having been formed, the duty of completing have not been completed properly. It would be the duty of respondent number 2 now to complete the said layout. In terms of the circular dated 26/5/2005, the security of those remaining plots being available with respondent number 2, respondent number 2 can sell the said sites, appropriate the amounts towards the completion of the layout. And as such, the petitioner's site which has not been released, the petitioner, as such, in respect of the petitioner site which has not been released, the petitioner cannot be granted a plan sanction. Correct? Anything else?
Site number 38, petition number site number is 38. That site number 38 is not in a release on. ಏನು ಮರಳು ಕೊಟ್ಟಿದ್ವೋ ನಾವು ಅದರಲ್ಲಿ ಅವರದಿಲ್ಲ ಸರ್.
He reiterates that petitioner site number 38 is not part of the release order granted by respondent number 2, and as such the petitioner cannot claim any right to put up any construction thereon. Shri Naveen Jain, learned counsel for respondent number 3, submit that respondent number 3 is a formal party.
They approve ownership plan, we will issue license.
Formal is only a formal party if the no objection certificate is issued by respondent number 2. The building plan will be sanctioned by respondent number 3. Who is respondent number 4? Kalyan Yakke? City Municipal Council has nothing to do.
Nothing to do.
Now this R3 merged with Arshinakunta Gram Panchayat. It has become a part of City Municipal Council. Therefore,
so now the sanctioning authority is respondent number 4.
Please,
where is Kalyan?
For respondent number 4.
Same NIM submission. You adopt the submission. Now you are the authority. You can't grant the plan sanction, Naveen. No.
I'm sorry, it was merged.
Naveen submission. The submission of Shri Kalyanar, current counsel for respondent number 4, is if a no objection certificate issued by respondent number 2, respondent number 4 would issue the necessary plan sanction for the building plan sanction and building license. Heard so and so peruse papers. The points that would arise for consideration are: 1, whether the circular dated 26/5/2005 issued by the
state government,
our department, issued by the Urban Development Department, is prospective in nature, or could it be applied retrospectively to a site which has been sold prior to the circular being issued? Whether in the facts and circumstances of the present matter, the respondent number 2 could deny the issuance of a no objection certificate on the ground that the site of the petitioner has not been released in terms of circular dated 26/5/2005. What order? Answer to point. I answer the above points as follows. Answer to point number 1. It is not in dispute that the circular was issued on 26/5/2005, and it's only in terms of said circular that there was restriction imposed on a private layout developer from sale of the sites formed in the layout without obtaining a release from the planning authority. The planning authority having sanctioned the layout on 31/8/2004 also not being in dispute, it is further not in dispute that the petitioner has purchased site number 38 on 21/2/2005 which is much prior to the circular coming into force on 26/5, circular being issued on 26/5/2005. Now, what the respondent number 2 is seeking to do is to apply the circular to a sale deed of the petitioner dated 21/2/2005, which is much prior to the circular being issued. And it is in that context that it is required to be considered as to whether the circular is prospective or retrospective. Para. The circular dated 26/5/2005 imposing a ban stroke prohibition on sale of a site by a developer without obtaining a release order. That prohibition being penal, having penal consequences, can, in my considered opinion, be said only to be prospective, inasmuch as the circular cannot be made applicable to a sale of a property which was made prior to the circular coming into force. At the most, it could be contended that any sales post the circular coming into force on 26/5/2005 would be bound by said circular, but cannot be applied to a sale which has occurred prior to 26/5/2005, since there was neither any embargo nor prohibition in relation to such sale as on the date of the sale, which in this case is 21/2/2005. When the sale made in favor of the petitioner by the developer of the layout was not subject to or could not be said to be subject to the circular dated 26/5/2005, it cannot now be contended by respondent number 2 that the said circular would apply. Sorry, the next point. In that view of the matter, the circular dated 26/5/2005 having penal consequences of the remaining sites being vested with the planning authority with power to sell the said site, appropriate the amounts therefrom to complete the formation of the layout if the developer has not completed, cannot, in my considered opinion, be made retrospectively applicable to a site which has been sold prior to the circular coming into force, since the purchaser cannot be now put to a disadvantage to say that there is no release order passed in respect of his site. Hence, I answer point number 1 by holding that the circular dated 26/5/2005 will not apply to sites sold under a registered sale deed prior to the circular coming into force, but would however apply to all sales effected post 26/5/2005. Answer to point number 2. In the facts in this matter would have been dealt with above, would categorically indicate that the sale in favor of the petitioner has occurred on 21/2/2005 when the circular has come into force on 26/5/2005, which I have held to be prospective in nature, and that the same cannot be retrospectively applied to sale in favor of the petitioner on 21/2/2005. In that view of the matter, merely because the layout formation has not been completed and all works have not been completed by the developer, would not entitle respondent number 2 to deny the no objection certificate to the petitioner for constructing on his property. I am also persuaded to arrive at this conclusion in the present matter for another reason, inasmuch as when an application had been made by the developer for release of certain sites, it was required of respondent number 2 to ascertain the total number of sites which have been sanctioned, total number of sites which are to be formed, if any of those sites have been sold prior to the circular coming into effect. If so, to identify those sites and then include the same in the release order when applied for, inasmuch as the discretion could not have been left to the developer alone to seek for release of sites of his choice without seeking for release of sites which have already been sold. This duty was vested with respondent number 2 to discharge before such release of sites, taking into consideration that the circular came into force on 26/5/2005 whereas the plan was sanctioned on 31/8/2004, layout plan was sanctioned on 31/8/2004, and in the interregnum, there was always a possibility of the developer selling any site post the layout being approved. This duty was cast on respondent number 2 during that particular phase to all the sites, all the layouts which had been approved prior to the circular coming into force, is my considered opinion. The developer, therefore, having applied for release of sites of his choice, respondent number 2 not having verified if any other site had been sold in the said layout, I have the considered opinion that respondent number 2 has not discharged his duties, and as such, on account of the non-discharge of the duties on part of respondent number 2, the petitioner cannot be prevented from making use of his property for his personal use. As such, I answer point number 2 by holding that in the peculiar facts and circumstances of this case, the respondent number 2 would have been required to issue the no objection certificate for the purpose of the plan sanctions sought to be obtained by petitioner from the erstwhile respondent number 3, which is now the Nelamangala City Municipal Council respondent number 4. What order? In view of my finding in respect of point number 1 and 2, it would be required now for a direction to be issued to respondent number 2 to issue a no objection certificate for respondent number 4 to sanction a building plan and grant a building license in terms of the applicable law as on today. As such, I pass the following order. Writ petition is allowed. It is declared that the circular dated 26/5/2005 bearing number so and so at Annexure J is not applicable to the petition scheduled property with subject matter of a registered sale deed in terms of Annexure A dated 21/2/2005. Respondent number 3. Respondent number 2 is directed to issue a no objection certificate within a period of. Now you want to continue with the same plan or different plan?
I will inquire. I will
You
give a
can't
fresh.
continue with that plan.
Yes, I will give a fresh.
But plan you will have to give to respondent number 4.
Yes, madam.
NOC
I
only.
have to give NOC.
Respondent number 2 is directed to issue a NOC to the petitioner stating is no objection for the petitioner to approach respondent number 4 for sanction of building plan in accordance with the applicable laws, including the building bylaws as applicable today. Respondent number 4 is directed to consider the plan submitted for sanction by the petitioner along with the no objection certificate issued by respondent number 2 and approve the same within a period of 60 days from the date on which the plan is submitted to respondent number 4.
Serial number 3, I am just held up. I dismiss.
You'll have to wait. We can't jump.
Please.
Serial number 16, HR Ananta Krishnamurthy.
For
the petitioner, my lord.
Yes.
My lord, this pertains to PVMP tax demand. Lord, on 16/2/2024, there was an order, my lord. If your lordship may kindly peruse that.
16/2/2024. Yes.
Yeah, my lord, memo of calculations filed on behalf of the petitioner, my lord. And according to our memo of calculation, 7,66,135 was payable. Demand draft for which was already paid, handed over to respondent number 1. My lord, there was a direction for respondent number 1 to encash that said DD and without prejudice to their stand. They have not filed any objections to a memo of calculation and the matter is standing at that stage.
We have also filed a memo of calculation
You
on
have filed?
8/12/2023.
On what date?
8th December 2023.
That was the earlier one.
Earlier one, yes.
So, my lord.
Now, after this payment, you are asked to make your submission.
So, my lords, my instructions are as per this memo of calculation, whatever amount he has paid, around 7,66,000, the balance amount he needs to pay. That's all my instructions are with respect to the memo of calculation.
Don't go by only your instruction. You have to make your submission. You are the counsel. So you're ready to address arguments to support that.
Yes, my lords.
So 8, when did you file it?
8th December 2023, my lords.
8 December 23. Yes. There's nothing in this, madam.
My lords, we have filed a memo of calculation which pertains to the tax from 20.
You have produced a memo of calculation which doesn't have anything. No, not filed here. You might have given there.
Lords, it is taken on record also, my lords.
Yes, the undersigned counsel for respondent prays to produce the following document and same may be taken on record. Tax calculation of subject property, but there is no calculation. There's only one page.
My lords, there might be, can request to file it again, my lords. Can you?
You have a copy of it?
We have a copy, just one.
Additional copy you have? Then you,
If my lords
you have a
can-
copy?
No, my lord,
You also don't have.
Lords, can you have, if my lords can have it
And
next
counsel
week?
for respondent submits that the calculation that though in spite that, and though in terms of the order dated 16/2/24, the respondent has encashed the demand draft which had been furnished for a sum of rupees 7,66,135, the respondent would still continue for insistence of payment of taxes in terms of the calculation submitted on 8/12/23. A peril of the memo dated 8/12/23 does not indicate any calculations having been produced. And counsel for the petitioner also submits that he has not been furnished with a copy of the memo dated 8/12/23. In that view of the matter, the counsel for, faced with the above situation, counsel for respondent seeks for and is granted a week's time to file the memo of calculation after furnishing copy thereof to the counsel for the petitioner. Relist on, when will you furnish it, madam?
Tomorrow, my lords.
How long do you want to take to go through it and come back?
My lord, next week.
My lords,
for
I may
10
be
days.
granted time because this is given in 2023. I may be allowed to update this memo for calculation, give him day after tomorrow, my lords. In 2023, I'll hack
Relist on 16th February.
Lord, interim order may be extended.
Interim order earlier granted is extended. You give it to him in 2 days' time, so he can go through it.
Yes.
Take his phone.
Serial number 17, adjourned. Serial number 18, M.R. Vijay Kumar.
Lord, appealing for the petitioner. Senior is not well, may not kindly have it next week.
Submitted, the arguing counsel for the petitioner is indisposed. Relist on 17th February.
Much obliged.
19, Harish Bhandari.
Yes, Mr. Bhandari.
Please, Your Lordship. Demand notices, Your Lordship. The petitions are in the business of advertisements. Hoardings, Your Lordship. Outdoor hoardings.
Yes.
A corporation, municipal corporation, it's a city corporation, because Shivamogga issued demand notice, Your Lordship, pursuant to the resolution passed by it, Your Lordship. Your Lordship, I kindly refer to Annexure C. Resolution of the corporation, Your Lordship, Annexure C. Page 24, Your Lordship. Right.
You annexure B1, B2, B3. 24.
ಶಿವಮೊಗ್ಗ ನಗರ ಪಾಲಿಕೆ ಮಹಾನಗರ ಪಾಲಿಕೆ ಶಿವಮೊಗ್ಗ ಅದರಲ್ಲಿ ನೆಕ್ಸ್ಟ್ ಪೇಜ್ 25ಗೆ ಬಂದಾಗ ವಿಷಯ ಸಂಖ್ಯೆ ವಿಷಯ ನಂಬರ್ 28 ಸಬ್ಜೆಕ್ಟ್ ನಂಬರ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಅದರಲ್ಲಿ ಕೆಳಗಡೆದಲ್ಲಿ ಲಾರ್ಡ್ಶಿಪ್ ಪ್ರಸ್ತುತ ಶಿವಮೊಗ್ಗ ನಗರಸಭೆಯು ಲಾರ್ಡ್ಶಿಪ್ ನಗರ ಪಾಲಿಕೆ ಮೇಲ್ದರ್ಜೆಗೆ ಏರಿಸಲ್ಪಟ್ಟಿದ್ದು ಇಟ್ ವಾಸ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಮುನ್ಸಿಪಾಲಿಟಿ ಕರ್ನಾಟಕ ಪೌರ ನಿಗಮ ಅಧಿನಿಯಮ 1986 ಕಲಂ 103 ಶೆಡ್ಯೂಲ್ 8ರಂತೆ ಈ ಕೆಳಕಂಡ ಜಾಹೀರಾತು ತೆರಿಗೆಯನ್ನು ವಿಧಿಸಬಹುದಾಗಿರುತ್ತದೆ. This is the lordship maximum they have enhanced your lordship.
Maximum permissible.
Maximum they have
Schedule 8 they have applied it.
Yes, they have maximum to enhance your lordship. This, your lordship, objected by certain members of the corporation. Then it was decided to place it before the financial committee. That, your lordship, financial committee resolution, lordship, or the decision at Annexure D, I have produced, your lordship. Page 27 onwards. Financial committee.
Relevant portion.
What is, lordship?
Relevant portion.
Relevant portion, lordship, page 28 ಅಲ್ಲಿ.
ವಿಷಯ 7.
ವಿಷಯ ಸಂಖ್ಯೆ 7.
7.
ಶಿವಮೊಗ್ಗ ನಗರದ ಖಾಸಗಿಯವರು ತಮ್ಮ ಮಾಲೀಕತ್ವದ ಕಟ್ಟಡದ ಮೇಲೆ ಜಾಹೀರಾತು ಫಲಕ ಹೋರ್ಡಿಂಗ್ಸ್ ಅಳವಡಿಸಲು ಜಾಹೀರಾತು ಸಂಖ್ಯೆಯವರಿಗೆ ಅನುಮತಿ ನೀಡಿದ ನಂತರ ಪಾಲಿಕೆ ವತಿಯಿಂದ ನೆಲ ಬಾಡಿಗೆ ಪಡೆಯದೆ ಕೇವಲ ಜಾಹೀರಾತು ಶುಲ್ಕ ಪಡೆಯುತ್ತಿರುತ್ತದೆ. ಆದರೆ ಖಾಸಗಿ ಕಟ್ಟಡದ ಮಾಲೀಕರು ತಮ್ಮ ಕಟ್ಟಡ ಜಾಹೀರಾತುಗಳನ್ನು ಹೋರ್ಡಿಂಗ್ಸ್ ಅಳವಡಿಸಿ ವಾಣಿಜ್ಯ ಉದ್ದೇಶಕ್ಕೆ ಉಪಯೋಗಿಸುವುದರಿಂದ ಸದರಿ ಜಾಹೀರಾತು ಫಲಕಗಳನ್ನು ಅಳವಡಿಸಿರುವ RCC ಮೇಲ್ಚಾವಣಿ ವಾಣಿಜ್ಯ ದರದಲ್ಲಿ ಆಸ್ತಿ ತೆರಿಗೆಯನ್ನು ಪಾಲಿಸಿಕೊಳ್ಳುವ ಬಗ್ಗೆ ಸಭೆಯಲ್ಲಿ ಚರ್ಚಿಸಿ ಸೂಕ್ತ ತೀರ್ಮಾನ ಕೈಗೊಳ್ಳುವ ಬಗ್ಗೆ. ನೆಕ್ಸ್ಟ್, ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್, ವಿಷಯ ಬಗ್ಗೆ ವಿಸ್ತೃತವಾಗಿ ಚರ್ಚಿಸಲಾಗಿ ಖಾಸಗಿ ಕಟ್ಟಡದ ಮಾಲೀಕರು ತಮ್ಮ ಕಟ್ಟಡ ಮೇಲೆ ಜಾಹೀರಾತು ಫಲಕಗಳಿಗೆ ಅನುಮತಿ ನೀಡಿದ ಸಂದರ್ಭದಲ್ಲಿ ಅಂತಹ ಆಸ್ತಿ ಮಾಲೀಕರಿಂದ ಜಾಹೀರಾತು ಫಲಕಗಳನ್ನು ಅಳವಡಿಸುವ ಕಟ್ಟಡ ಮೇಲ್ಚಾವಣಿಗೆ ಪ್ರತಿ ವರ್ಷ ವಾಣಿಜ್ಯ ದರದಂತೆ ಆಸ್ತಿ ತೆರಿಗೆಯನ್ನು ವಿಧಿಸುವಂತೆ ಸರ್ವಾನುಮತದಿಂದ ತೀರ್ಮಾನಿಸಲಾಯಿತು. ಮುಂದುವರೆದು ದಿನಾಂಕ 30/3/2015 ಮಹಾನಗರ ಪಾಲಿಕೆ ಪರಿಷತ್ ಸಭೆಯಲ್ಲಿ ವಿಷಯ ಸಂಖ್ಯೆ 28ರಲ್ಲಿ ಶಿವಮೊಗ್ಗ ಮಹಾನಗರ ಪಾಲಿಕೆ ವ್ಯಾಪ್ತಿಯ ಅಡಿಯಲ್ಲಿ ಅಳವಡಿಸಿರುವ ಜಾಹೀರಾತು ಫಲಕ ಜಾಹೀರಾತು ತೆರಿಗೆ ಮತ್ತು ನೆಲ ಬಾಡಿಗೆಯನ್ನು ಹೆಚ್ಚಳ ಮಾಡಿ ನಿರ್ಣಯ ಕೈಗೊಂಡಿದ್ದು, ಸದರ ನಿರ್ಣಯವನ್ನು ದಿನಾಂಕ 3/6/15 ಸಾಮಾನ್ಯ ಸಭೆಯಲ್ಲಿ ಓದಿ ರೆಕಾರ್ಡ್ ಮಾಡುವ ಸಂದರ್ಭದಲ್ಲಿ ಜಾಹೀರಾತು ಶುಲ್ಕ ಭಾರಿ ಪ್ರಮಾಣದಲ್ಲಿ ಹೆಚ್ಚಳ ಮಾಡಿರುವ ಬಗ್ಗೆ ಸದಸ್ಯರುಗಳು ಪ್ರಸ್ತಾಪಿಸಿದಾಗ ಚರ್ಚೆ ನಡೆದು ಈ ಬಗ್ಗೆ ವಿಸ್ತೃತವಾಗಿ ಚರ್ಚಿಸಿ ಜಾಹೀರಾತು ಶುಲ್ಕ ನಿರ್ಧರಿಸಲು ಮಹಾನಗರ ಪಾಲಿಕೆಯ ತೆರಿಗೆ ನಿರ್ಧಾರ ಮತ್ತು ಹಣಕಾಸು ಸ್ಥಾಯಿ ಸಂಸ್ಥೆ ಸದರಿ ವಿಷಯವನ್ನು ವರ್ಗಾಯಿಸಲು ತೀರ್ಮಾನಿಸಲಾಗಿರುತ್ತದೆ. ಸದರಿ ವಿಷಯದ ಬಗ್ಗೆ ಸಭೆಯ ವಿಸ್ತೃತವಾಗಿ ಚರ್ಚೆ ನಡೆದು ಈ ಹಿಂದೆ ನಗರಸಭೆ ಅಸ್ತಿತ್ವದಲ್ಲಿದ್ದಾಗ ವಿಧಿಸಿದ ಜಾಹೀರಾತು ಶುಲ್ಕದ ದರಕ್ಕೆ 100% ಹೆಚ್ಚಿಸಿ 3 ವರ್ಷಗಳ ಅವಧಿಗೆ ನಿಗದಿಪಡಿಸಲು ಮತ್ತು ಸದರಿ ದರವನ್ನು ಪ್ರತಿ 3 ವರ್ಷಕ್ಕೆ ಪರಿಷ್ಕರಿಸಲು ಸರ್ವಾನುಮತದಿಂದ ತೀರ್ಮಾನಿಸಲಾಯಿತು. ಹಾಲಿ ನಿಗದಿಪಡಿಸಿದ ದರವನ್ನು ಪಾವತಿಸಿಕೊಂಡು ಜಾಹೀರಾತು ಫಲಕಕ್ಕೆ ಅನುಮತಿ ನೀಡಲು ಸರ್ವಾನುಮತದಲ್ಲಿ ತೀರ್ಮಾನಿಸಲಾಯಿತು. This is the resolution, your lordship. It was the financial committee, your lordship. Despite this resolution, your lordship, the corporation demanded, your lordship, the
100% more than last.
Yes, that has been challenged, your lordship. Demanded made by the, though it is such resolution is there, your lordship.
You are challenging even the 100%. You are challenging even the 100%.
Yes, your lordship.
ಕಮ್ಮಿ ಮಾಡಿದ್ಮೇಲೆ ಅದನ್ನು ಚಾರ್ಜ್ ಮಾಡ್ಬೇಕು.
ಅಲ್ಲ, 100% ಅಂತಲ್ಲ. ಈಗ ಡಿಮಾಂಡ್ ನೋಟಿಸ್ ಅದಲ್ಲ.
ಡಿಮ್ಯಾಂಡ್ ನೋಟಿಸ್
100% ಇದಕ್ಕೆ ಮುನ್ಸಿಪಾಲಿಟಿ ಇರುವಾಗ ಏನ್ ಕೊಟ್ಟಿದ್ರು ಅದನ್ನ 100% ಮಾಡಿ 3 ವರ್ಷ ಮಾಡೋಣ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು. ಈಗ ಇವ್ರು ಕೊಡ್ತಾ ಡಿಮಾಂಡ್ ನೋಟಿಸ್ ಮಾಡ್ತಾ ಇರೋದು ಕಾರ್ಪೊರೇಷನ್ ಆದ್ಮೇಲೆ 100% ಶೆಡ್ಯೂಲ್ 8 ಪ್ರಕಾರ ಏನ್ ಅನೌನ್ಸ್ ಮಾಡಿದ್ರು ಅದನ್ನ ಕೇಳ್ತಾ ಇದ್ದಾರೆ.
Though it has been
yes, that is what we are challenged.
Demand is as per the earlier resolution.
Yes, corporation resolution. Annexure C.
Item number 28.
Yes, item number 28.
What happened to this resolution? This is a resolution of the finance committee, na? ಹಣಕಾಸು ಹಾಗೂ ಅಪೀಲುಗಳಿಗಾಗಿ ಸಾಯಿತು. This is a standing committee resolution.
Standing committee for appeal and standing committee.
So standing committee resolution was placed before the corporation.
That corporation has to corporation ಗೊತ್ತಿಲ್ಲ ಅದು ನನಗೆ. I have no lordship because now my submission only shows this is a resolution has been passed now. So those such resolutions are there, lordship, demanding your lordship. Subsequently, your lordship, in 2017-18, your lordship is aware that the GST ಬಂತು, ಅದು 101 amendment to ಅದು separate issue.
This is all for which year?
This is all for your lordship
2015 to 17.
Yes. Yes. Prior to that.
So your contention is that the standing committee resolution will override the
overruled and it was not considered while issuing such notices on demand notice.
Yes, Mr. Gangadhar.
I will have to get the clarification with regard to this aspect of the matter. Kindly call this matter next week.
That counsel for respond number 1, 2, 3 seeks for and is granted 10 days time to obtain instruction as to how respond number 2 and 3 could have caused a demand on the petitioner in terms of resolution dated 23/2015, when the standing committee by its resolution dated 7/8/2015 had recommended only an increase of 100% over the existing tax payable by the petitioner, by advertisers for a period of 3 years. Released on 16th February.
Grateful.
Serial number 20 adjourned. Serial number 21. P. Vinod Reddy.
So Vinod Reddy. Despite the order dated 7/1/26, none appears for the petitioner today also. Appears as not interested, dismissed.
22. Zamir Pasha.
The petitioner seeks to withdraw the petition.
Petitioner is before this court, memo dismissed as withdrawn.
23. V.V. Gunjan.
Petitioner says ಸರಿಯಾಗಿ ಬರ್ತಾರೆ.
Alternative jurisdiction. Alternative ಇದೆ, only notice issue ಆಗಿದೆ. Notice
Alternative
ಇದೆ.
jurisdiction ಇದೆ.
Annexure A. Government property.
We can't consider on merits in his absence. Sri M.S. Devraj has appeared, so and so. None appears for the petitioner. If none were to appear, dismissal for non-prosecution, released under the caption dismissal for non-prosecution on 18th.
My lord,
yes,
it may be passed over. I am representing the counsel for petitioner. I got to know now. He is there in quota 11.
Pass.
Next week. Next week.
Objections ಹಾಕಿದ್ದೀರಾ?
Objections ಹಾಕಿಲ್ಲ.
ಹಾಕ್ಬೇಕಾ ಇದಕ್ಕೆ?
ಏನ್ ಬೇಕಾಗಿಲ್ಲ. ಆಲ್ಟರ್ನೇಟಿವ್ ಜುರಿಸ್ಡಿಕ್ಷನ್ ಒಂದು, ಎರಡನೇದಾಗಿ ಅನೆಕ್ಷರಿ ನೋಟಿಸ್ ಅದು ನೋಟಿಸ್
ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಅವ್ರು ಬಂದಾಗ ಇವತ್ತೇ ಮುಗಿಸೋಣ. ಪಾಸ್.
24. H.M. Kishore Kumar.
For the petitioner 24.1, my lord.
My lord, the impugned notification communication is at annexure H.
There is petitioner in 24. So Pawan Kumar. Paso, you are ready?
Yes, madam.
Paso.
Obliged.
25. Harish Kumar.
Respondents.
Yes.
My lord, the petitioner is running a poultry farm, my lord. And kindly see the page number 14, my lord, annexure B, my lord.
D. Page
number 14, my lord.
Annexure B.
Yes, madam.
Yes.
ರಾಮವಳ್ಳಿ ವಿದ್ಯುತ್ ಸಂಪರ್ಕವನ್ನು ಕಡಿತಗೊಳಿಸುವ ಬಗ್ಗೆ ಕರ್ನಾಟಕ ರಾಜ್ಯ ಮಾಲಿನ್ಯ ನಿಯಂತ್ರಣ ಮಂಡಳಿ ಪತ್ರ ದಿನಾಂಕ 4/4/2017 ಈ ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಬೆಂಗಳೂರು ದಕ್ಷಿಣ ತಾಲೂಕು ಕೆಂಗೇರಿ ಹೋಬಳಿ ರಾಮವಳ್ಳಿ ಗ್ರಾಮ ಪಂಚಾಯತ್ ವ್ಯಾಪ್ತಿಯ ಭೀಮನಕುಪ್ಪೆ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 116ರಲ್ಲಿರುವ ತಾ ಹೆಚರಿ ಸರಿಸಿರುವ ಅನಧಿಕೃತ ಕೋಳಿ ಫಾರಂ ನಡೆಸಿದ್ದು ಸುತ್ತಮುತ್ತ ಜನ ವಸತಿ ಪ್ರದೇಶ ಹತ್ತಿರವಿರುವ ಶಾಲಾ ಮಕ್ಕಳಿಗೆ ತಮ್ಮ ಫಾರಂನಿಂದ ದುರ್ನಾತ ಬೀರುತ್ತಿದ್ದು ಅನೇಕ ಸಾಂಕ್ರಾಮಿಕ ರೋಗಗಳನ್ನು ಹರಡುವಲ್ಲಿ ಕಾರಣವಾಗಿರುತ್ತದೆ ಸಾರ್ವಜನಿಕ ದೂರು ಬಂದಿದ್ದು ಕರ್ನಾಟಕ ಪರಿಸರ ಮಂಡಳಿಯವರ ಖುದ್ದು ಪರಿಶೀಲನೆ ಕರ್ನಾಟಕ ಪಂಚಾಯತ್ ರಾಜ್ ಕಾಯ್ದೆ ಸೋನ್ಸೋ ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ಸಹ ಲಿಖಿತವಾಗಿ ಸೂಚಿಸುತ್ತಾರೆ. ಇದರನ್ವಯ ದಿನಾಂಕ 28/2017ರಲ್ಲಿ ನಡೆದ ಪಂಚಾಯಿತಿ ಸಾಮಾನ್ಯ ಸಭೆಯಲ್ಲಿ ಸದರಿ ವಿಷಯವನ್ನು ಗಂಭೀರವಾಗಿ ಚರ್ಚಿಸಿ ಸಂಬಂಧಪಟ್ಟ ಕೋಳಿ ಫಾರಂಗೆ ನೀಡಿರುವ ವಿದ್ಯುತ್ ಸಂಪರ್ಕವನ್ನು ಕಡಿತಗೊಳಿಸಲು ಪತ್ರ ವ್ಯವಹಾರವನ್ನು ಕೊಡುವಂತೆ ಸಭೆಯಲ್ಲಿ ಸರ್ವಾನುಮತದಿಂದ ನಿರ್ಣಯ ಕೈಗೊಳ್ಳಲಾಯಿತು. ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಸದರಿ ಕೋಳಿ ಫಾರಂಗೆ ತಮ್ಮ ಇಲಾಖೆ ನೀಡಿರುವ ವಿದ್ಯುತ್ ಸಂಪರ್ಕವನ್ನು ಕಡಿತಗೊಳಿಸಲು ತಮ್ಮನ್ನು ಕೋರಲಾಗಿದೆ. Then my lord, on the basis of this, my lord, the annexure C, my lord, next page, my lord. A typed copy is also there. Then my lord, ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ page number 16.
ವಿದ್ಯುತ್ ಸರಬರಾಜು ಅದು ಪಂಚಾಯತ್. Yes.
Yes. Then approach is honorable court.
ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ
without any spot infection and without any.
My lord, this is a case wherein, my lord, the petitioner is compelled to obtain the no objection certificate from the Pollution Control Board to start the poultry farm. as per section 25-26 of the Water Prevention and Control Pollution Act 1974, as well as under section 21, without obtaining the same, they cannot run the poultry farm. That's what the act says, and they are the competent authority to issue permission, my lord. Based on their letter,
You
they have
have not
taken
made
action.
the pollution control board a party.
Or a party madilla, they are necessary parties, my lord.
No, but it is agricultural activity, madam, poultry farm is produced.
Agriculture activity, if there is some requirement to be taken.
No, madam. Producer.
If it is in the pollution control act and
Within 500 meters from the
CFE
residential zone.
ತಗೊಂಡ್ಬೇಕು.
That is a agriculture field only it is running, my lord. It now it is I will produce a judgment.
Then if the CFE is required under the Water Act, you have to challenge that act. If you succeed, then you can make that submission. Otherwise, the requirement is there under law. Mr. Pollution Control Board and party ಮಾಡಿ, then we'll have to get them to say what is the provision that they are applying. Without making them a party, they are saying Pollution Control Board permission. Counsel for the petitioner. But now being of the considered opinion that the Pollution Control Board is required to be made a party to these proceedings, the Karnataka State Pollution Control Board, represented by its member secretary, is brought on record as respondent number 5. Shri Gurraj Joshi, learned counsel, is directed to, standing counsel is directed to accept notice for respondent number 5. Counsel for the petitioner to furnish 2 sets of the petition along with annexures on the said counsel, which shall be so done by end of day, 2nd February 2026. Shri Gurraj Joshi is granted 2 weeks' time to obtain instruction, make a submission as to the applicability of the Water Act, Water and Air Act.
And air, both, man.
Water Act so and so and Air Act so and so to the activity of running a poultry farm, to place on record the necessary circulars, notification or the like applicable for establishment and operation of a poultry farm. Released on 18th February.
Interim order.
Interim order earlier granted is extended till next date of hearing.
Serial number 26. C. Vijay Kumar.
I appear for the second response. ಇಲ್ಲ
ಬರಲ್ಲ ಅಂತೀರ?
ಅದು ಸರ್ವೈವ್ ಆಗೋದು ಇಲ್ಲ ನನ್ನ ಪ್ರಕಾರ.
ಇದಕ್ಕೆ ಬರ್ತಾ ಇಲ್ಲ. ಇದ ಏನು ಬರ್ಕೊಂಡೇ ಇಲ್ಲ ಇಲ್ಲಿ.
We had not informed the respondent, my lordship, so adjournment was not.
At the request of counsel for the petitioner, released on 16th February. If arguments are not advanced on that date, petition will be liable to be dismissed for non-further execution. Submission of learned counsel for respond number 2 that the above petition does not survive for consideration is placed on record. Why doesn't it survive?
No, because my lord, the petitioner claims right on the basis of an order passed in favor of his brother. That order has been set aside in the connected petition.
On account does not survive consideration on account of the fact that the order relied upon by the petitioner has been set aside
in WP number 13513/2018.
Released on 16th.
Please.
27. Subramanya.
Appearing for the petitioner in this matter. In this matter, my lord, in the last occasion, your lordship have directed to instructions whether the sanction plan and building license has been issued or not. But,
No.
I have tried hard to communicate to the petitioners, my lord. I have written a letter, but the letter did not reach as well, my lord. Therefore, I have no instructions whether the plan has been sanctioned or not.
My lord,
Or
every
to
time there
prosecute
is an
the
excuse.
petitioner.
Every time they are seeking
Some reason.
some excuse, my lord. Matter is urgent. I moved the court so many times, my lord. Finally, it has reached today. It has to be heard, my lord, today. Last time he said he has some more documents. My lord, the matter is very simple. I am given permission
You
to
claim
construct.
that you have a plan.
Lord, yes, I have
We
a
produced the
valid permission to construct Prarthana Mandira in my land.
Have you produced it?
Yes, my lord.
Yes.
Everything
it's
is,
been
he
produced
himself
already.
has produced.
What do you want? What instructions do you want?
27.
When did you file it, madam? When did you produce your plan?
Vacating the stay, my lord, on 9/9/25. From that time it is,
9/9/25.
yes,
ಅಲ್ಲೇನಾರು ಇದೆಯಾ?
IF for
Case number
20888.
ಯಾವ ಮ್ಯಾಟರ್ ಮೇಡಮ್?
ಯಾವ list?
List one.
49015 ಇದು.
49015.
Am I wrong?
Yes, it appears so. 49015.
27 is the
I'm
serial
appearing
number.
for the petitioner in this matter.
27 alla?
Saturday listed.
Ayyo, sorry. It was listed on Saturday, it seems. I'm sorry, because I did not see the date. Sorry.
List number, date of the list, ella we are issuing list 1 week in advance so that you can get prepared.
I have no instructions in that respect, my lord.
Ian, what are you planning to do then?
Maybe disposed of with a liberty, whether they are approaching.
Disposed of on merits. If you don't argue, we can't pass orders. So we can at the most dismiss it for non-prosecution. If you argue, we can pass orders on merits.
Please.
Where's Pawan?
The respondent counsel, my lord, they have submitted that on the last occasion that the sanction has been issued. That they have to clarify, my lord, because the petitioner is not reachable, my lord, in my hands.
Pass over. Let us, if he has issued the plan and if he gets that confirmation, then nothing survives in this.
Please.
Serial number 28. K. Rambert and connected matter.
Mr. Rambert,
ನೀವು
Mr. Siddhartha, ಇದರ VCL ಇದ್ದಾರೆ. ಇಬ್ರೇನಾ? You are appearing for whom, madam?
R3 in WP
R3.
53813.
So S. Mahesh had appeared, is it? Again,
No,
you will
Your
continue
Lordship.
to appear?
No, Your Lordship, those are the connected matters in which we had given NOC Wakalat. This one also, I mean, they have asked us to give a NOC Wakalat, but due to the death of Mahesh sir, nothing has been done.
Who will appear in the matter now?
The TMC hasn't.
Even I made a call to them. They told that we will engage the council. So far, it is
Not done.
Avana GK retirement memo. S. Mahesh NOC. S. Mahesh ಇವಾಗ ಇದಾಗಿದೆ. You came just in time. Who will be appearing?
The TMC hasn't taken any decision on it yet, Your Lord.
Yeah, who is respondent number 7?
Respondent number 3, Commissioner.
In connected matters, respondent number 7 is TMC.
Who is respondent number 3? Who are you appearing?
Commissioner City Municipal.
CMC Chalkare.
Chalkare.
ಇದು ಯಾರು ಇದಾರ? ಯಾರಿಲ್ಲ. 28.1. Since Sri S. Mahesh had entered appearance for respondent number 7, memo of retirement filed by Ms. G.K. Bhavana is accepted. She is discharged from the matter. Registry is directed to. Since Sri S. Mahesh had entered appearance for respondent number 7, the memo of retirement filed by Ms. G.K. Bhavana is accepted. She is discharged from the matter. Registry is direct delete her name as that appearing for respondent number 7. Same order in 28.2. 28.3. 28.5, 28.6, 28.8, 28.9, 28.13. It is informed that Sri S. Mahesh has expired. Learned AGA had been asked to contact respondent number 7. His submission is that respondent number 7 is informed that a new counsel will be appointed In that view of the matter, released on 17th February.
Again, I will make a call.
Registrar Judicial is directed to forward a email of the above order to respond number 7. Forward the above order by email to respond number 7.
Serial number 29.
Petitioner.
I am appearing for R2A.
Impugned order is, my lord, suspension of trade license issued, my lord, in favor of the petitioners for the year two.
Suspension?
Yes, my lord. Then, my lord, presently, my lord, they have issued a fresh license, my lord, for the year 2025-26. Therefore, my lord.
Regular license is issued, my lord. Hence, it has become infructuous, my lord.
Petitioner is before this court seeking for the following relief. File a memo.
Please.
Memo has been filed which reads as under accepting the memo, petition is dismissed as infructuous.
30. Subramanya.
For petitioner in this matter. More matter, my lord. One more similar matter has to be listed along with the last time also.
Number for
Please.
For the authority.
You have filed your objections?
No, man. We will file, but on the previous occasion, we have taken an objection that this matter should be referred through the revisional authority under 322. That's an order passed under 180. There's an alternate and efficacious remedy as per many judgments.
You don't want to file your objection, you want to address arguments. So one more matter. Yavadappa, WP number?
WP number 1983 of 2019.
So learned counsel for respondent submit that it does not wish to file any statement.
We will file our objections.
Want to file?
We'll file.
Seeks fund is granted 10 days time.
10 days.
You will be drafting.
Please do. I will do.
Everything.
I will do.
Don't ask your senior to do.
Please, ma'am.
Seeks fund is granted 10 days time to file a statement of objection. Objections, if any, by 13th February, released on 17th February.
Interim order, my lord.
Interim order earlier granted is extended till next.
And may I make a submission, my lord? In serial number 27, my lord. Could it be on any other day, my lord? I have to be ready, my lord.
27.
27, it has been passed over.
You will get ready.
Please, ma'am.
New argument, madam.
Please, ma'am. Any other day.
So this plan is not.
Plan has been sanctioned?
Because objections here, plan is not sanctioned because there is no layout plan approval, my lords.
There is no plan signed. Then the petition
has to be heard.
On the last occasion,
That to be heard.
it has been submitted.
27, learned counsel for respond number 1 and 2 submits that no plan has been sanctioned. In that way of the matter, the petition is required to be heard. Counsel for the petitioner seeks fund is granted 10 days time. Necessarily.
Nagraj.
Sri Nagraj seeks for 10 days time to get ready and address his arguments. Released on 17th February.
17th.
Written submission ಎಲ್ಲ ಮಾಡಿ ನೀಟಾಗೆ
Please.
ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಎಲ್ಲ ಕಂಪೈಲ್ ಮಾಡ್ಕೊಂಡು ತಗೊಂಡ್ ಬನ್ನಿ.
Serial number 31. Nitin Prasad.
My lord, for the petitioner, on the last date of hearing, my lord, I was to serve some copies on Mr. Devaraju, my lord. I have not yet done that. Maybe listed next week.
You still not served him.
I'll serve today or tomorrow, my lord.
Counsel for the petitioner undertakes to serve 2 sets of the petition along with annexures on Shri M.S. Devaraj by end of day 2nd February. Shri M.S. Devaraj is granted 2 weeks time thereafter to obtain instruction, make his submission, released on 18th February.
Can it be 19th, my lord?
19th February.
How much about?
Serial number 32 dismissed. 33. P. Ravindra Prasad.
Rama Ravindra Prasad.
Advertisements have been made for.
Krishna, you are appearing? Krishna.
8/1/2026.
8/1/26. Order would be passed on the reply submitted by within a period of 3 weeks. Yes, Mr. Krishna.
My lord, the order ಆಗಿಲ್ಲ. The reason being, my lord, I am told by the
AEO of Chamarajpet is that he is no more the authority for it. As per the new JBA, my lord, adella change agibitide. Therefore, he can't pass order. That's what he says. And may I request for 2 more weeks time, my lord, to get confirmation regarding who is the authority, and I will instruct him to pass orders immediately.
Whoever is the concerned authority, ask them to pass orders. Otherwise, it will be just being adjourned.
Yes.
Learned counsel for Shri B.V. Krishna, learned counsel for respondent number 1 and 2 submits that the respondent number 2 is no longer the concerned authority to pass orders in view of the reconstitution of the Greater Bangalore Authority. He submits that given 2 more weeks, the concerned and appropriate authority would consider the representation of the petitioner and reply of the petitioner and pass necessary orders. Released on 18th February.
Much okay.
35.
IPF for respondent 3 and 4, madam. 10 days time may be granted for filing objections, madam.
None appears for the petitioner. Counsel for respondent number 3 and 4 seeks to and is granted 10 days time finally to file her objections. Objections, if any, by 13th, failing which will be taken as not filed, matter proceeded with. Released on 17th February.
36. PS Raghu Prasad.
For the respondent number 3, my lord, case PCB.
My lord, in this matter, my lord, the petitioner seems to have closed his shop and is gone. I've sent a letter, I even produced the letter copy to the court, which has not been put up, my lord. If that is confirmed, the suit shall become infringed.
Number of retirement.
Because in the retirement, it is clearly shown that no such person and the shop is closed, my lord.
Petitioner is before this court seeking for the following. A memo of retirement has been filed enclosing the notice issued by the counsel for the petition dated 14/1/2025 along with the returned postal cover. The returned postal cover bears the endorsement that there is no such person at the address indicated. In that view of the matter, the memo of retirement is accepted. Shri Raghu Prasad BS is discharged from the case. Since the notice issued by the respondent, by the counsel itself has returned with the endorsement no such person, there would be no purpose in issuing a court notice to the petitioner. As such, the petition is dismissed for non-prosecution.
It's actually infructuous as well, my lord.
Since they have vacated the shop.
They have vacated the premises itself.
The submission of learned counsel for respondent number 1 and 2 that the petitioner has vacated the shop is placed on record.
Respondent number 3, my lord.
Respondent number 3.
Whose submission?
Pollution control board.
No, whose submission do we record? Your submission or his?
My submission, my lord. He is my colleague.
Yes. Your colleague. Respondent number 3 that the petitioner has vacated the subject property is placed on record.
Much. 37.
For the petitioner, my lord.
For R1, my lord.
In this matter, my lord, the petitioner is the owner of land bearing survey number 1/2, measuring 1 acre.
You're for the petitioner?
Petitioner.
You're for
R1, sir.
Who is the contesting respondent?
They are seeking the not to form the road, my lord.
Not to form the road.
The respondent number 1, my lord, without due process of law, without any acquisition proceedings, have formed a road in the property, in the southern portion of the property belonging to the
Already
petitioner.
formed the road.
They have formed the road and
In your land.
Yes, my lord, please. Without any due process of law, without any acquisition proceedings, without any resolution passed by the panchayat, the respondent number 1, with the aid of the respondent number 2, who is the inspector of police, they formed a road in the southern portion of the property belonging to the petitioner. Approximately 9 guntas of land had been illegally trespassed into, and a road has been formed. The present scenario, my lord, is the respondent number 3 is a private party who is a local developer. She has impleaded herself in the writ petition. The respondent number 3 and the petitioner.
You appear for respondent number 1.
1.
Respondent number 3 is not here.
Respondent number 3 and the petitioner share a common boundary. Present scenario is the respondent number 3 herself has put up a compound wall. and one side of the road has been closed, my lord. And on the other portion of the road, I have put up a compound wall and I have closed the road.
Very good. So both of you will have to be proceeded against for, how can you close it? You want to take the law into your hands?
No, my lord.
We'll first direct them to take action against you doing these things. Then we'll decide your matter. Even if when you are before this court, how do you close the road?
My lord, the road is not being used for any public purpose.
How do you close it by putting up a compound wall?
There was no road at all, my lord. Kindly see annexure.
You yourself have made your submission now, Mr. Counsel.
Kindly
That
see
there was a
annexure
road
D.
formed illegally.
Illegally
or otherwise, you cannot put up a compound wall on it. How do you put up a compound wall? You do for illegality, you also do illegality. Yes.
My lord, the allegation of the petitioner is that on 24 January 2019, both respondent 1 and 2 came near his property, destroyed the sheds used for agricultural purpose is totally false, my lord. Actually, road was already in existence on the southern side of the property much before filing of this petition, my lord.
What document have you produced?
Yes, yeah, one minute. So the petitioner, what he has done, he has concealed the fact that there is already an existing road with drainage and street lights used for the general public, and he has filed a false case. My lord, I would like to draw your attention to annexure R1, page number 6 of the statement of objections.
R1. Yes.
Yes, my lord, this R1, what is this R1? This R1 is a survey sketch prepared at the time when the surrounding owners of the property applied for conversion. Okay, so this survey sketch clearly shows the existence of the road on the southern side of the property. So this was prepared by the survey officer, vouched by the Tashildar, and bears the seal of the DC. Secondly, my lord, the earlier PDO issued an attestation certificate way back in 2014, where he clearly says that there was already an existing road with street lights and drainage facility. My lord, kindly see R2, Dhrudi Patra. My lord, it is dated 30/5/2014.
Yes.
This petition in 2019. Okay, Dhrudi Patra. Bengaluru Purva Taluku, Vartur Hobli, ಹಾಲನಾಯಕನಹಳ್ಳಿ ಗ್ರಾಮ ಪಂಚಾಯಿತಿ ವ್ಯಾಪ್ತಿಗೆ ಸೇರಿದ ಚಿಕ್ಕನಾಯಕನಹಳ್ಳಿ ಗ್ರಾಮದಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 1/1 ಜಾಮೀನಿಗೆ ಸರ್ವೆ ನಂಬರ್ 2 ಮತ್ತು 3 ಜಾಮೀನಿನಲ್ಲಿ ರಸ್ತೆ ಹಾದು ಹೋಗಿದ್ದು ಸುಮಾರು ವರ್ಷಗಳಿಂದ ಈ ರಸ್ತೆಯನ್ನು ಸಾರ್ವಜನಿಕರು ಉಪಯೋಗಿಸಿರುತ್ತಾರೆ ಮತ್ತು ಈ ರಸ್ತೆಯಲ್ಲಿ ಬೀದಿ ದೀಪಗಳೂ ಸಹ ಇರುತ್ತವೆಂದು ಈ ಮೂಲಕ ದೃಢೀಕರಿಸಲಾಗಿದೆ. Nextly, my lord, I also humbly submit that respondent number 1 also obtained a satellite photo from a government app called Dishank. Okay, in this photo, I would like to draw attention to R3. In this photo also, it is clearly visible that there is an existing road.
What is the orientation of this map? Which is north?
My lord, this is a
North
government
is below.
mobile app, Dishank.
Well, north is below you. You marked it here.
R3, my lord.
Yes.
Okay.
Southern side, there's a road.
So then what is the dispute? Then what is the problem? The problem is, it is the petitioner who has set up illegal constructions in the middle of the road. It is the petitioner who has blocked the drainage. It is the petitioner who has not obtained any permission and has set up illegal constructions. So this is the issue. Now what did R1 do? R1 did what a responsible officer would do. He lodged 3 complaints before the jurisdictional police, my lord, reporting illegal construction, blocking the road, and setting up and giving incontinence. I would like to draw your attention to R4, my lord.
Yes.
R4, page number 9. Okay, Vishaya. ಹಾಲನಾಯಕನಹಳ್ಳಿ ಗ್ರಾಮ ಪಂಚಾಯಿತಿ ವ್ಯಾಪ್ತಿಯ ಚಿಕ್ಕನಾಯಕನಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ಕಾರಿ ರಸ್ತೆಯನ್ನು ಒತ್ತುವರಿ ಮಾಡಿ ಕಟ್ಟಡ ನಿರ್ಮಿಸಿರುವುದರ ಬಗ್ಗೆ ದೂರು. ಹಾಲನಾಯಕನಹಳ್ಳಿ ಗ್ರಾಮ ಪಂಚಾಯಿತಿ ವ್ಯಾಪ್ತಿಯ ಚಿಕ್ಕನಾಯಕನಹಳ್ಳಿ ಗ್ರಾಮದ ವಾಸಿಯಾದ ಶ್ರೀ ಬಾಬುರೆಡ್ಡಿ ಬಿನ್ ಗುರು ಲಿಂಗೇರೆಡ್ಡಿ ಆದ ಇವರು ಚಿಕ್ಕನಾಯಕನಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ಕಾರಿ ರಸ್ತೆಯ ಎರಡೂ ಬದಿ ಇರುವ ಚಪ್ಪಡಿ ಮೋರಿಯನ್ನು ಮಣ್ಣಿನಿಂದ ಮುಚ್ಚಿ ಹಾಗೂ ಸರ್ಕಾರಿ ರಸ್ತೆಯಲ್ಲಿ ಅನಧಿಕೃತವಾಗಿ ಕಟ್ಟಡದ ಕೆಲಸವನ್ನು ಪ್ರಾರಂಭ ಮಾಡಿರುತ್ತಾರೆ. ಇದರಿಂದ ಸಾರ್ವಜನಿಕರಿಗೆ ಓಡಾಡಲು ತುಂಬಾ ತೊಂದರೆಯಾಗುತ್ತದೆ. ಆದ್ದರಿಂದ ತಾವು ಕೂಡಲೇ ಕಾನೂನು ರೀತಿ ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ಕೋರುತ್ತೇನೆ. ನೆಕ್ಸ್ಟ್ ಮೈ ಲಾರ್ಡ್ R5 ವಿಷಯ ಸರ್ಕಾರಿ ಸ್ವತ್ತನ್ನು ಹಾಳು ಮಾಡಿ ಸದರಿ ಸ್ಥಳದ ಅತಿಕ್ರಮವಾಗಿ ಕಟ್ಟಡ ನಿರ್ಮಾಣ ಮಾಡಿ ಸಾರ್ವಜನಿಕರಿಗೆ ತೊಂದರೆ ಉಂಟು ಮಾಡಿರುವ ಚಿಕ್ಕನಾಯಕನಹಳ್ಳಿ ವಾಸಿ ಬಾಬುರೆಡ್ಡಿ ಬಿನ್ ಗುರುಲಿಂಗೇರೆಡ್ಡಿರವರ ವಿರುದ್ಧ ದೂರು. ಫರ್ದರ್ ಮೈ ಲಾರ್ಡ್ R6 ವಿಷಯ ಸರ್ಕಾರಿ ರಸ್ತೆಯನ್ನು ಹಾಳು ಮಾಡಿ ಎರಡೂ ಬದಿ ಇರುವ ಚಪ್ಪಡಿ ಮೋರಿಯನ್ನು ಮಣ್ಣಿನಿಂದ ಮುಚ್ಚಿ ಹಾಗೂ ಸರ್ಕಾರಿ ರಸ್ತೆಯಲ್ಲಿ ಮಣ್ಣನ್ನು ಹಾಕಿ ಸಾರ್ವಜನಿಕರಿಗೆ ಓಡಾಡಲು ತೊಂದರೆ ಮಾಡುತ್ತಿರುವ ಬಗ್ಗೆ ದೂರು. My lord, I also humbly submit that the police have also registered FIR in CR 21/2019 and the same is marked as annexure R7. Lastly, my lord, kindly I would like to submit the photos taken by the respondent.
Yes.
In these photos, it is visible to anybody that there is street lights, buildings that has been constructed in the middle of the road.
Drainage is also there.
So what is my concluding remarks, my lord, is this is what has happened. The petitioner, without obtaining permission, has set up illegal constructions. He has blocked the drainage and he had made sure that general public.
What happened to that criminal proceeding which had been initiated? What is the status? Crime number?
My lord, that is R2.
Crime number 21 of 2019. What has happened to it?
One second, my lord.
I have to check whether the charge sheet has been filed or not, my lord.
Your complainant alla, complainant ಗೊತ್ತಿಲ್ವಾ ಏನಾಯ್ತು?
My lord, the thing is, it is remaining as it is in the sense that the building constructions were there.
What happened to this crime number?
My lord, will not.
It's 2019, 6 years ಆಯ್ತು.
My lord.
You know what happened to it?
Yes, my lord.
What
I have filed a quashing petition before the High Court and it has been stayed.
And also I'd like to bring your attention, my lord, they have filed a contempt proceeding against respondent number 1. That contempt proceeding is dismissed.
Yes.
It was not on merits, my lord. My lord, I would like to bring to notice of R2. It states that Bengaluru Purva Taluku, Varturu Hobli, Halnaiknalli, Panchayati Vyaptige ಸೇರಿದ ಚಿಕ್ಕನಾಯಕನಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 1/1ರಲ್ಲಿ ಜಮೀನಿಗೆ ಸರ್ವೆ ನಂಬರ್ 2 ಮತ್ತು 3 ಜಮೀನಿನ ರಸ್ತೆ ಹಾದು ಹೋಗಿದೆ. Mine is 1/2, my lord. This is not at all relevant what they have produced. Coming to the Dishank map, my lord, that is at R3. I just pointed out at 2 and 3, this is the private layout formed. A road has been passed, is going here. With respect to 1/1, this is the portion, and this is the 1/2. With respect to this, there is no documents. Whole entire 1 acre is in my name. They have not acquired the land or done anything in as such.
Where is your conversion order?
The land is in agricultural status only. It has not been converted, my lord.
You are not converted.
I have not converted.
So whose affidavit was that there is a road as per your letter?
My lord.
Must be the other person.
My lord.
They have not got their land converted.
Yes.
So what could be the value of this annexure R1?
R2,
This is the survey sketch of the other owners, my lord, like the surrounding owners.
So that is in
They,
their
when
property.
they applied for conversion, this survey has been done.
So it is in their property at the moment.
No, my lord, this road has been used by other owners as well. It's a common road.
Mr. Naresh, if another person has filed an affidavit, it cannot bind the petitioner. It can only bind that person. If he has wrongly shown it, he has wrongly shown it. You will have to show us that how did this, apart from that affidavit of that person, a private affidavit, how did it become a road? Do you have any document of respond number 2 in your office indicating that this is a public property, this vest with respond number 2? You acquired the land or it has already vested with you? You can't rely on affidavit of a private party. And on that basis, when they form a layout, you can't be taking their property.
My lord, no attempt to form a layout has been made. Earlier, there was street lights.
There's a layout which has been formed in design, as per your Disank map, by respond number 3, who you appear to be colluding with.
Yes, my lord.
Right now, we'll say appear. When we write the order, it may be different.
My lord,
have any that would depend on whether you will place any other document apart from the affidavit of respond number 3, indicating that this road is a public road. You don't have any document.
No, no, my lord. The earlier attestation certificate was there.
That is of respond number 3.
Okay.
So your officers are colluding with respond number 3.
No, Lord. Well,
And we're doing very nice argument, but factually no base.
Kindly come at annexure G, my lord.
Annexure G.
Page number 31. Which shows that in survey number 2 and 3, a road has gone. With respect to survey number 1, no road is there. Village map, my lord. This proves that there was no road at any point of time.
Third. Petitioner is before this court seeking for the following leaves. The petitioner claims to be the owner of the land in survey number 1/2, measuring 1 acre, situated at Chiknayakanalli village, Vartur Robli, Bangalore East Taluk, Bengaluru. The said land was earlier measuring 3 acres 30 guntas, which came to be divided in a partition among the brothers. The petitioner being allotted 1 acre on the southern portion of the said survey number, in person of which a mutation was entered into in MR number 38 of 2004 on 21/2/2005. As things stood thus, respondents number 1 and 2 sought to form a road in the property of the petitioner, which was objected to by the petitioner, contending that there is no such road in existence in the property of the petitioner. And in that regard, the village map was also furnished to indicate that in the property of the petitioner, there is no road which is situated. Despite the said objection having been raised, the respondents sought to persist with the formation of the road. And in that background, the petitioner has approached this court seeking for aforesaid relief. The submission of learned counsel for the petitioner, by relying on the village map, is that there is no road which is in existence in survey number 1 in its entirety. Hence, the question of any road being in existence in the land of the petitioner at survey number 1/2 would not arise. The submission is that it is at the behest of respond number 3, who had subsequently been implemented, who had formed a layout
Not the police.
on the southern side of the land of the petitioner, that a road has been sought to be formed to provide access to the layout formed by respond number 3. And it's in that background that a serious allegation is made that respond number 1 and 2 are colluding with respond number 3 to usurp the land of the petitioner. Learned counsel for respond number 1 would submit that there is a road which is in existence on the southern side of the property of the petitioner, and in that regard he relies upon a survey sketch which has been produced at annexure R1, which has been so drawn on the basis of the affidavit which had been filed by respond number 3 for the purpose of conversion of the land belonging to respond number 3 from agriculture to non-agriculture residential purposes. The said sketch showing the existence of the road, he submits that there is a road which is in existence. The petitioner cannot claim otherwise. He also relies upon a declaration made by the Panchayati Development Officer on 30/5/2014 stating that there is a road forming access to the land in survey number 1/1 through survey number 2 and 3, and as such the petitioner cannot contend otherwise. Reference is also made to the satellite map from Dishank as also photographs to indicate that there is a road in existence on the southern side of the property of the petitioner. His submission is that this road has been sought to be obstructed by the petitioner. Complaints have also been filed by the Panchayat Development Officer and certain others, on which basis an FIR in crime number 21 of 2019 has been registered by the Bellandur police station. On all the above bases, he submits that the existence of the road cannot be disputed. The petitioners are seeking to obstruct the existing road, as regards which respondent number 1 and 2 have sought to take action. None appears for respondent number 3. Heard counsel for the heard Shri Supreet. Yes, Athreya, learned counsel for the petitioner. Shri Naresh N, learned counsel for respondent number 2. Fair use papers. The dispute in the present matter is whether there is an existence of a public road on the southern side of the property of the petitioner. Though the present matter is a writ petition, the documents on record would be sufficient for examination of this issue and rendering a finding in regard thereto without relegating the petitioner to a civil suit. The documents on record clearly and categorically indicate, even according to the counsel for respondent number 1, that there is a road, the document on Advardaki. According to the counsel for respondent number 1, there is a road situated on the southern side of the property of the petitioner by referring to Annexure R1. The said Annexure R1 has been drawn on the basis in order to facilitate the conversion of the land of respondent number 3 from agriculture to non-agricultural residential purposes, and not drawn on the basis of any affidavit which has been submitted by the petitioner. There is a self-serving affidavit and survey sketch created on the basis of the submission stroke affidavit of respondent number 3, which cannot be said to be binding on the petitioner. The declaration which has been given by the Panchayat Development Officer is also sought to be misinterpreted by counsel for respondent number 1 by stating that there is a road to survey number 1/1 through survey number 2 and 3. The land of the petitioner admittedly bearing survey number 1/2, the land in survey number 1/1 is that belonging to respondent number 3.
Yes, madam.
And the road is passing through survey number 2 and 3 and not through survey number 1/2. As such, the contention of the counsel for respondent number 1 that there is a road in existence on the southern side is not established even by the said document. Insofar as the satellite map of Dishank is concerned, this map has been, this photograph has been taken on 6/2/2019, which is after an attempt had been made for formation of a road to show that there is an existence of the road. The said map is not one, the said picture is not one which has been taken at an undisputed point of time. Even the photographs which have been produced by respondent number 1 are ones which have been taken after the road has been formed, which had been objected to by the petitioner. What is required to be seen is that independent documents are to be established, are to be produced by respondent number 1 to establish the existence of a public road to the southern side of the property of the petitioner, since the negative thereto cannot be established by the petitioner. The positive aspect of existence of a road being required to be established by respondent number 1 has not been established by respondent number 1. The facts of the matter which have been stated here and above would indicate that the said road would only, the facts of the matter as indicated and a perusal of the satellite map of Dishank would indicate that the road claimed to be in existence by respondent can only serve a better access to respondent number 3, and it is for that reason apparently that the officers of respondent number 1 have ex facie colluded with respondent number 3 in seeking to deprive the petitioner of his lands. In that view of the matter, I am of the considered opinion that necessary inquiry would have to be conducted by the Principal Secretary, Revenue Department, or an officer designated by him into this issue to ascertain the complicity, if any, of respondent number 1 and his officers with respondent number 3. As such, I pass the following order. Writ petition is allowed. The respondents are restrained from forming any road in the land of the petitioner in survey number 1/2 measuring 1 acre situated at Chicknaiknalli village, Vartur Hubli, Bangalore East Taluk. Learned AGA is directed to communicate the above order to the Principal Secretary, Principal Secretary, Panchayati Raj, Rural Development and Panchayati Raj Department. Inquiry report of the said Principal Secretary to be filed within 4 weeks from today. Registry is directed to print the name of learned AGA in the cause list to enable the filing of the report. Though the above petition is disposed, released on 26th February 2026.
Much obliged.
ಮಾಡೋದಕ್ಕೆ ನಮ್ direction.
AG Badolli inform ಮಾಡಿದೀರಾ? 42 the BK Chandrasekhar, learned counsel for respondent number 5, submits that the petitioner is expired. Petitioner is expired. Counsel for the petitioner seeks for and is granted 2 weeks time. Seeks for and is granted 2 weeks time to take necessary to file necessary application to bring the legal representative of deceased petitioner on record. Released on 23rd February.
I'm highly inconvenienced.
Just a moment. Yenamma? ಏನಾಗಬೇಕಾಗಿತ್ತು? GM mat 25 matter. Kotal number 7. Kotal number 7 ಗೆ ಹೋಗಿ. ನಿಮ್ಗೆ ವಕೀಲರಿಲ್ವಾ? Who wants to do some pro bono work to assist? ನೀವು ಇಲ್ಲಿರ್ಬೇಕು, ನೀವು ಹೋಗಂಗಿಲ್ಲ.
Just case ಒಂದು 10 ನಿಮಿಷ.
Any young junior lawyer? Yes, please guide them, help them out as to what has happened. Find out from the court officer. Yes.
Serial number 41, I'm little highly inconvenienced in the afternoon. Can it be had sometime in the
Have
next
you
week?
informed the respondent counsel?
No, I did
Then
not. I will inform Mr. Deshpande.
Then please don't mention. Yes.
Only
after,
kindly make a mental note.
without informing, no.
Serial
Your
number-
junior can come and say.
Serial number 105, my lord, the petitioner advocate and respondent advocate are present.
105.
105, my lord. Any date?
Present for argument or adjournment?
Adjournment.
Maybe
So-
refer to mediation for.
Refer to mediation. Possibility of settlement is there?
Yes.
ಏನಿದೆ issue ಏನು?
Building violation.
Building violation, both are adjacent to one.
Setback.
105, both the councils submit that if the matter is referred to mediation, there's a possibility of an amicable settlement being arrived at. In that view of the matter is referred to mediation. Since order is passed in the presence of both the councils, the party shall appear before the director, Karnataka Mediation Center at 2:30 PM on 4th February 2026. Released on 25th February 26 to ascertain the progress in the mediation. If the mediation is going on successfully, the file need not be sent back to this court.
My lord, I may be
amended
permitted
plaint,
to amend the cost.
Please amend it.
List 223.
List
Amended
223.
plaint submit ಮಾಡಿದ್ದೇನೆ, my lords. But the pending section was not having the original file. So kindly allow that complaints can be done before 230, my lords. File ಇಲ್ಲೇ ಇದೆ, my lords.
List 2 serial number 23.
23, my lords.
ಎಲ್ಲಿ ಚಂದನ್ ಆರ್ ಅಂತಿದೆ.
25836, my lords. The children case, my lords.
ಅದೆಲ್ಲಪ್ಪ ಅದು. ನಂಬರ್ ಏನು ಸಮ್ ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ. 24.3.
Yes, my lords.
ಏನ್ ಮಾಡ್ಬೇಕು ನೀವು?
ಅದೊಂದು ಕಾಂಪ್ಲೇನ್ಸ್ ಇದೆ, my lords. ಅದು ಒರಿಜಿನಲ್ ಫೈಲ್ ಪೆಂಡಿಂಗ್ ಸೆಕ್ಷನ್ ಅಲ್ಲಿ ಸಿಗ್ಲಿಲ್ಲ, my lords.
ಸಿಗ್ಲಿಲ್ವಾ?
ಸಿಗ್ಲಿಲ್ಲ.
ನಮ್ಮ ಹತ್ರ ಬಂದಿದೆಯೇನಮ್ಮ?
The entire way. Yes, my lords. Complaints.
ಮಾಡ್ಬೋದಾ ಇಲ್ಲಿ ಕಂಪ್ಲೈನ್ಸ್? ಕೊಡ್ತಾರೆ ಮಾಡಿ.
ಅಡ್ಜರ್ನ್ ಅದೇ ಅಡ್ಜರ್ನ್ ಅದು ಯಾವತ್ತಿಗೆ 23/2 ಫಸ್ಟ್ ಧಾರವಾಡ, ಆಮೇಲೆ 230 ಮ್ಯಾಟರ್ಸ್, ಅದಾದ್ಮೇಲೆ ಫಾಸ್ಟ್ ಇಲ್ವಲ್ಲ, ಅದೇ ಲಾಸ್ಟ್ ಕೇಸ್ ಕರ್ದಿದ್ರಲ್ಲಿ, ಅದೇ ಲಾಸ್ಟ್ ಕೇಸ್. ಹೌದು, ಲಿಸ್ಟ್ ಮುಗೀತು, ಲಿಸ್ಟ್ ಹೌದು ಹೌದು. ಫಸ್ಟ್ ಧಾರವಾಡ, ಆಮೇಲೆ 230 ಮ್ಯಾಟರ್ಸ್, ಪಾಸ್ಡ್ ಓವರ್ಸ್ ಕಂಟಿನ್ಯೂ. ಪಾಸ್ ಓವರ್
ಆನ್ ರೆಕಾರ್ಡ್ ಇದೀನಿ ಹಾಕಿ,
ಅದು ಅಷ್ಟೇ. ಬಿಸಿ ಇದೆ ಅಂದ್ರೆ ಇಲ್ಲಿ ಏನಂದ್ರೆ ಈ ಕೋರ್ಟಲ್ಲಿ ಯಾರು ಕೇಸ್ ಕರೆದಾಗ ಆ ಕೇಸ್ ನಾವ್ ಅಲ್ಲಿ ಕ್ಲಿಕ್ ಮಾಡ್ತೀವಿ. 7 ಕೇಸ್ ನಂಬರ್ 7 ಕರೆದ್ರೆ 7 ಅಂತ ಕರೆದಿದ ತಕ್ಷಣ ಅವ್ರು ಕ್ಲಿಕ್ ಮಾಡ್ತಾರೆ, ಅವ್ರು ಜಾಯಿನ್ ಆಗ್ಬೋದು ಅಷ್ಟೇ, ಎಲ್ರು ಒಟ್ಟಿಗೆ ಬರಕ್ಕಾಗಲ್ಲ. ಆ ಕೇಸಲ್ಲಿ ಅಂದ್ರೆ ಇಲ್ಲಿರೋ ಹೆಸರು ಮಾತ್ರ, ಬೇರೆ ಇವಾಗ ನೀವು ಲಾಗಿನ್ ಆಗ್ಬಿಟ್ಟು ಬಂದ್ರೆ ಆಗಲ್ಲ. ನಿಮ್ಮ ಹೆಸರು ಇಲ್ಲ ಅಂತಂದ್ರೆ ಈ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಬರಲ್ಲ, ಆಗಲ್ಲ. ಕೇಳಿಸ್ಕೊಂತಾ ಇರ್ಬೋದು ಅಷ್ಟೇ. ನಾವು ಮಾಡ್ತೀವಿ. ಪರ್ಮಿಟ್ ಅಲ್ಲ, ಅದು ಸೀರಿಯಲ್ ನಂಬರ್ ಹಾಕ್ತಿವಿ. ಅದ್ರಲ್ಲಿ ಎಷ್ಟು ಜನ ಅಡ್ವೊಕೇಟ್ಸ್, ಇವಾಗ ಸಪೋಸ್ ಈ ಕೇಸ್ ಅನ್ಕೊಳ್ಳಿ, ಇವರು ಬರ್ಬೋದು, ಇವರೆಲ್ಲ ಬರ್ಬೋದು. ಅದೇ ಆ ಕೇಸ್ ಕರೆದಿದ ತಕ್ಷಣ ಎಷ್ಟು ಜನ ಇದಾರೆ ಅಷ್ಟು ಜನನು ಬಂದ್ಬಿಡ್ತಾರೆ. ಸೀರಿಯಲ್ ವೈಸ್ ರೀಚ್ ಆದಾಗ, ಹೌದೌದು, ಒಂದೊಂದ್ ದಿನ ಆಗುತ್ತೆ, ಒಂದೊಂದ್ ದಿನ ಆಗಲ್ಲ ಸರ್. 98 ಯಾವತ್ ಹಾಕಿದ್ದು ಹೇಳಿ ಮೆಮೋ, ಅದು ಡೇಟ್ ಹೇಳಿ. 22/1 ಕೇಸ್ ಕರೆಯೋಷ್ಟ್ರಲ್ಲಿ ತರ್ಸ್ಕೊಂತೀನಿ ಸರ್, ಅದು ಪೇಪರು ಕೇಸ್ ಕರೆಯೋಷ್ಟ್ರಲ್ಲಿ ತರ್ಸ್ಕೊಂತೀನಿ. ನೀವು ಮೆಮೋ ಹಾಕಿದ್ರೆ ತರಿಸ್ತೀನಿ. ಯಾವತ್ ಹಾಕಿದ್ದದು ತರಿಸ್ತೀನಿ. ಯಾವ ಲಿಸ್ಟು? 65 ಇದೆ. 88 ಪಾಸ್ ಓವರ್. ಫಸ್ಟ್ ಧಾರವಾಡ ಮ್ಯಾಟರ್ಸ್, ಅದಾದ್ಮೇಲೆ 230 ಮ್ಯಾಟರ್ಸ್, ಅದಾದ್ಮೇಲೆ ಲಿಸ್ಟ್ 1 ಅಲ್ಲಿರೋ 230 ತಗೊಳುತ್ತೆ, ಲಿಸ್ಟ್ 2 ನಲ್ಲಿರೋ 230. ಫಸ್ಟ್ ಲಿಸ್ಟ್ 1, ಆಮೇಲೆ ಲಿಸ್ಟ್ 230 ತಗೊಳುತ್ತೆ ಸರ್ ಅದು. ಅದಕ್ಕೆ ಬಂದ್ಬಿಟ್ಟಿದೆ ಅಲ್ವಾ ಇಲ್ಲಿ, ಅದನ್ನೇ ಹೇಳ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಬೇಡ ಮಾಡೋದ್ ಬೇಡ, ಅದೇ ಇಲ್ಲ, ಅದೇ ರಿಫ್ಲೆಕ್ಟ್ ಆಗ್ಬಿಟ್ಟಿದೆಯಲ್ಲ. ಒಂದೇ ಒಂದು ಹೇಳಿ, ಅದೀಗ ಹೇಳದ್ನಲ್ಲ ಇಷ್ಟೊತ್ತು. ಫಸ್ಟ್ ಧಾರವಾಡ, ಆಮೇಲೆ 230 ಮ್ಯಾಟರ್ಸ್, ಆಮೇಲೆ ಪಾಸ್ಡ್ ಓವರ್ಸ್ ಕಂಟಿನ್ಯೂ ಅಷ್ಟೇ. ಕೇಸ್ ಕರೆಯೋ ಅಷ್ಟ್ರಲ್ಲಿ ತರಿಸ್ತೀನಿ ಸರ್. ಅದು ಗೊತ್ತಿಲ್ಲ ಸರ್, ಕೊಟ್ಟೆ, ಅದೆಲ್ಲ ಮುಗಿಸ್ಬಿಡೋಣ. ಯಾವ್ದು ಹೇಳಿ ಅದು ಫೈಲು? ಅಲ್ಲ ಸೀರಿಯಲ್ ನಂಬರ್ ಹೇಳಿ. ಸೀರಿಯಲ್ 24 ಲಿಸ್ಟ್ 2 ರಲ್ಲಿ 24 ಇದೆ. 24 ಹೌದು. 23/2 ಅವ್ರು 24 ಇನ್ನೊಂದ್ಸತಿ ನೋಡ್ಬಿಡೋಣ. ನೀವಾಗ್ಲೇ ಹೇಳ್ದಾಗ ಮಿಸ್ 20 ಅದರಲ್ಲಿ 0.3 105 ಹಂಗೆ ಬರ್ತಾರೆ ಆದ್ರೆ 105 ಹಾ ಸರ್ ಹೌದು ಒಂದೊಂದ್ ದಿನ ರೀಚೇ ಆಗ್ಬಿಡತ್ತೆ ಫುಲ್. ಫಸ್ಟ್ ಧಾರವಾಡ, ಆಮೇಲೆ 230 ಮ್ಯಾಟರ್ಸ್, ಅದಾದ್ಮೇಲೆ ಫಸ್ಟ್. ಹಾ ಸರ್, ಕಲಬುರ್ಗಿ. ಎಲ್ಲಿ ದೊಡ್ಡದು ಅಲ್ಲ ಅಲ್ಲ, ಅಲ್ಲೆಲ್ಲ ಕೊಟ್ಟರು ಅಂತಿದ್ದಾರೆ. ಕೊಟ್ರ ಅಲ್ಲೇ ಇತ್ತು ಅದು. ಸರ್ ಫಸ್ಟ್ ಧಾರವಾಡ ಒಂದೇ ಒಂದಿದೆ, ಅದಾದ್ಮೇಲೆ 230 ಮ್ಯಾಟರ್ಸ್, ಆಮೇಲೆ ರಿಸರ್ವ್ ಆಗಿದ್ದ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಂತ 24029 of 25. ಯಾನ್ ಚಿನ್ನಪ್ಪ 24029. ಹದಿನೆಂಟೇನೋ ಇದೆ ಉಂಟು. ಆಯ್ತು ತಗೊಂಡು ತಗೋಬಿಡಿ. Dharwad bench matter. Serial number 1, Abhijit, yes.
Please, Milords. Milords, in this matter, Milords, Your Lordship might be, Milords, remembering 6 months time has been given, Milords, for conducting the Milords survey of entire land, Milords.
Yes.
Milords, one thing, Milords, the entire land is, Milords, measuring, Milords, 3,509 acres, Milords. Some portion of the land falls within the jurisdiction of Belgaum, Milords, and some portion of the land falls within the jurisdiction of Uttar Kannada, Milords. Therefore, Milords, a joint survey was held, Milords, but now the notification has to be announced, Milords, by bifurcating the lands which are falling under the Belgaum division and which are falling under the Uttar Kannada district. And moreover, Milords, one problem is that, Milords, Milords, in some of the ROR, the reserve forest name is appearing. Therefore, Milords, we have also requested for disforestation. So, Milords, they sought for, Milords, some more time, but I request, Milords, another 6 months time is required, Milords, to file further report, Milords.
Praveen, 6 months will give, but all those people who are residing there cannot use the land. The problem agate avrige.
Milords, they are using the lands, Milords, but only thing is that, Milords, they are not getting the exact, Milords, the record of right in their favor, Milords.
Record of rights illa, plan illa, construction license illa, enu ilvalla.
Now, Milords, the entire area, Milords, that has been, Milords, boundary has been, Milords, demarcated. Only the district bifurcation has to be done, Milords. That letter also, Milords, I have annexed. That has been forwarded to, Milords, regional commissioner.
We'll extend the time by 6 months, but please instruct your officers to get it done in 6 months because there are thousands of people will be affected by it.
Please, Milords, please, Milords.
Accepting the reasons stated in IA 1 of 25, the time granted for survey wide order date, the time granted wide order dated 28 February 25 is extended by a further period of 6 months. It is hoped and believed that the entire work would be completed by 3rd August, relist on 3rd August.
Please, Milords. Grateful.
230 Moot matter. Naveen JL. 230 matters.
Naveen? Undena matter. First.
230 matters. List number 1, serial number 121. PL Sanjeev.
Srinivas, pass over.
122. Yes, Sudarshan.
Pass over. 123 nimdu. One. Karde illa inna 122 karde.
Yes, Sudarshan.
Sudarshan. Sudarshan ante AGA new file madbekaಗಿದೆ.
121 and 122 both are connected. That we have filed the complaints report.
ಯಾವಾಗ ಫೈಲ್ ಮಾಡಿದ್ರಿ?
Last week, last hearing ಅಲ್ಲಿ file ಮಾಡಿದೀವಿ. And the principal secretary would like to address this issue. And there is an amendment is going, since the session is going on, we will be taken up after 10th, my lord. There we will be.
Principal secretary would like to address the issue andre?
Issue, whatever that we address in the affidavit. And last time, your lordship, remember that we have given a demo in respect of aided and recognition of aided schools. This issue should be taken after 10th, since the session is going on. We have
121, 122.
Yes, my lord.
And AGA.
We have filed the complaints affidavit, but there are some developments also. Last it was listed on 19th or 20th.
It's taken on record.
Well, it was filed in 19-1.
19-1.
Yes, my lord. The status report, Lordship, page number 7. Thereafter, the earlier paragraphs were the directions of this honorable court. 7 onwards. Furthermore, there are some developments, my lord. After 19, there are some more developments. That also will place it on record.
In affidavit.
The only difficulty that we had with respect of the district registrars, where we are unable to get some registration of document because the 2004 earlier documents are not available because the digitalization which took place before that. So some correspondence had happened. That also will place it before Lordship. The registration 2004 onwards.
Registration of societies and.
No. Registration of properties.
Sub-registrar's office.
Sub-register office. We made some correspondence. 2004 ಗಿಂತ ವಿದ್ದು ಸ್ವಲ್ಪ ಡಾಕ್ಯುಮೆಂಟ್ ಸಿಗ್ತಾ ಇಲ್ಲ. 2004 ಆಗಿದ್ದು ಆಟೋಮೆಟಿಕ್ಲಿ ಇಟ್ ಇಸ್ ಗೋಯಿಂಗ್ ಟು ಲಿಂಕ್ ಇಟ್.
ಅಲ್ಲ 2004 ಮುಂಚೆ ಸ್ಕ್ಯಾನ್ ಆಗಿ ಡಿಜಿಟೈಸ್ ಆಗಿಲ್ವಾ?
ಅದು ಆಗಿಲ್ಲ ಬಿಕಾಸ್ ರಿಜಿಸ್ಟ್ರೇಷನ್
ಆಫೀಸ್ ಆಗಿಲ್ವಾ?
ಆಗಿರಲಿಲ್ಲ.
Verify ಮಾಡಿ maybe it has happened.
No, that I'll check, my lord. After that, there's some developments happened. That also will place it.
An affidavit of the Additional Chief Secretary to Government Department of School Education Literacy has been filed, which reads as under. On the basis of this said affidavit, Land AGA submits that several meetings have been conducted to integrate the various departments concerned with the establishment and running of schools in the state of Karnataka. Notifications have been issued by the Director, Fire Service and Emergency Department in pursuance of which inspection of 46,460 government schools for fire safety compliance has been carried out. 28,809 government school buildings have also been subjected to fire audit, which process is ongoing. Efforts are being made to develop a API to integrate the fire and emergency services and the Seva Sindhu portal for digitally fetching the fire safety certificate by the concerned schools, colleges. The PWD department is also being onboarded to develop an online application portal to secure a building stability certificate, which will also be made part of the Seva Sindhu portal.
Out of 25 documents, the four documents, my lord, the school land conversion and school stability fund, the state may not have anything to say on that. Para number 9.
PWD department will have to do that.
Yes,
D is about the conversion and building plan.
Yes.
ULMS you can integrate.
Yes, ma'am. No, the conversion, there are some schools where it was situated without conversion also. So those documents were unable to fetch. That the efforts are going on to that extent also. The serial number second, my lord, the around 21 documents. These are all already digitalized, my lord.
We are at para D at page 5. Express some difficulty in land conversion and building plan.
Yes, my lord.
And simplification of the your ULMS baradrinda everything will be in the uniform land management system.
Yes,
that you can integrate.
Yes. The efforts are on, my lord, to that extent to extract all those documents.
Istella hakire effort ide ide. It is stated that insofar as land conversion and building plan, since there are multiple departments involved, the process is sought to be simplified. In my custom opinion, since uniform land management system is being implemented across all municipalities and municipal corporations, ULMS dealing with conversion, plan sanction, building license, etc. The same could also be integrated onto the portal for educational institutions. There are certain other issues which have been pointed out, which is stated to be being worked out to arrive at a solution. A categorical submission has been made that a substantive shift from a rigid, fragmented, and document-intensive compliance framework is now sought to be changed to a simplified, technology-enabled, and outcome-oriented regulatory mechanism. And towards that end, all the departments are being integrated and are working towards. Learned AGA submit that if the matter is taken up in the second week of February, a further compliance report will be filed. Released on yavat
After 10th, any convenient date, Lords. After 10th.
Yav date ಹೇಳಿ at 4 o'clock.
Yes, ma'am.
12th at 4 o'clock. (121, 122). You also go through the
Serial number 123, Jagdish Achari.
yes. ಬ್ಯಾಕ್ ಪೇನ್ ಅಷ್ಟೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋದು ಎಷ್ಟು ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಜಗದೀಶಾಚಾರಿ ಇದರಲ್ಲಿ ಇಟ್ಸ್ ಆರ್ ಪಿ ಅಲ್ಲಿ ಒಂದು 10 ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ತಗೊಂಡಿದ್ದೀರಾ ನೀವು ಇನ್ ಪರ್ಎಂಪ್ಟರಿ ಆರ್ಡರ್ ಆಗಿದೆಯಾ ಈ ಸತಿ ಪರ್ಎಂಪ್ಟರಿ ಆರ್ಡರ್ ಮಾಡಿ counsel for the petitioner seeks fund is granted 1 week's time finally to address his arguments. If arguments are not advanced on the next date, petition will be liable to be dismissed for non-prosecution. Relist on 10th at 2:30 p.m.
230 matters. List number 2, serial number 15. G. Suresh.
ಊಟ ಮಾಡಿಲ್ಲ ಉನ್ನಿಕೃಷ್ಣನ್
ಇದು my lord, I have entered appearance today, my lord. My name was shown, but I have not collected a copy of the petition.
Copy has not been come.
So if my lord,
counsel for the petitioner undertakes to furnish 2 sets of the petition along with annexures on Shri Unnikrishnan by end of day 2nd February. Shri Unnikrishnan seeks for 2 weeks time thereafter to obtain instruction, make his submission. Released on 17th February.
my lord, sorry, this counsel, my lord, what happened? Change of. No, or I'll take a copy.
Email ಮಾಡಬೇಡಿ.
Email ಮಾಡಿ.
16.
ಇಲ್ಲ ಅಲ್ಲೇ ಏರ್ ಡ್ರಾಪ್ ಮಾಡಬೇಡಿ. ಸಿಂಪಲ್ ಟೇಕ್ ಇಟ್ ಅಂತ ಏರ್ ಡ್ರಾಪ್ ಮಾಡಬಿಡೋದು.
Petitioners were appointed as permanent employees of the cooperatives society. But the appointment was cancelled by the deputy registrar by an order without holding an inquiry and without being confirmed. Because that petition was disposed of in directing us to approach to take appropriate steps under 70.
2D.
Plus 70 subclause 2D, since this cooperative society is within the target jurisdiction, it comes to AR, assistant registrar. But the order passed is by the deputy registrar. Until unless that is set aside, the AR will not have jurisdiction to.
And AGA is directed to accept notice for respondent number 1 to 4. 5 Yarrow, who had appeared? Unserved and unrepresented. Since respondent number 5 had earlier been served and unrepresented, notice is dispensed to respondent number 5. Counsel for the petitioner served 2 sets of the petition along with annexures on the learned AGA, who seeks for and is granted 10 days time to obtain instruction making submission. Relist on 11 February. This legal issue, if DR has passed the order, 72D is assistant registrar and the problem.
17, PA Hanmantaya, 13%.
Yes, Chikbadapura.
The FSL ಕಳಿಸಿದ್ದು ಇನ್ನೂ ಬಂದಿಲ್ಲ documents. That is regarding that RTA applications, my lord.
When is it going to come?
I am not.
We have 1 month,
2 days.
1.5 months I think.
I am not aware of it. 2 days.
Or ಅದಕ್ಕೋಸ್ಕರ ಬರ್ತಾರೆ ನಿಮ್ಗೆ ಎಕ್ಸ್ಟ್ರಾ
2 days ಅಂತ ಹಾಕ್ಸೋದ್ಬೇಡಿ ಮತ್ತೆ ಬಂದು ಹೋಗೋದ್ ಬೇಡ. ಒಂದ್ ಕ್ಲಿಯರ್ ಡೇಟ್ ಕೊಟ್ರಿ ತಾವು 1 ತಿಂಗಳು ಕೊಟ್ಬಿಡ್ತೀನಿ ಅಂತ.
ಮಲಾಡ್ ಇದ್ರಲ್ಲಿ
ಅಂಡ್ ಇದ್ರಲ್ಲಿ ಅವರು that person was alive for 5 years.
Venkatachala, you appear through VC next time.
ಅಲ್ಲ,
Once
VC
they
ಬೇಡಿ,
file,
ನಾನು
ಆಮೇಲೆ ನೀವು physically ಬನ್ನಿ.
ಆಗ್ಬೋದು.
ಇದು ಇನ್ನ ಯಾರು ಡೈರೆಕ್ಟರ್ ಫಾರೆನ್ಸಿಕ್ ಸೈನ್ಸ್ ಲ್ಯಾಬೊರೇಟರಿ. It's been about 3-4 months.
I'll check. I don't know.
And AGA once again submits that the report from the forensic science laboratory has not been received. He seeks for a short accommodation. Released on
Lordship, I have it on 11th, my lords. 11th.
ಯಾವತ್ತಪ್ಪ ಬರುತ್ತೆ? 12th February.
11th.
The director, forensic science laboratory, is direct look into the matter and expedite the furnishing of the report. You can forward this order to them so that they expedite.
11th Sunday, sir.
Serial number 18, Sampath, connected matter.
File it or send it or it was
I was directed to file an affidavit. I filed my lords.
Affidavit written submissions, synopsis, sir. Affidavit.
Affidavit filed. My lords are directed. I'll file an affidavit.
Both of them seek a week's time to file the written submissions.
Please.
Affidavit ಏನಕ್ಕೆ ಬೇಕು? ಇದ್ರಲ್ಲ. Maybe something else. This is that section 77.
Please,
Yes, my lords.
BW.
There is direction, my lord, that chairman's affidavit. Then I said engineer in chief affidavit. I'll file. My lords may recall, although 77 only, if my lords were inclined that, my lords, what would happen in the situation that we don't pay the compensation? So let us file. I was directed to file an affidavit.
Okay. Filed?
Filed.
When?
Unless I have filed it, my lords,
27th.
27th, I've served a copy also, my lords.
27th in ನೋಡಿ ಇದೆಯಾ? In which matter did you file? 8296 or 77?
8296, my lords.
8296 ಅಲ್ಲ.
Put up again. I requested. They said it is put up also.
What about your synopsis of argument? That you have
I'll file it.
Learned counsel for respondent number 1 and 2 submit that he has filed the affidavit of
Engineer in chief.
engineer in chief. Registry is directed put up the same. He seeks for and is granted.
Chief engineer, my lords, chief engineer UWP.
Chief engineer UW ಅಂದ್ರೆ
Under UWP and ಹಾಕಿದ್ದಾರೆ.
bracket UWP. He seeks for and is granted. ಎಷ್ಟು ದಿನ ಬೇಕು?
10 days, 5 days, weeks time. I'll file it.
10 days time to file his synopsis of arguments. Released on 10th February.
10, please.
You have filed?
Yes, sorry, I will file it today itself. I served it.
Served.
Please.
Serial number 19, Sujata Nayak.
Please.
ಏನಪ್ಪ ಆಯ್ತು?
Before I had requested my client to come down. He had come here. They were there. My client is not willing because of this reason.
No, reasons we don't want you.
Please.
You want to settle, you can settle. If you don't
I
want
also
to
tried, my lords. My friend is aware.
Lords, we had made an honest attempt.
Hmm.
Lords, but what the petitioner's client is asking is ultimately in a way to do another illegal act, for which again the other side will come on.
No, we are not saying any illegal.
No, no. Ultimately, that action would be illegal on my part. They are beneficiary. They are not.
Also requested. What he said was his parents were physically, my lords, pulled out from the house and dumped into the car. And my lords, at the airport, my lords, in full view, he was arrested. He was put into a jeep. He was
No,
humiliated.
what do you want? They are ready to apologize.
Plus,
Unconditional apology and ಹೇಳಿದ್ದಾರೆ.
ಹೌದು.
What more do you want? Anything else you want?
He has sought for damages. That is one aspect. And at least now what transpires is that action against him, the inquiry holds he is guilty. All these aspects have come out in the inquiry.
And that is the argument, Mr. Munish.
Please.
For your settlement, what is holding back?
Settlement, he's not inclined.
Not inclined at all.
I requested.
Lords, we have unconditionally said both apology.
You said what he's asking will make me do illegal act. He's not wanting anything. He doesn't want to settle.
There are a lot of things which transferred. Lords, I didn't want to put it across. That is.
He's not willing
Lords,
to settle.
when we went for a settlement, karma theory, all these cursing, family cursing, all these.
It's up to you to settle.
But we are more than willing to settle.
If then report settlement, otherwise argue the matter and finish it. Either of these two.
Petitioner's
You
client
can't
is
be
not.
adjourning the matters for settlement and nothing happening.
My client is very clear, my lords. He doesn't want any settlement.
But
I
in
requested him also. He said there is no
Finish it. It's only your reply which you have to give.
There's one another one.
You are not reply. You are surrejoinder. That you have to
Only
give.
one submission, please, my lords. Now, the very fact, please, my lords, that the arrest, please, my lords, and the humiliation meted out to the parents came to the knowledge of the learned magistrate. And the magistrate, my lords, directed, please, my lords, the respondent, the police inspector, to file an affidavit. He tenders, my lords, unconditional apology before the magistrate. Now, my lords, that presupposes that they don't, their defense in this case, my lords, is wiped out.
I'm sorry,
Humble
my lords,
submission. Is my humble submission. Because unconditional apology for all the acts committed and tendered before a learned magistrate. That, in my humble submission, please.
Will that preempt them from raising their defense in this matter, Mr. Munish? That cannot be said to preempt them from raising defense.
Their defense, my lords.
We'll be considering this matter
Lords,
on.
if that is the submission.
That will not affect the decision in this matter. You argued, just file your written submission. There's nothing more for you to say.
And this honorable court, while quashing the criminal proceedings initiated against us, made an observation that the conduct of the inspector, please.
You've shown us.
And that is affirmed, my lords, by the honorable apex
You've
court.
taken us through.
Please. And Rini Johar's case, I have placed.
Lords, I understand your lordship has given me a long rope in this matter. I would like to only have 10 minutes of my lord's time.
Clearly.
Please, my lords. First, on the submission made that we are preempted from the defense. If that is true,
that we won't.
They have themselves admitted before the magistrate that there is no custodial pen.
Don't
And
waste
the
time
petition
on
is
that.
not made.
That won't. You can argue the merits of the matter in a surrejoinder, not re-argue.
Please. Lords, in the gist of it, my lords, I have made my submissions on the legal issues, on both how the interplay between anticipatory bail, LOC, and non-bailable one. Lords, if my lords recalls it, I will not repeat it. And lords, the only argument is, as on date, there was a warrant in force. Warrant had to be executed. There was an LOC in force. LOC was enforced. This is in the case of the my lord's husband. Insofar as the father, my lords, the allegation that he was tortured, he was beaten. Your lordship may kindly see the medical. Page 113 of their petition. Starts from 112, my lords, annexure H. Am I with my lords?
Yes.
Page 113 is the discharge summary, my lords. Lords, patient is, date of admission is on 19th July, date of discharge is on 21st July. Kindly see the chief complaints. This is the allegation. Patient presented with alleged assault by police. Patient admitted for observation. Kindly see the past history, my lords. hypertension, type 2 diabetes mellitus, ischemic heart disease.
Yes.
Now kindly see the course in the hospital. What was detected by? Patient was admitted in the ward for the above complaints. Relevant investigations done. Troponin was negative. Chest X-ray report awaited. 2D echo revealed ischemic heart disease. No RWMA, good LV systolic function, normal valves and dimensions, no clot vegetation, effusion with EF of 65%. During the stay in the hospital, patient was treated with antihypertensives, which is with respect to blood pressure, antipyretics with respect to clots and other supportive treatment. He is being discharged in a stable state. Not even a complaint of a small contusion or an abrasion. If their entire case, Milords, is taken to be true on the face of it. The only detection which was made in the course of 2 days of inpatient admission by the medical records is ischemic heart disease. I'm consciously making this submission. Before that, I had gone through the medical jurisprudence with respect to how ischemic heart disease operates. This is a disease which tends to come with age. This has nothing to do with any sort of force, compulsion or coercion or any physical assault. The entire medical reports I have gone through, Milords. The petitioner has not produced one iota of evidence to show, apart from making bald assertions and statements in their petition and making claims that I was pulled out, I was harassed, I was tortured. There is nothing on record, Milords. Kindly see the next annexure, annexure J, Milords. Petitioner would not stop there. Kindly see page 128.
Yes.
Petitioner would lodge a complaint before the Hanumantanagar police station on the same thing. Annexure J is the complaint. Page 130, Milords, is the relevant portion, that there was custodial torture and I was tortured. Because what has happened to this police complaint, Milords, the petitioner would have to answer. I'm given to told that it has been converted into an FIR. Milords, first he would approach the police authorities, he would give a representation. Then there is an enquiry conducted. Enquiry also, Milords, does not reveal. Your Lordship may kindly see the enquiry findings.
Yes.
Enquiry report findings will, Your Lordship will get at 177. Annexure R starts from 167. Lordship may kindly see the operative portion 177, the relevant portion. Last para, Milords. Tanikedare, the third line from the bottom.
Yes.
Milords, it says magistrate has given a warning that don't repeat such acts. Kindly see.
Repeat what acts?
Milords, the fact that the act which I admit to is that for counseling, he should not have been taken. Yes, I admit. But the fact that he was beaten or he was tortured is an aggravated claim. That is what the enquiry also finds. Kindly see the next page.
Warrant illade. As regards arrest without warrant.
Please, which is not the case, which is not
105 page number. That is the show cause notice issued by the learned magistrate.
Please.
105.
Milords, that was the issue at hand, where Milords had demonstrated to show.
The show cause notice issued on the
Illegal
assault.
arrest.
Illegal arrest, yes. About the assault, any notice had been issued?
No.
My friend is reading out, please, Milords, what transpires in another hospital. I was first taken to KG General Hospital.
We'll come back to you. Let him
that,
finish.
my lords, finding my lords will have to appreciate. Yes, he can. He's reading.
Let him finish.
Yes, please.
Milords, insofar as whether arrest is illegal or not, at what your lordships notice, Milords, the action on the magistrate, despite in their own order sheet, which is a certified copy,
That you have extensively argued.
Please, Therefore, my lords,
Only
my
as
learned
regards
friend,
the injuries you
please,
were
injuries,
mentioning.
kindly see
That you had
178.
not argued earlier.
Please. That is why, my lords, I restricted my submission. I don't want to repeat it. Page 178, your lordship may see. The enquiry report also says that your action of taking the petitioner, who is the father of the husband, to counseling center was wrong. You should have just called them. You shouldn't have taken them. For that, I have suffered admonition. I have suffered no, my lords, punishment by way of decrease in increment. My increment is stalled. My promotion is stalled.
Yes.
There is a criminal proceeding instituted against me. Not the fate of which the petitioner would have to explain. I was called for investigation. I had gone to the police station. Lords, inquiry has been done. Lords, alternatively, 20A Police Act is for them. They have the alternative remedy. Apart from that, my lords, I had apologized. I had come to magistrate. My action, the action of mine, I may put it, my lords, your lordship permits, an overzealous action of enforcing the law. At best.
What law, my lords?
Enforcing the law, enforcing the
the
wish
bail
of
will
one of
arrest
the
not
parties.
Wish of one of the party, I may put it.
Not enforcing the law.
That is why, my lords, I sought my lord's prior permission.
When there is a-
to enforce one party.
Sorry to
That is the
intervene.
problem.
When they-
Let him
I'm sorry.
finish. Let him finish.
I'll-
Mr. Mani.
Mani sir is generally, my lords, very good.
I
Kindly
you
for-
mooks in you.
He's knowing where to butter.
Let him finish up and you ಇಬ್ಬರೇ ಮಾತಾಡ್ಕೊಂಡಿದ್ರೆ ಆಗಲ್ಲ ಇದು. Yes.
That's the fact. But the question of injuries which is being canvassed throughout the petition, my lords, is an aggravated claim. The entire petition papers, there is not an iota of evidence which they were able to produce, or in any of the proceedings, either by the magistrate or in the inquiry proceedings or in the criminal case. Nothing of, not a piece of evidence is found that I have laid any sort of force, abused any sort of force on them, which has resulted in an injury, even in simple nature.
Shows the injury.
Lords, and on the quantum, if my lords, alternatively, my lords, on the quantum, my lords, I have suffered. Lords, even when we honestly went for settlement, my lords, we understood what fell from my lords. My senior sincerely advised him. He was ready, he went. Lords, in fact, it went to the stage that cursing not only the client's family, but also the advocates who represent the client's family is also gone into karma theory. There's nothing which
Too
I can do
exaggerated
here.
ಆಗ್ಬಾರ್ದು. Too emotional and too exaggeration. Lots are.
We'll disregard all the non-legal arguments.
Let's two aspects. Annexure F, lots, page 105.
Yes.
That's this is the show cause notice which was issued by the learned magistrate.
Yes.
Now, as per the orders dated 16/8/2014, you are hereby directed to submit your explanation by next date of hearing as to how you arrested the accused number 1 without any warrant, and even though the bail order passed in criminal misdemeanors number so and so on the file of FTC 12, Bangalore is in force. Hence, you are hereby called upon to show cause as to why action should not be taken against you for the said reason. So, wherefore, my lords, on the face of the record, he arrests me, please, my lords, at the airport no sooner I land.
This you already.
Yes.
This is
My
not-
submission.
Only the injury
Yes,
you show us.
Injury part. But my learned friend's argument is, I get the police beat up, my lords, an innocent citizen. When he goes to the hospital, please, my lord, no wounds are found. So wherefore, his expectation is the police should beat up innocent citizens till such times that the wounds are found on the body.
there
Kindly
anything
appreciate
to
page number
establish?
112 for a minute. What transpires, please, my lords? After, my lords, I was picked up, I was thrashed. That's uneasiness in the chest, said by the attendant, previous history of open heart surgery. So patient not responding and blinking of eyes, maligning. Patient, I cannot understand what is written, not responding
copy
to
ಹಾಕಿದ್ದೀರಾ?
so and so. I think we know that is not
Type
that
copy.
Okay.
Your lordship will
And,
find the type copy in 127.
120. If it is so, please, my lords, I'll have the benefit of reading it out. Yes. Patient not responding, blinking of eyes, maligning, not so and so, so and so. So therefore, this establishes that I was taken to a government hospital.
Malinguing is speaking
incoherently, probably. Incoherently.
Yes.
So that, my lords, presupposes, my lords, that I have been subjected to some amount of torture. And this person, my lords, this
150
the
by
patient,
90.
yes, the patient, my lords, Mr. Javarasetti, He is nowhere associated in the crime. He is only the father, please, my lords, of the petitioner. He has been physically lifted, please, my lord, from his daughter's house, beaten up, taken to some police station, beaten up, then taken to a hospital. Now, what is his role, please, my lords, in the whole situation on hands? He has no role at all. There is no allegation. He is not in the FIR. He is not in the charge sheet. Yet, my lord, the police excesses are to such an extent that, my lords, he has to be taken to the hospital. My lords, and he is admitted for 2 days.
That you already argued,
Please,
Mr.
please,
Munish.
that my friend was saying, lords, no injury, no nothing.
Lords, I
So
was
therefore,
arguing on
my
record.
feelings-
So for injury, you are only referring to
I'm not- my-
127.
for the
Anything
excesses
else you are
that-
referring to?
My excesses that have been committed, lords, is extracted here at the KC General Hospital, because the KC General Hospital could not effectively treat him. He was taken to one another hospital, and he was an inpatient for 2 days. If a person is, my lords, hit up by the police,
Where is that discharge summary?
discharge summary, please, my lords,
Not
is
there, my
Apollo
lord.
Hospital.
Fortis
Fortis,
Hospital.
I'm sorry, please.
Fortis Hospital is what I read to my lord.
That was what was read out. But there it
That's
says,
the only
lords, it
medical
is,
record
alleged
which are
police
available.
assault, lords, is clearly, my lords, typed out. There is absolutely, please, my lords. Now question arises, why was the father picked up? Why was the father picked up?
That is a different matter.
Yes.
We are now on the aggravated aspect.
Yes, these are
For
the
the
injuries.
purpose of compensation.
Compensation. This is enough, my lord. This, my lord, establishes.
Ashtena?
Ashtes.
Okay. When will you file your written submissions?
Lordship may grant me 4 days time. I'll file.
Heard sir rejoinder arguments of counsel for respond number. ಯಾವ respondent ಅಪ್ಪ ನೀವು? Respond number 3.
Third respondent.
And the reply to sir rejoinder by the counsel for the petitioner. Both of them seek for and are granted a week's time to file the respective synopsis of arguments. Relist on the said synopsis of arguments to be filed on or before 6th February, relist on 11th February to verify if it has been filed.
Lords, with my lord's indulgence, there is one aspect which my lords had asked both the counsels. What is the procedure regarding LOC? Lords, the circular instructions I may not be able to secure.
Delhi
There
High
is one
Court
judgment Delhi High Court. Please,
I have produced
what my learned friend is referring to is right. I'll produce it along with my written section.
He is already,
Please.
I produced.
you produce whatever.
Please.
At least produce it and finish it.
Please.
That is what, that's
ನಿಮ್ದೇನು?
regarding the LOC circular procedure, that I'll place it on record by this.
That direction was there, my lord, that they will produce the entire file, but
And
they did not
AGA
produce it.
They
No.
produced it, we have seen it and we have given it back.
Yes.
Fine, grateful.
And AGA also seeks for a week's time to place a circular in respect of issuance of LOC on record.
I'm grateful for a patient.
Grateful.
Serial number 20, Zikara PK on connected matters.
This 15 July, your lordships had directed government advocate Chandra, Karsudra, to provide
A method of calculation.
method of calculation of rental.
ಏನಪ್ಪ ಆಯ್ತು? ರೆಡಿ ಇದೆ ಅಂದ್ರೆ ಕೊಡ್ಬೇಕು ಅವ್ರು ನೀವು. ಅವ್ರು ನೋಡಿ they can make the submission. ಫೈಲ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
File ಮಾಡಿ.
And AGA submits that has filed a memo enclosing the methodology of calculation. The same is taken on record. Copy has been furnished to the counsel for the petitioner and respondent who seek for and are granted 10 days time to go through the same and make their submission. Relist on the 12th February.
Interim order maybe.
ಇದೆ ಫೈಲ್ ಮಾಡ್ತೀನಿ.
We have recorded, you have given the copies. Interim order earlier granted is extended till next year.
We will have to
Catch
join-
hold of him and get it.
We will have to jointly make submission on that day that it has not been furnished, if it is not furnished. For once, we will be together perhaps at that time.
Not.
21, K.R. Lingaraja.
My lord, under wrong provision, acquisition has been initiated, my lord. And this court already matched the notification. And considering the same, my lord.
My lords,
Court directed the.
there was a direction to me, to the Urban Development Authority. The contention that the petitioner has taken is that the acquisition notice is issued under the wrong provisions of law. Then at that time, I responded that it is the right provision, the old 1884 Act. Then come the question of whether we have given him the money. I have produced documents indicating that the money is deposited. My lords at an earlier point in time directed me to say where I have deposited the money. Whether it is in the Assistant Commissioner Court or in the civil court. I am unable to get these records in the civil court. It's not there. But I have produced necessary documents to establish, indicate that from Urban Development Authority, we have passed it on to the Assistant Commissioner, which is.
You might have passed it on to the Assistant Commissioner. If it is not deposited, it's not deposited. If you don't have
Our
any
deposit.
papers.
None, I am a beneficiary under the.
You may be the beneficiary, but you can claim only the benefit of action on part of the Assistant Commissioner. If he is not deposited, the SLO is not deposited.
ಅಲ್ಲಿ ಕೆಳಗಡೆ ಸಿಗ್ತಾ ಇಲ್ಲ ತಮ್ಮಿಂದ ಏನಾದ್ರು ಒಂದು ಡೈರೆಕ್ಷನ್ ಸಿಗುತ್ತೆ ರೆಕಾರ್ಡ್ಸ್ ತರ್ಸಕ್ಕೆ ಐ ವಿಲ್ ಗಿವ್ ದಿ ರೆಕಾರ್ಡ್ ಸೊ ದಟ್ ಅವಾಗ ಕೋರ್ಟ್ನವ್ರದ್ದು ಎಲ್ಲದನ್ನು ಕಳಿಸ್ತಾರೆ ಇಲ್ಲಾಂದ್ರೆ ಸೆಂಟ್ರಲ್ ರೆಕಾರ್ಡ್ಸ್ ಇಂದ
Going inquiry on it. If you produce positive aspect, you have to establish.
I have produced a record indicating that I have deposited before the Assistant Commissioner at an earlier point in time. My lords were not happy with that kind of this thing.
That is not the procedure. It has to be deposited in the reference matter.
Reference matter. Tamma ಒಂದು
Section 18 ಕೋರ್ಟ್ ಅಲ್ಲಿ ಡೆಪಾಸಿಟ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ there is no deposit.
Just one last chance ಅಂತ ಕೊಡ್ಬೋದು ಇಲ್ಲಾಂದ್ರೆ I'll just give. ಯಾಕಂದ್ರೆ ಅವ್ರು ಕೊಡದೇ ನಾನು ಇನ್ನೇನ್ ಮಾಡಿ.
We'll draw an adverse influence matter proceeds.
ಏನು ಅಲ್ಲಿ ಸಿಗ್ತಾ ಇಲ್ಲ. Not that they have not done it all, they have. Last chance.
We'll only look into what documents are available with us.
That's it.
We can't look beyond that.
Beyond.
So if you produce it, we'll consider it. If we don't produce it, it is not there. If you don't produce it, it's not there.
Assistant Commissioner, government advocate may be direct because I'm a lawyer for a beneficiary. So ultimately they will have that.
Your managing director is IAS officer.
Managing director, yes. ಹೇಳಿದೆ ಇಲ್ಲಿ ನಾವು local level urban development ಅಲ್ಲಿ they'll be just a.
You can get the Assistant Commissioner. He can always get it.
ಒಂಚೂರು ಸಹಾಯ ಮಾಡಿದ್ವಿ
ನೋಡಿ ಅದೇನಿದೆ. Counsel for respond number 4 once again seeks for a short accommodation to comply with the order dated 27/10/25. Though no further indulgence is required to be granted, in the interest of justice, 10 days time is granted. Released on 9th February. If compliance is not made of the said order, adverse inference would be drawn and matter proceeded with, without granting any further adjournment on that ground. ಅಷ್ಟೇ. ಮತ್ತೆ ಕೇಳಬೇಡಿ.
My lord, previous matter filing memo. Previous matter that.
ಕೊಟ್ಬಿಡಿ. ಅವ್ರ ಕಾಪಿ ಕೊಟ್ಬಿಡಿ.
In fact, these documents are available with the respondent only. They ought to have produced,
ಅಲ್ಲ ಇದಿದೆ.
On these basis only we notify.
The methodology of calculation ಇದೆಯಾ?
Based on these circulars, my lord, we calculate and fix the lease or rent rates.
That is not sufficient to understand anything out of it.
Except this,
That's not the point was, the nature in which we need to bring the auction is stated in this 2019 order. This honorable court wanted to know how we have to charge the rentals. I have produced a document in a similarly circumstanced, in the same place, just bang opposite, charging 6,000 rupees at an earlier point in time. My lords wanted the government to verify this, my act, my lords wanted to verify this. Therefore, there is a direction given, not with respect to, this is already a part of the court record.
I have verified, my lord, to this extent. They fix the lease or rents based on these circular rules. That is the information that I have, my lord.
Place on record the guidelines which would have to be followed by respondent number 1 in fixing the rentals for the premises and or the property owned by respondent number 1. So have we produced the guidelines? What have we produced? Kodi a memo kodi.
ನೇರವಾಗಿ ಮಾಡೋದು ಡಿಸ್ಟ್ರಿಬ್ಯೂಷನ್ ಮತ್ತೆ ಆಕ್ಷನ್ ತರದ್ದು.
ಅದು ಇದೆ ಮೆಥಡ್ ಆಫ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಏನೋ ಒಂದು ಫಾರ್ಮುಲಾನು ಏನೋ ಇದೆ.
ಏನಪ್ಪ ಕಾಣಿಸೋದೇ ಇಲ್ಲ ಇದು.
ಓದೋದ್ ಕಷ್ಟ.
ಹಾ ನಗರ ಸ್ಥಳೀಯ ಸಂಸ್ಥೆಗಳ ಖಾಲಿ ಜಾಗದಲ್ಲಿ ನೂತನವಾಗಿ ವಾಣಿಜ್ಯ ಸಂಕೀರ್ಣ ನಿರ್ಮಾಣ ಏನೋ ಹೋಗಿದೆ. It's not properly photocopied also.
ಸಂದರ್ಭ 3 ಹೆಡಿಂಗ್ ರೆಲೆವೆಂಟ್ ಆರಂಗಿದೆ ಆದ್ರೆ ಓದಕ್ ಆಗ್ತಿಲ್ಲ.
This is as regards the future. This is the our notification, 2009 notification. This is as regards the further lease of the property. We were to take out the auction and then right to first refusal. ಅದಲ್ಲ ಇದು.
ಇಲ್ಲ ಇದು ಇದೆ ಸಂದರ್ಭ 3 ನೋಡಿದ್ರೆ ತಾವು
ನಾವು ಡಿಟರ್ಮಿನ್ ಮಾಡೋದು.
ಸಂದರ್ಭ 3 ಹಾಲಿ ಇರೋ ಹಳೆಯ ವಾಣಿಜ್ಯ.
It will be vetted by the Deputy Commissioner. It is not that they have any, they can do what they themselves. There will be a guideline on which they will have 6,000 rupees at an earlier point in time, not now. Earlier point in time. He's been sweating on the property since 2 decades. So even 6,000 as of today will be too less. But totally dispose model ಮುಂಚೆ ಒಂದು ಇದು ಬರಲಿ ಅಂತ ಈ Deputy Commissioner fix ಮಾಡೋದು.
If they fix and forward the file to you, what are the guidelines under which you operate? And that ಕೇಳಿದ್ದು.
Sections, my lord, that based on these circulars, the deputy commissioner has a power to fix it. There they have illustrated it, under various scenario, the fixation of rents. The first notification, first circular. This I'll produce a better copy of this.
ನೀವು legible copy ಕೊಟ್ಟಿದ್ದೀರಾ ರವಿಶಂಕರ್?
ಇಲ್ಲ ಅವರು ಕೊಟ್ಟಿರೋದು ನಾನು
ನೀವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೀನಿ ಅಂದ್ರಲ್ಲ.
ಅದು ನಾನು ಲೀಸ್ ಡಿಡ್ ಹಾಕ್ಬಿಟ್ಟಿದ್ದೀನಿ.
This note,
this no.
My lord, I'll produce the legible copy, my lord. This
because there's some calculation which is there at page 4 at the bottom.
Yes.
But it's not legible.
I'll produce that legible copy.
So is that the calculation for the rental?
Yes.
So if there's the variables are being given for calculation, then that could be the guideline.
That could be.
He would be right in that. But we are not able to make out from your estimate.
1 or 2 days, maybe tomorrow day after, I'll produce that copies.
And AG has filed a memo. I'll clear what that. Has filed a memo said to be in compliance with the order dated 15/7/25. The document which has been produced along with the said memo being the circular dated 26/10/2009 is not legible, nor is it complete. Hence, learned AGA seeks for a week's time to place on record a legible and complete copy of the circular dated 26/10/2009, released on 4th February.
12th ಇದೆ ಒಂದು.
12th ಹಿಂಗೆ ಅಂದ್ರೆ ಆಮೇಲೆ 12th
other matters.
Entry order.
Serial number 22. D.M. Halaswamy.
Appearing for the respondent 3 in this petition.
Yes.
Appearing for petition, my lord.
There's a direction to AG.
Yes, about that sound pollution.
Yes. Temple.
2 weeks time we'll give you. If you don't, we are giving you enough of time. If you don't, then first respondent will be here. Now, who is to take a decision on this?
It's for them.
Now, which officer is to take a decision?
The authority definition, defines may I read from?
Yes.
As per section 2C of the noise rules.
My lord, in this.
authority means and includes any authority or officer authorized by the central government or in the case may be the state
No, we have requested the Principal Secretary of Home Department to consider the above.
My lord, I have made a communication with them since the session is going on. I was unable to get the instruction, my lord.
This was before the session.
Yes, my lord, I understand. 19th it was
AGA
listed.
seeks for and is granted 10 days time to comply with the order dated 22/7/2025. Yavattu session complete agadu?
Session another 2 days. 12th ಹಾಕೊಳ್ಳಿ. On 12th. we'll do.
February.
Serial number 23. Lakshmi Narayan K. 13%.
Report has come.
No, that we have filed, he has already filed the objections, though I have not received the objections copy, my lord. We have.
You're not given him the objection copy?
He says that he has filed in the register, I have not received it. Copy is there. And I'll keep the IO present, my lord.
Same day morning itself I had filed.
No, you should give them a copy.
I don't have an additional, I'll take a Xerox and give.
All of you are entitled to file anything, but when you file, you should give a copy to the other.
I have given it to him. I filed in his office.
You have received copies?
No, no.
None of you have received. But you.
After that, he has filed the objections with the official report.
Hmm.
But directed to place the entire investigation report to Lord, so that we have filed it.
You have filed it. And objections have been filed.
He said you have filed it. He said you have filed in the register.
When did you file it?
This was filed on 14th January.
Idiyanama. You filed a rejoinder on 14th. Copy ilva? You have a copy of it?
I'll Xerox and give it to him.
The petitioner party in person has filed a rejoinder on 14/1/20.
Lordship, with your permission, I would first like you to go through page 51. Do you have it?
Go through it when all of you are on the same footing. There's no point in hearing you once and then them. You give them copies.
No, I'm showing you the live Trojan. Live Trojan on my mobile. They're saying they have not found anything. I'm
We
showing
won't
a
know
live
all
Trojan.
those things.
Can
If you show us, how will we know?
I'll
mean, if
keep
you would
the.
like to see it, you can see it.
I'll keep the ACP of the cybercrime present next at a hearing.
You need a
No, he
technical
has
person.
many grievances against my lord, that we cannot do it. If we board into the metro, somebody, he files a complaint, says somebody is following.
They will load it by way of an app.
This RTOchalan.apk, all of us have received. I have received it some 4 times.
On which he has filed many complaints before us.
That everybody has received. This malware keeps on coming. Somebody keeps sending.
But they said there's no malware. That's the point.
There's no malware in the sense, in a WhatsApp or somebody keeps sending it. You'll have to be circumspect and delete it.
Yes, we delete it.
So all these
And it
.apk
keeps-
files you have to delete.
It keeps running.
You give him a copy of whatever you filed.
Sure, sir.
You want to keep the
ACP, so because he has answer it into cyber. So I'll keep.
technical person.
He's a
your
technical
ACP
person, technical person.
Has filed a rejoinder on 14/1/26. He seeks for a week's time to furnish copy thereof on the respective counsels for the respondents.
I have also filed an affidavit of technical discovery. So that may also be.
First give everything, we'll take it up on one day when everybody has it. Argue the whole matter. This adjournments won't help. Please give them the copies. All of them. Again, one of them is not given, it will again have to get
No,
adjourned.
whoever is here, I'm having more, sir.
Whoever is on the right hand side
That
of the cause list,
to my
please
left.
give it to them. And AJ submit that you would also keep the jurisdictional ACP.
ACP or technical person.
And or a competent technical person present during the course of arguments. Relist on 17th February at 2:30 p.m.
Serial number 24. Yes, sir. Connected
Lord, I am
matters.
filing statement of objection.
We should file. Received copies?
Not it.
Not yet.
ಈಗ ರೆಡಿ ಆಗಿದೆ.
Now all the pleadings are complete.
Our name can be set
Yes.
for that.
Now, Shauri, how long will you take? How long will you take?
State has to argue yet because we have already argued the matter once.
So nothing more.
And on this
You want to
objection,
make your submission on this?
Yes, certainly, my lords.
So 10 minutes for you. Madam, you are finished.
I
20
know I
minutes.
have finished.
No, I have to reply to madam after once the state does the, my only understanding is we have argued the matter. Madam has commenced and completed. Now the state has to argue. Then I will give reply. Otherwise it should be piecemeal.
That's all.
I may reactivate some of my submissions.
So you will take 20 minutes to finish your arguments. Nimdu eshtotu?
In 20 minutes, Mala.
20 minutes.
15 minutes for Mata.
So 1 hour is required.
For them, I require 20 minutes because I have to answer all the points that madam has raised. Amicus curiae has raised.
Whether 18th, 19th Feb or.
February is a Saturday, which is a working day. So we'll have it on
Saturday, unfortunately, I'm traveling.
21st February, yes, we also have.
The March.
No, not much. Finish it now.
Then the 20 is 28th Saturday. What?
28 is only for the trial court, not for the high court.
26th Feb.
So 18th is fine.
18th
Realistic.
is fine. Yes, great. 18th is fine.
Learned AG has filed a statement of objections. In which one have you filed, Mr. Bopaya?
It's all same.
In all three?
All the
Separate objections?
single objections to all.
Consolidated objections?
ಹಾಕಿದ್ದಾರೆ 21816 ಅಲ್ಲಿ
ಒಂದರಲ್ಲಿ ಹಾಕಿದೀವಿ.
ಅದಕ್ಕೆ ಬೇರೆ ಅಡಾಪ್ಟ್ ಅಂತ ರೆಕಾರ್ಡ್ ಮಾಡ್ಬೇಕಲ್ಲ. ಯಾವ್ದ್ರಲ್ಲಿ ಫೈಲ್ ಮಾಡಿದ್ದೀರಾ?
First one 2181.
21816.
Yes, my lord.
And AG has filed a statement of objection in WP 21816 of 2025. The same is taken on record. Copy thereof has been furnished to the counsel for the petitioner and the other respondents. And AG has submitted that the said objection may be treated as objection in the other matters. Hence, the objection is treated as objection 20555, 21850, 25836 of 2025. Then 24.3, what is this 24.3?
2586.
Bari GS served antide yake?
Okay. ಅದೇ ಪಿಂಕಿ ಅದೇ
5367
Only the government is the party, anybody else a party in 24.836. What is this? What tagged?
Pinky and others, my lords.
This is a new matter. It's coming up before us for the first time. You got it tagged. Notice is not complete in this.
Which one, my lords?
25836.
25836, amendment has been carried out.
In amendment. No, the responses have not been even, notice has not been ordered. 24.3. Learned AG accepts notice for respondent number 1 to 3, 4, 5, 6, 7, 6. Juvenile Justice Committee, High Court of Meghalaya, who had appeared, Nayanthara had appeared. Nayanthara BG is directed to accept notice for respondent number 7. Shri Zulfikar Kumar Shafi is directed to accept notice for respondent number 8. Union of India, who had appeared in the other matter?
Mr. Kumar.
Kumar.
Shri M.N. Kumar is directed to accept notice for respondent number 9, 10, 11. AGA for respondent number 12 and 13. What is this matter that you have filed?
My lords, 21850, first time one single mother appeared. Then when all the parents came, it became 25836 separately.
There's nice reliefs which you have sought for. Hopefully it is under proper legal consideration. If any of these were to be rejected, you could be in trouble. The way that you have asked for this relief. Petitioner could be in trouble if any of them are rejected. Wording is very. Give a copy of this to the amicus also.
Yes, my lords. It has been submitted, my lords.
This matter was not part of this
No, it
batch
was,
matters.
it has been part, it is continuously there, Lord. There,
writ
from the
appeal
beginning,
ಎಲ್ಲ ಅದ್ರ
all
ಮೇಲೆ.
the arguments have happened in that. They have made an
25836.
application for amendment in that. Your Lordship have allowed, Union of India and others were made party. Throughout, it has been part of it. In only 21816, I had appeared for petitioner after obtaining NOC from them. The rest of the matter, that 25550, that was not connected to this, but somehow the issue is related to that. That has been
Yes, so
tagged.
now it's come. IA 3 of 25 is for impleading.
Yes.
Who do you want to implead in this?
That your Lordship has already pleaded.
That is on 24/10/25.
Still pending, no order has been
No, no, it
passed.
is.
That has
your
been
Lordship
done.
has allowed. Union of India has come.
When was it allowed? ಇನ್ನೊಂದು ಯಾವ್ದ್ರಲ್ಲೂ ಆರ್ಡರ್ ಶೀಟ್ ಇದೆಯಾ ನೋಡಿ.
So most of these orders, my lords,
25836.
25836 is the petition where all the parents have contested.
24/10/2025.
24/10?
10/2025.
File.
2410 ಆಗಿದ್ದ ಅಪ್ಲಿಕೇಶನ್ ನಿಮ್ಮನ್ನು ಕ್ಲಿಯರ್ ಮಾಡಿದ್ದಲ್ಲ ನೀವು ಹಾಕಿಲ್ಲ ಮಾತ್ರ ಮಾಡಿ ನಿಮ್ದು ಕಂಪ್ಲೀಟ್ ಅಪ್ಲಿಕೇಶನ್ application complete in India.
IA 3 has not been considered in that order. IA 3 ಕೊಡಿ.
ಇದನ್ನ ತಪ್ಪಿದೆ.
IA 3 is pending.
IA 3 has not been allowed. You already carried out the amendment. ಅದಕ್ಕೆ ಮುಂಚೆ ತಗೊಳ್ಳಿ. IA 3 of 25 has been filed to bring on record the Union of India represented by the Ministry of Social Justice and Empowerment, Union of India represented by its Secretary, Ministry of Tribal Affairs, National Commission for Protection of Child Rights through its chairperson, accepting the reasons stated in support of the said application. This stated in the affidavit in support of affidavit to illa. Reasons stated in support of the application is allowed. They are brought on record as respondent number 9, 10 and 11.
For union of.
Counsel for the petitioner has already carried out the amendment even prior to the application being allowed. Allow Agilla. That act, the said act is condoned. 12 and 13 also you have made party. How did they come?
They are the original part, my lord. 7 and 8 ಇದೆ.
12 and 13.
7 and 8, my lord. Original application 7 and 8. Original application 7 and 8 were DDPA Chikballapura and BEO Chikballapura. Later onwards in a court record, it became because of the JJ committee, Shillong and Director of Social Welfare Department, once again Government of Meghalaya, they were named as 7 and 8.
You should bring it to the notice of the court before doing all these things. You can't by yourself go and do it. This is like,
My lords,
if we use the word, then we'll have to take action.
with due apology, my lords. That day the court itself ordered.
You change the original respondents to some other number. If there was a mistake in numbering, you should have brought it to the notice at that time only. The numbering could be corrected. You can't correct the numbering by yourself.
Sorry.
Now, the reference in the petition to 7 and 8 is different. The actual respondent is different. Now, you made them 12 and 13. How can you do that, Shyam?
I'll do that. I'll correct myself.
You received this copy, madam, 25836?
Yes. I don't have the amended copy.
Amended copy only. The same thing.
But it says
ಹೆಸರುಗಳೆಲ್ಲ ಬಂತಲ್ಲ ಆಮೇಲೆ so and so
Yesterday.
for each of the respondents. Registry Director printer name as such. Relist on 18th February at 4 p.m. 18th at 4 p.m. Yes. In the meanwhile, respective counsels to file their respective synopsis of arguments after exchanging same with each other.
Serial number 25.
My lords, I won.
Interim order earlier granted is extended.
Graceful. Extremely sorry, my lords.
Learned counsel for learned AGS seeks fund is granted 3 weeks time to file a statement of objection. Relist on 23rd February.
26.
Exhuming the dead body, my lord.
There is 10 foot of land there. Is there in Panchayat Deviation? There is no demarcation. No 100 hours for Panchayat.
In survey number 58.
Out.
So that is within the same village.
Out. I produced the RTC in the petition itself.
Turundahalli Gramadalli. Yes.
They told that all the
within the jurisdiction of panchayat.
So then how did this happen and what is the action to be taken?
I require 2 more weeks to time to take it. And I have communicated to Assistant Commissioner.
So now what will you do? Will you exhume the body and
My difficulty, my infant of the
Yes,
house, my lord,
the
it is that I
instructions,
can-
it's going on for
1.5 years,
instructions.
I am not able to use my house, my lord. My residential house, I am not able to use.
This is a serious matter. Ms. Baba, I will give you one last 1 week's time. Whatever instructions you get, if you don't get, you don't get. Address your arguments and finish the matter. 1 week we'll give you, but address and finish the arguments. And AG and Counsel for Respond number 11 has filed a memo dated 29/1/2026 enclosing the correspondence of the Panchayat Development Officer dated 16/1/2026, stating that there is an extent of 10 guntas of land reserved in survey number 58 for burial of dead bodies. The same is taken on record. And AGA once again seeks for one short accommodation to get ready and address his arguments. Relist on 5th February, it is made clear that no further adjournment would be granted.
Serial number 27.
Lord, matter is dismissed for non-prosecution. Have filed application for a recall the
Why does
order.
it come to before us? When was it dismissed?
At 25/3/2025.
Any objection, Mr. Krishna?
Several adjournment was taken. Thereafter, he filed the application, memo for retirement. After, once later, this application was filed, and after filing this application also, I will see the last order.
Yes. We saw the last.
Previous order.
17/12. No, but why is it coming before us? Should go before the regular bench, alva. Recalling also can go before the regular bench. Only if there's a modification. Recalling alle ಹೋಗ್ಬೋದಲ್ಲ. Merits ಏನಿಲ್ಲಲ್ಲ. It's only recalling for non-prosecution.
ಅಲ್ಲ ಅದು ಹಳೆ ಮ್ಯಾನೇಜಿಂಗ್ ಡೈರೆಕ್ಟರ್ ಚೇಂಜ್ ಆಗಿದ್ರೆ ಅದು ಹಳೆ
ಅಲ್ಲಪ್ಪ ನಮ್ಮ ರಾಸ್ಟರ್ ಅಂತ ಇದು because there is a GM matter. This last GM matter. It was dismissed for non-prosecution. So recall application will have to go before the roster judge. What has been filed is an application for recalling the order of dismissing the above petition for non-prosecution. Or we'll recall it and post it before the. IA2 of 25 has been filed for recalling the order dated 25/3/2025, dismissing the above petition for non-prosecution. The contention now raised in IA2 of 25 by the petitioner is that there were several changes in the directorship of the petitioner, and as such they could not contact the advocate, which has resulted in the dismissal of the above petition. In support thereof, the necessary filing before the register of uh, uh, filing in the MCA portal have been produced. In that view of the matter, IA 1 of 25 is allowed. The delay in filing the recalling application is condoned. IA 2 of 25 is allowed. The order dated 25/3/2025 dismissing the above petition for non-prosecution is recalled. Petition is restored to file, subject to payment of cost of rupees 5,000 to the Advocates Clerks Benevolent Fund. Registry Director place the matter before the appropriate roster bench.
Serial number 28. Sunil Kumar Head.
Case, my lord, 28 point, my lord, 1 and 3 may be delayed, my lord, deleted from the, my lord. Yes,
What are these matters?
Lord, ask criminal petitions, matter 482 petitions.
482 petitions.
That 1 and 3, my lord, it is not even, because my ground, my lord, in the petition, my learned friend ground is totally different. Lord, so the, my lord, the FIR and the other, my lord, what facts are maybe, my lord, similar, but the facts, my lord, which has, my lord, in the, my case and this case is totally different.
Why is this before us?
Because your lordship has granted the bail, my lord, earlier, because of
Bail?
the bail, yes,
Some
of the accused people.
Lordship was pleased to hear it.
Because of that reason, it has been.
We'll go 482 gain connection.
After the charge sheet, my lord, the registry has connected.
Registry,
Special order.
special order.
Yes.
No, it's maybe dealing, my lord, 28.1, my learned friend
Is there a
cases.
special order for that also? Then we can't dealing.
No, it is not special order, my lord.
Yavadu?
The 28.1, because due to, my lord, the submission which has been made by my learned friend, my lord, government advocate, this matter has, these two matter has been tagged, 28.1 and 28.3.
Twenty-eight point three is.
28.1 and 28.3.
Yes, for respond number 2. Yes. This 28.1 and 28.3 connected to these.
By the, my lord, the government, I mean, the before.
Proxy counsel.
ಅಲ್ಲ ನಂದಿದೆ 28.2 ನಂದು ಅದನ್ನ ನಿಮ್ದು one in that one
Adjournment.
28. ನಿಮ್ 3 ಅಲ್ಲಲ್ಲ 28.1 ನಿಮ್ದು 28.
On behalf of the council for respond number 2.
Dealing ಮಾಡಿ ಅಂತ
The short accommodation. Really are respond number 2.
28 and my lord 28.4. ಅಲ್ಲಲ್ಲ 3.
Kolme Mohammed Saib, who is the executive engineer Bescom. You appear for Bescom. Ms. Swamini G. Monambal, who has entered appearance for the respondent number 2 in other matters, accepts notice for respondent number 2 in criminal petition number 144722 of 2025. Seeks bond is granted a week's time to comply with the office objection raised on the statement of objections filed in all the matters. Counsel for the petitioner submit that criminal petition number 11284 of 24 and criminal petition number 7700 of 2025 are not connected to this batch of matters. And counsel for respond number 2 seeks for and is granted 10 days time to make a submission. Released on 16th February.
Interim orders.
Interim order earlier granted is extended.
Wait.
29. R.P. Annapanavar.
Madam Renuka was appearing, I don't think she's, Madam Renuka was appearing in
Yeah,
these matters.
This
I'm
case
not
was,
aware.
As per instruction, the Renuka has filed and complied with the order of your lordship's order.
Report filed. Ide anta report ide. Circular has been issued. There's only one thing, that it was directly to be uploaded to the cloud server. ಇಲ್ಲಿ download and upload ಅಂತ ಹೇಳಿದ್ದಾರೆ.
That is what it was, my lord. My lords had
Anybody
already
can-
expressed. Lords had already expressed because of the police report, my lord. My lords wanted to directly route it to the cloud so that
This can create
yeah, problems and
evidential production, hash value will change.
yes.
So it won't be able to be produced as evidence.
But
So
my
doing
lord,
all these things will become useless.
My lord, what BMTC had said, my lord, it won't be feasible on the for calling tenders for a Wi-Fi this one, my lord. With the SIM router, my lord. It
eSIM,
won't be-
eSIM
eSIM won't be feasible for KSRTC for this reason, my lord. There won't be networks around, my lord. KSRTC, my lord, is all over Karnataka, my lord. But there'll be
Even otherwise, if it is recorded on it, the moment the network is available, it should upload directly.
that is yes.
It should not be download and upload. Download and upload, something could be deleted.
Now that's the system what they're using.
That will become a problem.
Yes.
So this you bring it to their
Yes, my
notice
lord, I'll bring it.
and correct that to say that it will have to be directly uploaded to the cloud server.
Yes.
Compliance report has been filed, which is taken on record. A perusal which circular number 1 of 2026 is enclosed with the said memo which reads as under. A perusal of the said circular indicates that the data and that the video, that the audio video recorded using the body worn camera is required to be downloaded and then uploaded onto the cloud server. Similar is the situation as regards the in-bus cameras proposed to be installed. The downloading and uploading would result in a different file being created. There being also a possibility of manipulation of the said videos. In that view of the matter, the response are directed to initiate a process of directly uploading the audio video from the cameras to the cloud server. In the event of there being no mobile signals at that relevant point of time, the uploading could commence as soon as there is a signal available. Learned counsel for the petitioner is directed to inform the concerned about the same and make a submission. Released on 23rd February.
30, my lord.
Serial number
Next matter.
30.
30, my lord, it's a different matter, BBMP matter, my lords have directed the
This
GBA.
one, Register of Births and Deaths.
Yes, my lord. Lord, I did contact them, my lord, I've not got any information, may I request for 2 weeks, my lord, Lord, I also wanted to know what system they're using so that we can integrate it in the same system. If they give us some information in that system, what they're using.
Speak to M. Kumar, he will let you know.
Yes, my lord.
Learned counsel for respond number 664 and is granted in 2 weeks' time to make a submission. Released on 23rd.
Much.
Number 1, serial number 1.
List number 2 ಮುಗಿಸ್ಬಿಡಿ first. ಆಮೇಲೆ list 1.
List number 2. Passed over matters, list number 2, serial number 7.
Lordship has heard the matter because 3 years' time was there.
Yes, you have relied on that judgment.
Judgment, 3 judgments.
My lord,
Your Lordship has directed who has changed the Khata in
Yes.
2003.
Yes,
My lords, I have written a letter, my lords, I'm just awaiting 3-4 days, my lords. ಅದು 2003 ನಲ್ಲಿ he's supposedly retired, my lords, I'm getting the details.
Retired.
Yes.
My lord,
Actually, it was in 97, it was changed.
ನಿಮ್ಮ argument ಮುಗೀತಲ್ಲ? Yes, madam.
my lord, I can, would like to make a submission. There cannot be any issuance of any khata in respect of any flat which is not there in the building sanction plan. Any construction made contrary to the building sanction plan will not give any legal right in favor of the violator to enter their name in the khata, which is non-existent in the building sanction plan. The BBMP has passed an order in conformative with the act of the Supreme Court judgment, which is attached here.
Yes.
Judgment. The petitioner is trying to overreach the order of the Supreme Court by presenting misleading and false facts before this honorable court and not come in clean hands and is suppressing facts. I'll tell you how they're suppressing me, my lord. The flat construction is in 100% total violation of the building sanction plan and is not entitled for any condemnation of deviation under KMC Act. My lord, any action in support of an illegal act, if so fact is illegal. If so fact is illegal. My lord, this you very well know, my lord, but I would like to bring it, you know this, my lord, I'd like to bring it to your attention. In the Constitution of India, in Article 141, you very well know, it's my thing to bring the point out. Law declared by Supreme Court to be binding on all courts. The law declared by shall be binding on all courts within the territory of India. This is Article 41 of Constitution of India. And my lord, this also you are very well aware, but I just like to read it. This is 141. Another one is Article 144. Civil and judicial authority to act in the aid of the Supreme Court. All authorities, civil and judicial, in the territory of India shall act in aid of the Supreme Court. This you are very well aware, but I'm forced to bring it to your attention, my lord. And one incorrect action, one incorrect act of the authority cannot support another incorrect act. This is a principle which is already there. It's already incorrect. So one incorrect act, the authority cannot support another, which this is the principle of law. My lord, the existence of the illegal flat also affects all my rights, the other owner's right. So transfer of khata is not permissible, my lord, because it's already illegal and the BBMP has taken rightful action and cancelled it once they came to know about it. So transfer khata which is already made illegally can't be transferred, which will add to the illegality, my lord.
Yes.
And my lordship, I pray to dismiss both the petition and I stand before you to give me justice.
Yes.
To be served. And my lord, I just like to bring to your notice the illegal thing. In the petition copy of the applicant, petitioner, if you can go to page 7, my lord.
7.
Writ petition number 26870.
26870.
LBBMP.
Yes, page 7.
Page 7, my lord. Para E. You know, he is trying to confuse this court, which this court is already, he goes on to say that in favor of the petitioner, the respondent JC has cancelled khata in favor of the petitioner E. Then if you go to respondent, page 8, my lord, in the same petition, he goes to say the second respondent, that says AEE, has AC cancelled the khata in favor of the petitioner. No, he's trying to confuse his court, saying that the khata is in their name, which is not so. The khata is the name of Revati. And even page 10, my lord. 10, my lord. Again, 10G. Page number 10, para G. In the present case of khata was made in favor of the petitioner. G. Page 10, my lord.
Yes.
No, but no, he goes on saying petitioner, which is the Khata holder Revati. And my lord, technical error or, this court thinks that the Khata is the name of the Nagbhushan, the petitioner, which is not so. The Khata is not transferred. There's so many paragraphs like that saying the petitioner, which is just confusing the court and myself as a respondent, my lord.
Yes. You have the Khata in your name, Ramesh?
No, my lord, no, my lord.
Khata
Last my is page number 12.
So
There is a direction, that's a typographical.
That we pointed out last time. You said you will check.
Which one?
So there is no Khata in your name.
No Khata in my name.
No
That was
transfer.
said, and our one prayer is to change my Khata in my name.
My lord,
That is why the
That is the
petitioner.
second petition.
Yes.
Now,
he's come to court for,
when Revati's Khata has been cancelled, where is your right?
That's why I will step into the shoes of the Revati.
Revati is not before us.
Yes, no. No, it is not. They are not.
Then how is your
Because-
petition maintainable?
Because I am the present owner, my lord. The Khata is even, let us assume,
What
the
has
Khata
been-
is in favor of Revati in year
We asked you
2003.
last time also, that is what you had to reply. If Revati's Khata is cancelled, is your Khata, you never had a Khata in your
No,
name.
that's why I sought a consequently the Khata is to made in my name.
Everybody question ಕೇಳಲಿಲ್ಲ
Yes,
ಅಂದ್ರೆ
ma'am.
what answer will you give? Revati's Khata has been cancelled.
Yes, ma'am.
So now there is no Khata for that property.
Yes, ma'am.
Where the question of transferring it into your favor when your vendors Khata is not there.
correct.
That even cancellation of Khata in favor of the Revati is also is not in
Who
accordance.
can challenge?
No, Revati is, I will step into the shoes of the Revati.
You can't step into the shoes unless you
I
have
am the
the Khata.
purchaser.
No, he's
I'm the
the
purchaser.
purchaser of AV.
Purchaser, because
Let him, we are asking him a question, madam.
Revati has sold the property in the year 2003, Melo. 2011, 2003. And the third respondent has filed an application to cancel the Khata in the year 2011. Even 8 years, even Revati's name also, it is 8 years. What was illegal cannot be legalized. Now, your last what, even according to her, even 2003 Revati, it is in the name of Revati.
Your locus.
Because I am the purchaser of that property. That's
But
what.
illegal property, knowing that.
That's
it's
a very far stretch for you to say.
Your last kindly see, in the subsequent, this honorable court has said, I will be step into the shoes of this.
That's how it's misguided, Your Honor.
Well, same court, on that day, the court was intended to.
Yeah, he is misguided this
More
court, Your
mis-
Honor. This court thinks that the Khata is in his name.
No, my lord.
Yes. Even the petition copy, the paragraphs after paragraphs is confusing.
What do you want to rely this order for?
Otherwise, it is, I am stepping into shoes of para 5.
Where is it? Which?
Sir, copy.
Can I have a copy to it? Another one. Can I have a copy?
Para 7.
How will that help you? That is submission of the respondent.
My lord,
The respondent is the authority, my lord.
That is a submission, that's not a finding.
Even para 7, it is a finding. Lord. So worthy of acceptance cannot be allowed to shortcut the appeal remedy. That's why I have been.
This as regards 248.
Yes, ma'am.
That's the different
My
footing than a
contention is
Khata.
I will step into the shoes of the Revati. my lord. The Revati Khata was cancelled, application was filed in 2011. 2003, it was the Khata was made in her name. What was illegal cannot be, my lord. Because 2003.
This person has retired.
Please, madam, that is my information.
The submission of Shri B.S. Karthikeyan, learned counsel for BBMP on instructions, submit that the person who had got the entry of the Khata in the name of Ms. B. Revati has retired. His submission is placed on record. Arguments having already been heard earlier, further arguments were heard today, reserved for judgment.
Reserved.
Apologies. Mentioned that serial number 25 list 2 3 weeks has been given. ಇನ್ನ ಬಂದಿಲ್ಲ ಇವಾಗ 7 ಅಲ್ಲಿ ಇದೆ. ಅಲ್ಲ wait please.
Serial number 8. Can Nanjay Reddy?
Much obliged. Yeah.
Same. Yeah, sorry. Sorry. Yes. Who is appearing? You are appearing for respondent number 2.
I am appearing. His endorsement has been challenged.
Last time GK but ಅಂತ ಹೇಳಿದ್ರು. Yes.
Milord, the properties, milord, lands falls within the city municipal council. The deemed conversion anta, there is a judgment of some report.
Yes.
Milord, the annexure, milord, H, page 19 is the endorsement issue. When the last paragraph, last may go to ಉಲ್ಲೇಖದಲ್ಲಿ ಪ್ರಾಧಿಕಾರದ ವಕೀಲರಾದ ಬೆಂಗಳೂರಿವರ ಕಚೇರಿ ಕಾನೂನು ಅಭಿಪ್ರಾಯ ನೀಡಲಾಗಿದ್ದು ಕರ್ನಾಟಕ ಭೂ ಕಂದಾಯ ಕಾಯ್ದೆ 64/92 ಅಡಿಯಲ್ಲಿ ಮಹಾಯೋಜನೆ ಅನುಮೋದನೆಯಾಗಿರುವ ಸ್ಥಳೀಯ ಯೋಜನಾ ಪ್ರಾಧಿಕಾರಗಳ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಹಾಗೂ ನಗರಸಭೆ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಭೂ ಉಪಯೋಗ ನಿಗದಿಪಡಿಸಿರುವಂತಹ ಜಮೀನುಗಳಿಗೆ ಸದರಿ ಉದ್ದೇಶಗಳಿಗೆ ಭೂ ಪರಿವರ್ತನೆ ಆದೇಶ ಪಡೆಯದೆ ವಿನ್ಯಾಸ ನಕ್ಷೆಗಳಿಗೆ ಅನುಮೋದನೆ ನೀಡಲು ಅವಕಾಶ ಕಲ್ಪಿಸಲಾಗಿರುತ್ತದೆ. ಹಾಗಾಗಿ ಘನ ನ್ಯಾಯಾಲಯವು ಸಹ ಸದರಿ ನಗರಸಭೆ ವ್ಯಾಪ್ತಿಗಳಲ್ಲಿ ಭೂ ಪರಿವರ್ತನೆ ಪಡೆಯುವ ಅವಶ್ಯಕತೆ ಇರುವುದಿಲ್ಲ ಎಂದು ಕೆಲವೊಂದು ಪ್ರಕರಣಗಳಲ್ಲಿ ನ್ಯಾಯಾಲಯದ ಆದೇಶ ಸಹ ಹೊರಡಿಸಲಾಗುತ್ತದೆ ಎಂಬ ತಿಳಿಸಿರುತ್ತಾರೆ. ಇನ್ಸ್ಪೈಟ್ ಆಫ್ ದಟ್ ಬ್ಲಡ್ ದಿ ಅಥಾರಿಟಿ ಹೊಸಕೋಟೆ ಸ್ಥಳೀಯ ಯೋಜನಾ ಪ್ರಾದೇಶಿಕ ಸರ್ಕಾರದ ದಿನಾಂಕ 31/2018 ಅನುಮೋದನೆಯಾದ ಮಹಾಯೋಜನೆಯಂತೆ ಪ್ರಸ್ತಾಪಿತ ಜಮೀನುಗಳನ್ನು ಯಾವ ಉದ್ದೇಶಕ್ಕೆ ಭೂ ಉಪಯೋಗ ನಿಗದಿಪಡಿಸಲಾಗಿದೆಯೋ ಅದೇ ಉದ್ದೇಶಕ್ಕೆ ವಿನ್ಯಾಸ ನಕ್ಷೆಗಳಿಗೆ ಅನುಮೋದನೆ ನೀಡಲು ಪರಿಗಣಿಸಲಾಗುವುದು. ಜಿಲ್ಲಾಧಿಕಾರಿಗಳ ಕಚೇರಿಯಿಂದ ಕೃಷಿ ಜಮೀನುಗಳಿಗೆ ಅನ್ಯಕ್ರಾಂತ ಮಂಜೂರಾತಿ ಪಡೆದ ನಂತರ ಪ್ರಾಧಿಕಾರದಿಂದ ವಿನ್ಯಾಸ ನಕ್ಷೆಗಾಗಿ ಅನುಮೋದನೆ ನೀಡಲಾಗುವುದು. ಅನ್ಯಕ್ರಾಂತ ಮಂಜೂರಾತಿ ಪಡೆಯದೆ ನೇರವಾಗಿ ವಿನ್ಯಾಸ ನಕ್ಷೆಗಳಿಗೆ ಅನುಮೋದನೆ ನೀಡುವ ಬಗ್ಗೆ ನಗರಾಭಿವೃದ್ಧಿ ಇಲಾಖೆಯಿಂದ ಯಾವುದೇ ಸ್ಪಷ್ಟ ನಿರ್ದೇಶನವನ್ನು ಇಲ್ಲಿಯವರೆಗೆ ಸ್ವೀಕೃತ ಆಗುವುದಿಲ್ಲ. ಹಾಗಾಗಿ ಈ ಬಗ್ಗೆ ಯಾವ ರೀತಿ ಕ್ರಮ ವಹಿಸಬೇಕು ಎಂಬ ಮುಂದಿನ ಸದರಿ ಇಲಾಖೆಯಿಂದ ಮಾಹಿತಿ ಪಡೆದು ಕ್ರಮ ವಹಿಸಲಾಗುವುದು. ಸೋನ್ಸ್
what is the yours is agriculture land?
Agriculture.
That when did you file an application for conversion?
No, the conversion is not necessary. And that is a conversion. If the lands falls within the limits of CMCR municipality or corporation limits, Bekilanta annexure J is the judgment of this. This is Dharwada. Totally measuring 50 acres, 53 acres, 19 gunta situated Attikolla village Taluk and district Dharwad. The petitioner has annexed the communication issued by the Hubli Dharwad Urban Development Authority stating that subject land designated for residential and commercial purpose in the revised master plan. The petitioner claims that the subject land falls within the limits of Hubli Dharwad Municipal Corporation.
Your land comes within the
Hoskote Municipal Corporation. CMC, City Municipal Corporation. In spite of the legal opinion, of course, that is there, but the judgment also speaks like that. So based on this, Lord,
yes,
Lord Gangadharappa. I am appearing for
town planning ನೀವು ಹೇಳಬೇಕು.
planning authority.
Planning authority ಯಾರು?
Hoskote Melodies.
You are appearing for planning authority, Mr.
Yes, please.
Yes.
ಅವರೇ ಒಪಿನಿಯನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಕೊಡ್ಬೋದು ಅಂತಂದು. ಅವರೇ ಒಪಿನಿಯನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಪರವಾಗಿಲ್ಲ.
ಅದಕ್ಕೆ ನಿಮ್ಮನ್ನ ಬಿಟ್ಟು ಅಲ್ಲಿಗೆ ಹೋಗಿ ಇವಾಗ ಯಾರು ಇಲ್ಲ ಅಂತ ಇರೋದು.
ಒಪಿನಿಯನ್ ಕೊಟ್ಟಿರ್ಬೋದು, ಒಪಿನಿಯನ್ ಕೆಲಸ ಸರಿ ತಪ್ಪಾಗಿರುತ್ತೆ.
ಕೊಟ್ಟ ಯೋಜನಾ ಪ್ರಾಧಿಕಾರನೇ ಹೇಳ್ತಾ ಇರೋದು.
Now, so far as provisions of section 95 of the Land Revenue Act, he is working on a different field
and the provisions of the Town and Country Planning Act are relatable to altogether different position. Merely because the land is coming within the limits of the municipality does not mean it ceases to be an agricultural land. It continues to be an agricultural land assessed to revenue. And under the Land Revenue Act, Section 95 specifically provides for conversion of the land for using for any other purpose other than agriculture purpose. That is the mandate of the law. Section 95 is very, very specific, and
There is judgment of this court, which is.
yes,
stated
yes,
upon.
I gone through the judgment. I am relying upon one judgment of the Supreme Court.
Kodi, judgment Kodi. If it's different from the judgment of this court, Supreme Court has
Yes,
said it,
please.
will be bound by the Supreme Court judge. Otherwise, we are bound by the coordinate bench.
Gulf Oil Corporation, yes,
Para 77.
yes, Gulf Oil. The contention that was raised. No, I will take it. I may draw the kind attention of the court to the contention that was taken and urged before the Honorable Supreme Court and the answer of the Honorable Supreme Court relating to that point.
Para
70, 71.
Kindly go to para 25.
27 illappa, 73 ಅಷ್ಟೇ ಇರುತ್ತೆ.
Kindly go to paragraph 25.
25.
25.
Yes.
ಅದೇ ಸೇಮ್ ಜಜ್ಮೆಂಟ್.
ನಾನು ರಿಪೋರ್ಟೆಡ್ ಕೊಟ್ಟಿದ್ದೀನಿ.
ನಂದು ಅನ್ರಿಪೋರ್ಟೆಡ್ ನಂತರ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಇನ್ ಜಜ್ಮೆಂಟ್ ತಗೊಂಡಿದ್ದೀನಿ. I may pass on to the honorable court.
You give us the para number in SEC online which you have given us.
Not that is not SEC. There are 47.
Sorry, no.
Or give us a copy of whatever you are relying on.
Same thing. Please go to page para 25.
Same judgment.
Same judgment.
As court video.
Same judgment.
You can use it in another matter. Para
25.
25.
Kindly go to page 15. I'm sorry. Yes, page 15. Para 25.
Yes.
It has been urged that Urban Land Sealing and Regulation Act 1976 was passed in the year 1976 with effect from 17 to 76, and that the lands at Kakutapalli became urban lands. Therefore, the urban lands are the lands situated within the limits of urban agglomeration and referred to as such in the master plan. And where there is no master plan, any land within the limits of an urban agglomeration and situated in any area included within the local limits of a municipality by whatever name called, a notified area committee, a town area committee, city and town committee, a small town committee, a cantonment board or a panchayat. Therefore, with the enactment of the aforesaid act, the agricultural land changed into non-agricultural urban land. This is the contention that has been taken. Now, the ruling is, kindly go to paragraph 70. At page 40. Page ಕೆಳಗಡೆ ಇದೆ. Similarly, the argument that the land now falls within the urban agglomeration in view of the enactment of Urban Land Sealing and Regulation Act 1976 is again not tenable. Firstly, the said act stands repealed on 22/3/1999. Still, further, the mere fact that the land has come within the municipal limits would not make the land as non-agricultural land. It only means that the land within the municipal limits can be utilized or the buildings be constructed in terms of the provisions of the municipal laws applicable thereto. Similarly, the argument that the land in question falls within the zonal development plan for Kakutapalli as per the communication of Hyderabad Urban Development Authority is again not tenable. The zonal development plan is future planning of the development of the area. Thus, in future, the land can be used only according to zonal development plan, but that does not mean that the agricultural nature of the land has ceased to exist. Therefore, the said communication is also not tenable. So therefore, my submission before the Honorable Court is notwithstanding that the land is situated within the limits of the city municipality or municipality as the case may be, still the land continues to be an agricultural land until it is converted as per the order passed by the competent
That's not
authority.
what this judgment says. This judgment only says that whatever the zonal development plan is, for that it can be used.
That's
Now,
right.
if the land, agriculture land is in residential category of your plan, they can use it only for residential purpose.
But even then, my contention before the court is, even then also, even to use it, supposing the land is under the master plan, comes within the agriculture, the green belt area or residential area, commercial area,
Whatever the zone
industrial
is.
area, so many things are there.
As per the zone,
Still-
that is what the Supreme Court says.
Yes,
The zonal
still-
development plan
My submission before the
can
court
only
is,
be according to zonal development.
correct, my submission is, it may be used for the purpose for which it has been earmarked, but even then, conversion under section 95 is absolutely necessary.
That's not what this judgment says. Yes.
14, my lord, Mayor. Section 14 of the Karnataka Town and Country Plan.
Body. ATCP Act.
Please.
Yes.
14, my lord, it says, my lord, dealt with, my lord, enforcement of the master plan and regulation, my lord. Provided, my lord. Proviso is there, my lord. Married, my lord. Provided that where the use or change of land use under this section needs to diversion of the agricultural land to a non-agricultural purpose, such use or change of land shall not be permitted unless permission to be obtained in accordance with the provision of the Karnataka Land Revenue Act 1964 website.
For such diversion.
Here, my lord, one submission is, my lord, to regarding this regard, the government should say, because, my lord, it comes within the municipality area, my lord, then, my lord, commissioner has, deputy commissioner has no power.
No, there is a judgment of a coordinate bench of this.
My lord,
The judgment of the Supreme Court.
that judgment, my lord,
That it has to be as per the zonal.
my lord, coordinate bench, my lord, consider, my lord, the Karnataka Town and Country Plan Act is not considered. The both judgments, my lord, I have read their judgments. They were just referred, my lord, that judgment is, my lord, it is not dealt with, my lord, Karnataka Town and Country.
Show us the judgment.
Not the. Not, I will give that, my lord. One is my
ಒಂದು argument ಮಾಡ್ಬಿಡೋದು ಆಮೇಲೆ ಕೇಳಿದ್ರೆ
one submission is, my lord, that judgment, my lord, I saw, my lord, in respect of this, this referred in the, my lord, writ petition number 10573 of 26. That says, my lord, they only dealt with, my lord, KLR Act, not, my lord, Karnataka.
both have been dealt.
My,
Both are dealt with in that judgment also.
but the act,
Even the Honorable Supreme Court says land can be used according to zonal development plan.
please, please,
So the restriction
please.
under both is that whatever the zonal plan is, if it is, suppose Gangadhar ಅವರು ಹೇಳಿದಂಗೆ, if it is a buffer green zone, then he can't use it for anything apart from that. Then he has to come back to you for change of land use.
If change of land use, my lord, section 14A is applicable. 95, my lord, only pertaining to the, my lord, pertaining to the, it comes within the only DC only. 14A, my lord, to its go to the government. The authority, they file application before the
Correct.
authority.
For conversion to the deputy commissioner.
Please.
Now that has been rendered redundant in view of that, those two judgments. There are 5 judgments on it actually.
Please, my lord, that regard, my lord, only my submission is, my lord, the act is very clearly say that the conversion is required.
There are judgments now. Do we
Please,
go to the
please.
act or the judgment? That has been interpreted and held that way. Way back some 20 years back, it has been held.
Please, my lord, on
Nobody
that.
has.
If
Division
the
bench
judgment
says-
is rendered, adheres the principles of law as has been mentioned in the enactment. I would only submit
which have been
that,
rendered, we are bound by the judgment.
I would only submit
It
that
can only be upset by a larger bench, by the division bench. If you take it and if your
I am
argument is
I am
successful,
trying to
that could be
submit
that.
before the court that the judgment has been rendered not consonance with the provisions of section 14, which my learned friend read,
Yes,
and they are working in 2 different fields.
yes.
Section 14 and other things. Karnataka
So
Town
what-
and Country Planning Act works in a different field. Land Revenue Act is in a different field. So therefore, we cannot say that the provisions of section 95 is not necessary in case the property comes within the limits of the panchayat or the municipality, as the case may be. It still continues to be an agricultural land. Only thing is, you have to go before the deputy commissioner or the revenue authorities, get the land converted. Where is the difficulty?
Yes. Petitioner is before this court seeking for the following reliefs. The petitioner claims to be the absolute owner of land bearing survey number 111, 112, 113 and
My lord,
114
one submission, my lord.
of Uskote village and Taluk, and survey number 114/1 and 114/2 measuring 1.24 acres and 0.38 guntas respectively.
My lord, one submission. My lord. Regarding, my lord, that land, my lord, earmark is what anta avaru helilla.
Whatever it is earmarked for, that is what we'll say.
Please.
You can't use it for other than what is there in your zonal plan.
Please, my lord. If, my lord, it shows as the agriculture, my lord, then, my lord, please.
Ashte adu.
Please, please.
Change of land use, he has to come to you. Please. Only the first stage of conversion has been done away with by both the judgments. This Honorable Supreme Court also says, as per the zonal development plan. Supreme Court also does not say conversion is required. Dandapallia village, Kasba Obli, Uskote Taluk. The petitioner submitted a plan for sanction to the City Municipal Council along with the representation, which was forwarded to the third respondent, Uskote Planning Authority. The Uskote Planning Authority, after obtaining the opinion of the advocate, issued an endorsement on 19/8/2024 stating that in terms of section 14(2) of the Karnataka Town and Country Planning Act, there is no necessity to get conversion from the Deputy Commissioner under section 95 of the Karnataka Land Revenue Act for lands falling within the jurisdiction of the City Municipal Council. ನಿಮ್ಮ ಒಪಿನಿಯನ್ ಅಗೇನ್ಸ್ಟ್ ಆರ್ಗ್ಯುಮೆಂಟ್
ಅದೇ ಅಪೇಲ್ ಮಾಡ್ತಾ ಇದಾರೆ ಅಂತ ಹೇಳಿದೆ ನನಗೆ.
You are upholding your opinion. Your argument is contrary to your own opinion. Despite the said opinion, the third respondent refused to consider the case of the petitioner for approval of the plan on the ground that the land had not been converted from agricultural to non-agriculture purposes. So in that background, that the petitioner is before this court seeking for the appropriate relief. Shri Nanjareddy Learned Counsel for the petitioner would submit that that admittedly the land of the petitioner falls within the planning limits of the Uskote Planning Authority, as regards which a comprehensive development plan RMP neither. A master plan has been issued, and in terms of the master plan, and a master plan has been issued
on the year of
the property coming within the limits of the Uskote City Municipal Council. His submission is that subsequent to the land of the petitioner coming within the City Municipal Council and the development and the master plan being made applicable to the petitioner, there is no requirement of the petitioner seeking for conversion of the land, and in that regard he relies upon the decision of a coordinate bench of this court dated 13th February 2024 in WP number 100547 of 2024, more particularly para 4 thereof, which is reproduced here under for easy reference. His submission is that once his submission is that the said decision would be applicable on all fours to the present case, and as such the insistence on part of the respondent number 3 for conversion under section 95 of the Karnataka Land Revenue Act is not justifiable. Respondent number 3 ought to have sanctioned the plan, taking into consideration the deeming provision, taking into consideration that the lands are deemed to have been converted for the purpose as designated in the master plan in terms of the aforesaid decision in Savitri's case. Shri A.V. Gangadhar, learned counsel for respondent number 3 would rely upon the decision of the Honorable Apex Court in Civil Appeal number 7759-7760 of 2014, more particularly para 25 and para 70, thereof which are reproduced hereunder for his reference. By relying on Gulf Oil Corporation case, his submission is that the mere fact that the land comes within the municipal limit would not make the land as non-agricultural land, and as such there would be a requirement for the landowner to apply for conversion in terms of section 95 of the Karnataka Land Revenue Act. Nimden submission.
Town and country planning.
Learned Shri New Yarge, BMRD.
BMRD.
Shri Yogesh Nayak, learned counsel appearing for respondent number 2 would refers to the proviso to section 14 of the Karnataka Town and Country Planning Act and submits that the conversion under section 95 is required to be obtained for purpose of use of the land in the manner prescribed under the master plan. Heard so and so previous papers. The short question that would arise for consideration is whether on a land coming within the jurisdiction of the CMC, would there be a requirement for an application under section 95? The short question that would arise is, if an agricultural land coming within the jurisdiction of the CMC, would there be a requirement for conversion proceedings to be taken up under section 95 of the Karnataka Land Revenue Act? Question mark. The above issue is no longer res integra. A coordinate bench of this court in Savitri's case has categorically held that once the land comes within CMC's limit, there would be no requirement to seek for conversion of the land. The decision in Gulf Oil Corporation case, which has been referred to by learned counsel for respondent number 3, again reiterates the said position in as much as what the Honorable Apex Court has said, has held, is that if that though the land, that has held that the mere fact that the land has come within the municipal limit would not make the land as non-agricultural land, but has gone on to say, hold that it only means that the land within the municipal limits can be utilized or the buildings be constructed in terms of the provision of the municipal laws applicable thereto. It is further clarified by holding that the zonal development plan, that in future the land can be used only according to the zonal development plan, which would mean that the usage of the land for the purpose that designated in zonal development plan is permitted once the land comes within the jurisdiction of the CMC. The said decision does not in any manner require a conversion to be obtained under section 95 of the Act, but restricts the usage of the land to that purpose which has been so designated under the zonal development plan. 2570-71. In that view of the matter, I pass the following order. Writ petition is allowed. Tertiary is issued. Annexure H is quashed. Respondent number 3 is directed to consider the application of the petitioner in terms of the above observation and grant such sanction as be necessary as regards the land of the petitioner as per the zoning of the said land under the master plan. Please. Bless.
Pastoral matters. List number 1, serial number 1. Abhinavar.
ಇಲ್ಲಿ ಮೋಹನ್ ಕುಮಾರ್ ಬಂದಿಲ್ಲ ಇವತ್ತು.
ಅವ್ರು ಬಂದಿಲ್ಲ, ಅದೇನೋ ಇವತ್ತು ಸಂದೇನೋ ಎಕ್ಸಾಮ್ ಏನೋ ಇದೆ ಅಂತ ಹೇಳಿ ಬಂದಿಲ್ಲ. Lot for children's exam, a lot parents are under stress.
On behalf of the council for respondent number 1 and 2, an adjournment is sought for. Relist on yavatante exam mugiyadu. released on 16th February.
Very grateful. Let it be removed from the caption or dismissal.
Since the counsel for the petitioner has appeared today, okay, list the matter in preliminary hearing B group.
I'm grateful.
Serial number 8, A.V. Gangadharappa.
Serial number 3, your worship is dismissed, ma'am. Serial number 3, mentioned it.
Serial number 3.
Please, ma'am.
Yes, Mr. Bhatt.
Is posted for dismissal.
ನೀವು ಬೆಳಗ್ಗೆ ಬಂದಿರ್ಲಿಲ್ಲ. ಇದೆಯಾ it survives the matter?
Issuance of a B Khata.
3 ಯಾರು ಇಲ್ವಲ್ಲ ಇವಾಗ.
I'm sorry, my lord, I was under the impression.
ಅದು ಹೊಡೆದಾಕಿ dismissal ಹೊಡೆದಾಕಿ. At the request of counsel for the petitioner, released on 11th February, it is made clear that no further adjournment will be granted. ಅವತ್ತು ಇದ್ಬಿಟ್ಟು argument ಮಾಡಿ. Because many of these old matters, they'll say it is infructuous, we will dismiss it.
Serial number 8, A.V. Gangadharappa.
Appear for the petitioner.
Mr. Ramananda, you are appearing for 4 and
4 and 5.
Nagarajappa,
For
ಅವ್ರು ಬೇಕಾ?
ಬೇಡ ಅವ್ರು ನಂದು reiterate ಮಾಡಿದ್ದಾರೆ.
ಅಷ್ಟೇನಾ?
Facts ಏನಿಲ್ಲ ಇದರಲ್ಲಿ.
Yes.
If
Yes, Mr.
your
Gangadhar.
lordship allows me, I can just take 2 minutes.
He is the petitioner, let him start. Yes.
ಅದು NOC ಅಂತ ತೋರಿಸ್ತಾ ಇತ್ತು ಅವ್ರ ಹೆಸರು. ತಿರ್ಗಾ ಬರ್ತಾ ಇದ್ದಾರೆ ಅಷ್ಟೇ.
ಏನ್ NOC ಅಂತ ತೋರಿಸ್ತಾ ಇತ್ತು?
Somebody else is appearing, he has given NOC, somebody, ಆ ತರ ಇತ್ತು ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ.
You are appearing, Mr. Gangadharappa, M. Mallikarjunaya. ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ ಅವರು. ಮಲ್ಲಿಕಾರ್ಜುನ. Gangadharappa, you are appearing or Mr. Mallikarjuna is?
No, I am appearing.
ಮಲ್ಲಿಕಾರ್ಜುನ ಹಾಕಿದ್ದಾರೆ.
He is an advocate who has signed the wakalat along with me, it appears. Correct, it appears that Mr. Mallikarjuna has signed the wakalat along with me.
Somebody should not come and raise that issue.
ಮೇಡಮ್ ಸ್ವಲ್ಪ ಚೆಕ್ ಮಾಡ್ತೀರಾ ವಕಾಲತ್ತು?
Let him argue, I have no issue.
No, we will have a problem tomorrow if somebody says that.
I was in the impression that because his name is, he has given NOC.
No NOC.
ಅಲ್ಲ ಸರ್, ಕಾಸ್ಟ್ ಲಿಸ್ಟ್ ನಾನು ನಿಮ್ ಬಗ್ಗೆ ಏನು ಹೇಳ್ತಾ ಇದ್ದೆ, ಕಾಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ. I am not, I said you can argue.
Separate wakalat.
Separate ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ.
We don't want to embarrass you in future. Please see that and then decide.
Let him do it. It has been filed subsequently.
ಅದಕ್ಕೆ ನಾನು ನಿಮ್ ಬಗ್ಗೆ ಏನು, I have respect.
ನಾಳೆ ನಿಮ್ಗೆ embarrassment ಆಗುತ್ತೆ.
ಅಲ್ಲ, I have respect to him.
You are right that you bring it
argue.
to a notice so that there is no issue in future.
I have no issues.
M. Mallikarjuna has entered appearance for the petitioner. Delete the name of Shri A.V. Gangadharappa as that appearing for the petitioner. None appears for the petitioner today. If none were to appear for the if none were to appear for the petitioner on next date of hearing, petitioner will have to dismiss to non-prosecution.
I'll take only 2 minutes. This is
unless the petitioner is there.
ಅದು bill 4 bill ಸತ್ತೋಗಿದ್ಕಿ.
Can we pass an order on merits?
Serial number 23.
26.
23.
23. 11th. Mr. Gunjal.
11th February.
My lords, I seek for a short accommodation.
This case, my lordship, challenging the annexure A.
My lords, I'm
See,
praying-
notice issued on the basis of the order passed by the district judge.
My lords, senior.
Challenging a notice.
Yes, my lords.
Annexure A.
You have to only reply to this, madam.
And also district.
Get instruction from your senior.
Yes, my lords.
You have to only reply to this if there is a notice.
And also one more
And
submission.
date may be given. my
Annexure
lords, I'll
page 39 ಅಲ್ಲಿ
Hmm.
ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಆಗಿದೆ. ನಿಮಗೆ ಆರ್ಡರ್ ಆಗಿ ಕಾನೂನು ರೀತಿಯಲ್ಲಿ ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಕೊಟ್ಟು ಎವಿಕ್ಷನ್ ಮಾಡಿ ಅಂತ ಆರ್ಡರ್ ಆಗಿದೆ. ಅದನ್ನ ಬೇಕಾದ್ರೆ ಚಾಲೆಂಜ್ ಮಾಡಬೇಕು, ಇಲ್ಲ ಅಂದ್ರೆ ನೋಟಿಸ್ ಆನ್ಸರ್ ಮಾಡಬೇಕು.
Counsel for respond number 1 to 3. 1 to 3 na ಯಾರಿಗೆ ನೀವು?
1 and 2, 3 ಗೆ ಇವರು ಪವನ್.
ಎಲ್ಲ ಅಪಿಯರೆನ್ಸ್ ಪ್ರಾಬ್ಲಮ್ ಆಗುತ್ತೆ. 1 and 2 ನಾ ನೀವು?
1 and 2 ಗೆ.
Registry Director, correct the appearance for MS Devraj as data paying for respondent number 1 and 2. Learned counsel for the petitioner seeks for a short adjournment. Learned counsel for respondent number 1 and 2 submit that in persons the orders passed by the 5th Additional District and Session Judge at Mysore in MA number 27 of 2015, the impugned notice at Annexure A has been issued. The order in MA number 27 of 2015 not having been challenged.
And also Taluk Executive Officer Direction.
It is for the petitioner to reply to the notice at Annexure A, which would be considered by respondent number 1 and 2. Faced with the above situation, learned counsel for the petition seeks for and is granted a week's time to obtain instruction, make a submission, relist on 9th February. You reply, you tell us when you will reply, we will direct them to consider and dispose of it.
24. H.M. Kishore Kumar.
For the petitioner in 24.1, my lord.
Yes, Pavan. R1 state property.
My lord, the impugned communication.
Just one minute.
Yes, ma'am.
Okay, 38983, they had not appeared on the last date also. 24. Despite the order dated 8/1/2026, there is no appearance on part of the petitioner today also. It appears that the petitioner is not interested in prosecuting matter. Petition is dismissed for non-prosecution. 24.1, Kodi. You are appearing for respondent number 1, Vinay JS for 2. Your relief is against respondent number 1 or 2, madam?
Respondent number 1, my lord. It is at the instance of respondent number 2 that an eviction notice came to be issued against the residents who are the petitioners before this honorable court. If my lords can kindly turn to page 64, Annexure H, my lord.
Then we'll give an opportunity for respondent number 2 to come. If he doesn't come, we'll take up your matter.
Very well.
Just for respondent number 2 today. If none were to appear for respondent number 2 on the next date of hearing, the matter would be taken up for consideration on the basis of submission made by counsel for the petitioner and respondent number 1. Relist on 9th February.
My lord, could I request it to be listed either on the 12th or 13th, my lord?
12th February.
Deeply obliged, my lord. Interim order may kindly be extended, my lord.
Earlier granted is extended till next day.
Serial number 33.
Deeply obliged, my lord.
Ravindra Prasad.
Sorry, Your Lordship, morning. Your Lordship, for the issuance of the B Khata, Your Lordship, I have applied, Your Lordship.
Issuance of B Khata?
B Khata, Your Lordship, because father has gifted.
Somebody is asking for B Khata.
It's been rejected, Your Lordship, without hearing the opportunity.
B Khata also rejected. Why?
Without giving the opportunity, Your Lordship, of hearing, Your Lordship, it has been straight away, they were rejected, Your Lordship. It is.
There is no order passed.
Your Lordship, it is under annexure, Your Lordship, K, Your Lordship, in page 62. ಸದರಿ ಸ್ವತ್ತು ಏಕನಿವೇಶನಕ್ಕೆ ಖಾತಾ ನೋಂದಣಿ ಆಗಿರುವುದರಿಂದ ಖಾತಾ ವಿಭಜನೆ ಮಾಡಲು ಅರ್ಹರಿರುವುದಿಲ್ಲ ಎಂದು ಅರ್ಜಿದಾರರು ಈ ಮೂಲಕ ತಿಳಿಸಿದೆ.
So you are asking for bifurcation?
Khata, Your Lordship, I am asking for the khata.
For the entire property or bifurcated property?
Bifurcate, only to the extent of larger extent, some portion of property has been granted in favor of the daughter.
That is why. You need to apply for a single plan development. You have to comply with that.
Your Lordship, I may be given an opportunity before the.
There's nothing, can we give a direction to them to act in violation of law? You have to apply for a single plan sanction, you apply for it. So when will you apply?
Your Lordship, a month's time.
You had argued this last time also, we told you the same thing. Petitioner is before this court seeking for the following leaves. The petitioner is before this court aggrieved by the rejection of the application filed by the petitioner for grant of Khata. The reason for rejection of the Khata is on the ground that there is that the Khata has been sought for in respect of a portion of the larger property, which would amount to bifurcation, and as such, the single plot development plan has been called upon to be furnished for the purpose of consideration of the said application. I do not find any infirmity in the said endorsement which has been issued by respondent, inasmuch as the larger property admittedly measures 9,600 square feet, and the petitioner has received 4,000 square feet of the said land as a gift. If a bifurcation is to be made in terms of plots, it would be required for the bifurcation to be in accordance with the master plan. And as such, the petitioner would have to approach the jurisdictional town planning authority seeking for such plan. On securing the said master plan, on securing the said single plot development plan, if the petitioner were to make an application to respondent number 2 for issuance of a bifurcated Khata, respondent is required to consider the same and pass necessary orders within 30 days of such application being filed.
Your Lordship, larger area is 3 acres 32 gutters.
9,000.
9,000. There are 2 plots, Your Lordship. 2 daughters it has been gifted. So 4,000.
Larger area is
3 acres 32 gutters.
3 acres 32 gutters. Then more the reason. More the reason.
230 Moot Matter. Naveen J.
Page 186, Your Lordship.
IA 1 of 26 is allowed. 180?
186, Your Lordship. Lordship, there is a notice calling upon the petitioners to vacate the premises. The petitioners are the tenants, Lordship, under the shops belongs to the municipality. The Lordship, the term will be expire on 31st of January 2026, Your Lordship. And they are sought for certain amount, Lordship, 1,48,900. Lordship, I already paid the rents, Your Lordship. So my submission is, Lordship, I produced the notification.
Now an auction is being conducted.
No, not an action.
No action is being
No action is conducted. Your. That is my contention. Your.
So without auction, they've been asked, they've asked you to.
Asking to vacate.
CMC Kollegala, Chamarajnagar.
T. Nagaraj.
T. Nagaraj is directed to accept notice for respondent. Counsel for the petitioner to furnish 2 sets of the petition along with annexures on the said counsel, which shall be so done by end of day 2nd February and acknowledgement filed with the registry. The contention of the petitioner is that without calling for an auction of the properties or without providing a right of first refusal, the petitioners have been called upon to vacate the property stroke shops which had been leased out to the petitioner. You paid all the arrears?
Paid all the rents. If at all, Lordship, any dues, I'm ready.
The submission of learned counsel for the petitioner is that all arrears of rentals have already been paid, and if at all there are any dues notified by a respondent, the same would be paid within reasonable period of time. In that view of the matter, the operation of
J series
annexure J to J16 are stayed till the next date of hearing. In the event of the acknowledgement not being filed by 2nd February, the interim order will stand automatically vacated.
Obliged.
Released on 16th February.
Number 1, serial number 38.
My lords.
Budget.
Yes.
My lords, in the serial number 25 list 2, my lord, state has sought 3 weeks of time, my lord. I request for earlier date. It's section 57, my lord, where it restricts for only for 20 years. The prisoner convict has spent 21.5 years, my lord.
GM police.
GM police.
What is that matter?
3 weeks, then I was in court all 1, my lord.
What is that matter?
The prisoner convict has spent 21 years in prison, my lord.
The interpretation of the 20 years.
Yes, my lord. I request for 1 week.
25 at the request of learned AG released on 5th February.
Deeply obliged.
Lordship, I'm appearing for the petitioners.
Yes.
I'm appearing for the petitioners,
Yes.
my lord. We are seeking a writ of mandamus against the respondent BBMP for their failure to transfer the Khata in our names, that is Dr. Harsha and Dr. Apurva, your lordship. Despite us giving the representation in the year 12th June 2018 itself. We have,
So one thing, you file an online application now. We'll
Okay.
direct them to consider the online application in 30 days.
indeed.
Petitioner is before this court, petitioners are before this court seeking for the following leaves. The petitioners having made an application for issuance of Khata in the name of the petitioners on 26/7/2018, the same not having considered, the petitioners are before this court. The application earlier made by the petitioner being a physical application, and now the requirement being to file an online application accompanied by necessary documents. I have the considered opinion that the interest of justice would be served by permitting the petitioner to file an online application with accompanying documents and directing respondent number two to consider the same and pass necessary orders within 30 days in terms of the Karnataka Sakala So-and-so Act. As such, I pass the following order. Writ petition is partly allowed if an online application is filed by the petitioner for issuance of Khata accompanied by all necessary documents. Respondent number 2 is direct to consider the same and pass necessary orders within 30 days from the date of receipt of such application.
Grateful, ma'am.
39, Naveen Jayan.
ಯಾವ ಮುನ್ಸಿಪಲ್ ಕೌನ್ಸಿಲ್ ಇದು? ಮಹೇಶ್ ಎಸ್ ಇದೆ.
PMC, Kadur, Chikmagalur.
ಕಡೂರ್ ಚಿಕ್ಕಮಂಗ್ಳೂರ್ CMC ಯಾರಮ್ಮ? Anybody has been nominated? 39, Learned Counsel for Respondent is stated to have expired. Registrar Judicial is directed to forward an email to the respondent to issue notice to respondent by way of email, returnable by 16th February.
Serial number 40, Varna ML.
Alex, I appear for the petitioner, please.
Mr. Vivekananda, Onkar.
Now he is appearing. He has to make alternative.
ನಿಮ್ ಜೂನಿಯರ್
ನಾನು restricted.
ಅದಕ್ಕೆ
He has disappeared.
he got an interim order and he ran away. Respondent is not here.
Please,
So,
Manoj.
the petitioner is present. Counsel for respondent number 1. Respondent number 1 is not represented. Relist on 10th February.
Grateful.
If none were to represent respondent number 1 on that date, matter would be taken up for consideration on the basis of submission made by the counsel for the petitioner.
Very much.
41, Arya Devanand.
At the request of counsel for the petitioner, relist on 16th February.
42, Arjun. 43, P.A. Karumbaya.
Appealing for the petitioner, my lord.
Mr. Shivramu. Five o'clock ಆಯ್ತು ಅಂತೆಲ್ಲ ಇಲ್ವಾ? The counsel for the petitioner is present, none appears for respondent number 2 and 3. If none were to be present for respondent number 2 and 3 on the next date of hearing, matter would be taken up for consideration on the basis of the counsel for the petitioner. Relist on 17th February.
Much obliged.
44, Jai Krishna Bhatt.
And only one side is present. I love it. Mr. V.K. Bhatt. We will just adjourn it instead of saying nobody is present bad after 5 o'clock. ಯಾವತ್ತು ರಿಪೀಟ್ ಆಗತ್ತಮ್ಮ ಇದು ಲಿಸ್ಟ್ 1?
16th February.
List one will, remaining matters will repeat on 16th February.
If I just mention one matter, my lords.
One matter, my lords.
My lords,
one submission, my lords. I'm sorry, my lords.
ಹೇಳಿದೆ.
My lords,
Yes, madam.
115, my lords. It is only for
Ah.
filing. My lordship has heard the matter substantially, but only wanted us to file an affidavit, my lords. My lordship may have it tomorrow or on Saturday, my lords. It's-
Non-filing of, oh, this has gone into orders matter.
My lords, tomorrow, it's ready, my lords. It would not be put up, so I couldn't file yesterday. I didn't file, my lords. I thought I can give it in the open court. My apologies. I'll get it filed in the morning. Let it come tomorrow. I will advise day after
One
tomorrow.
ನಿಮಿಷ, just one moment. Page
So-
wise ಎಲ್ಲ ಕೊಟ್ಬಿಡು.
Page number 13, serial number 44 to 46.
46, my lords, I represent the second respondent.
Yes, Masana.
Any date, my lords.
16th.
Please, my lords, please.
16th February ಎಲ್ಲ.
Please.
Page number 14, serial number 47 to 51.
16th. Unless you have some other submission to make, 16th default. So 16th yes ಅಂತ ಹೇಳೋದು ಬೇಕಾಗಿಲ್ಲ. 47 to 51, 16th.
Page number 15, serial number 52 to 56.
Yes. 16th.
Page number 16, serial number 57 to 61.
58, my lord. My lord, 58, my lord.
Yes.
My lord, my lord, in this matter, 3 counsels have changed, my lord. Now this honorable court has directed me to serve the copies again to the 3rd counsel. The 2nd counsel has already filed the objections to it, my lord. It's only transfer of Khata, my lord. They have been refusing to, transfer the Khata because
It's
of the
up to
personal
you.
vendetta of
If
the
you don't
president.
want to serve the copy, we'll be adjourning the matter.
No,
That's all.
I will, my lord. I
Serve a
thought
copy on
opposing.
Mr. Devraj, Ms. Somyaji expired, after that he has appeared, so please give him a copy.
Lord, 61, my lord.
Huh.
61. Lord, in
Please,
this
my
case,
lord.
Lordship has, my lord, given, my lord, directions to consider whether they wanted to purchase the property or, my lord. The short point, my lord, which, because otherwise, my lord, your lordship, because of their, my lord, my entire my lord, construction has been stalled. Because small property, maybe your lordship may remember, it is a 7th.
So you want to sell?
Yes, my lord, that is what, yes, we are ready to.
You're not.
They have got larger property behind that.
Then don't come back later saying I want to buy. Only one opportunity. 61, Lord Counsel for the petitioner submit that the petitioner does not intend to buy the property of respondent number 7 and 8.
Yes.
Relist on 16th.
Great.
Interim order. 57 to 61, 16.
Page number 17, serial number 62 and 63.
63, my lord. 63 ನಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಆಕ್ಷನ್ ಕಂಪ್ಲೀಟ್ ಆಗೋಗಿದೆ ಸ್ವಾಮಿ. ಅಲ್ಲಿ ಇವರು ಇನ್ಫ್ರಾಕ್ಚರ್ ಇದು ಆಕ್ಷನ್ ಹ್ಯಾಸ್ ನಾಟ್ ಪ್ರಾಪರ್ಲಿ ಕಂಟೆಂಡೆಡ್ ಅಂತ ಬಿಟ್ಟು ಬಂದಿದ್ದಾರೆ. ಹಂಗಾಗಿ ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಸ್ವಾಮಿ L1 ಬಿಡ್ಡರ್ಸ್ ಗೆ ಅಮೌಂಟ್ ರಿಲೀಸ್ ಮಾಡಕ್ಕೆ ನಮ್ಗೆ ತುಂಬಾ ಹಿಂಸೆ ಆಗ್ತದೆ. ಎರಡನೇ ಬಂದ್ಬಿಟ್ಟು ಆಲ್ರೆಡಿ ವಿ ಹಾವ್ ಕಂಡಕ್ಟೆಡ್ ದಿ ಎಲೆಕ್ಷನ್ ಆಕ್ಷನ್ಸ್. ಅದರಲ್ಲಿ ರೈಟ್ ಆಫ್ ಫಸ್ಟ್ ರೆಫ್ಯೂಸಲ್ ನ ಕನ್ಸಿಡರ್ ಮಾಡಿಲ್ಲ ಅಂತ ಬಂದಿದೆ. ರೈಟ್ ಆಫ್ ರೆಫ್ಯೂಸಲ್ is not applicable for the reserved category. 18% reservation ಇತ್ತು. SC/ST ಗೆ ರಿಸರ್ವ್ ಮಾಡಬೇಕು. ಅದರಲ್ಲಿ 18% ಗೆ ರೈಟ್ ಆಫ್ ಫಸ್ಟ್ ರೆಫ್ಯೂಸಲ್ ಕೊಡಕ್ ಬರಲ್ಲ ಅಂತ ಗವರ್ನಮೆಂಟ್ ಹ್ಯಾಸ್ ಪಾಸ್ಡ್ ದ ನ್ಯೂ ಸರ್ಕ್ಯುಲರ್.
Why?
ಅದು
new circular has been introduced. Amendment to the 2019.
You can't distinguish.
Somebody has to challenge that.
2019
But ಇವಾಗ ಅದು ನೋಟಿಫಿಕೇಶನ್ ಕೊಟ್ಟಿದ್ರೆ you will have to challenge that notification.
That notification.
ಅಲ್ಲ I am for the town panchayat.
You are for the town panchayat.
I am for the town panchayat.
You are in a hurry to. Who is for the petition? Mr. Balakrishna Astri.
Amendment.
That's it. That's why, my lord.
Notification ನ withdraw ಮಾಡ್ತಾರೆ.
They've taken, we are not producing any order because the file is not before us. 16th ಏನಾದ್ರು urgency ಇದ್ರೆ ಮಾತ್ರ ಅಷ್ಟಕ್ಕೆ ಕೇಳ್ತಾರೆ.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಏನು ಅಂದ್ರೆ L1 ಬಿಡ್ಡರ್ಸ್ ಗೆ ಅಮೌಂಟ್ ರಿಲೀಸ್ ಮಾಡಕ್ ಒಂದು ಆರ್ಡರ್ ಮಾಡ್ಬಿಟ್ರೆ
It's up to you, you want to release.
No.
ನಾವೇನ್ ಬೇಡ ಬೇಕು ಅಂತ ಹೇಳಿಲ್ಲ ಬೇಡ ಅಂತ ಹೇಳಿಲ್ಲ ನಿಮ್ಮ ಇಷ್ಟ ಅದು.
ಅಲ್ಲ if I
No,
get
don't make it an order of the court to do it. If you want to release it, you are entitled.
Earlier date ಅಲ್ಲಿ it was passed, if the town panchayat is willing to withdraw the notification, then it has to be released the L1 bidders amount ಅಂತ ಮಾಡಿದ್ದಾರೆ.
So you withdraw ಆಯ್ತಾ notification, no?
Withdraw ಮಾಡಿಲ್ಲ sir.
ಮತ್ತೆ how can we direct that? You withdraw it and pay no problem. Then they'll withdraw the petition only. New tender notification, if you withdraw, auction notification, if you withdraw, the petition itself will go, there's no problem.
That's right, my lord. Even though if I withdraw, again, the same, we will come to the square one, because right of first refusal ಬಗ್ಗೆ ಒಂದು clarification ಇಲ್ಲ. ಎರಡನೇದು 5% disability, 5% reservation to the disabled persons as per the disability.
Yes, it has to be given.
ಹಂಗಾಗಿ ಅದನ್ನ ನಾವೊಂದು ಮಾಡಿಫೈ ಮಾಡ್ಲಿಕ್ಕೆ ಗವರ್ಮೆಂಟ್ ಒಂದು ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟು ನಮಗೆ ವಿತ್ಡ್ರಾ ಮಾಡ್ಲಿಕ್ಕೆ ಒಂದು ಪರ್ಮಿಷನ್ ಕೊಟ್ಟು
So you are withdrawing and we record your statement, you record ಮಾಡಬಹುದಾ?
we are going
you're withdrawing the tender notification. Let counsel for respondent submit that the present auction notification is going to be withdrawn by the respondent within 7 days from today. He seeks permission to refund the money to the L1 bidders at the auction, as also to rework the auction notification in terms of the applicable.
But ಅಲ್ಲಿ ಅದೊಂದು ಲ್ಯಾಚ್ ಆಗುತ್ತೆ ಸ್ವಾಮಿ. ಅದಕ್ಕೆ ಗವರ್ಮೆಂಟ್ ಹ್ಯಾಸ್ ಟು, ಇಟ್ ಇಸ್ ಎ ಪಾಲಿಸಿ ಮ್ಯಾಟರ್. Government has to formulate the procedure to allot the shops to the SC/ST reserved percentage. ಅದು ಮತ್ತೆ 5% reservation to the disability person.
ನೀವು proposal ಕಳಿಸ್ತೀರಾ government ಗೆ?
ನಾವು ಕಳಿಸ್ತೀವಿ.
You submit that a proposal will be sent to the government with the revised auction notification and parameters. And as and when the same is approved, the fresh auction notification would be issued, wherein the petitioners could also participate. The said submission answers the grievance of the petitioner, placing the said submission on record. Petition stands disposed by directing the respondent state to consider the
procedure to allotment of
consider the revised auction notification by laying down the applicable procedure.
Action notification ಅಲ್ಲ
sir. New auction notification ಕಳಿಸಬೇಕಲ್ಲ. New auction notification ಕಳಿಸಿದಾಗ ಅವರು they'll have to work on it. Revised auction notification, by considering the revised auction notification and laying down the guidelines for allotment of the shops to each of the categories. ಎಲ್ಲ ಇಂಪ್ಯಾಕ್ಟ್ ಆಗತ್ತಲ್ಲ, ಇದು ಚೇಂಜ್ ಆದ್ರೆ ಅಲ್ಲಿ ಇಂಪ್ಯಾಕ್ಟ್ ಆಗುತ್ತೆ.
ಡಿಸಬಿಲಿಟಿ ಬರುತ್ತೆ ಅಗೈನ್ ದಿಸ್ ಒನ್ ಫಾರ್ ರಿಸರ್ವೇಶನ್ ಫಾರ್ SC/ST
percentage change ಆಗುತ್ತೆ to each of the categories, including persons belonging to persons having physical disabilities and those belonging to scheduled caste and scheduled tribe category. ಆಯ್ತಾ? Now anyway, that will be extended till they lay down the guidelines.
Till the revised.
So, automatic extension ಆಯ್ತು. Yes, petitions and disposed.
Page number 18, serial number 64 and 65. Page number 19, serial number 66 to 70.
My lord, kindly Monday, my lord.
And what is the urgency?
Allotment of sites, my lord. Junior council engagement Monday.
17.
Allotment of sites is only
16th ಬರುತ್ತೆ. Yes.
interim order kindly.
Interim order extend.
Page number 20, serial number 71.
Well, it's in 71.3. Well, on the last date of hearing, my lord said, this is that Panchayat tax matter, my lords, where my lords had indicated no precipitative steps shall be taken as against the petitioners, my lords.
Yes.
But my lords, the Panchayat respondent authorities say that that is with respect to the previous demand notices which have been issued, and they're causing some inconvenience, my lords. In fact, Nagarajappa sir had said
PDO, my lord, not to precipitate. There is an interim order. I don't think, my lord.
My lords, I just placed this memo on record, my lords, that subsequent demand.
You filed your objections?
My lord, the state has filed, my lord. It's, primarily state has filed.
You are the
Filed
one.
in one matter, my lord. One matter.
71, your lordship, nothing has been filed. No reply has been received in 71.
Just a moment, please. We are asking them, you are answering. You have filed in which matter?
It is 71, my lords, 1047. In the other matter, we have to file.
17332 all you have filed?
No matters, 1047 of 24.
24, that is 71.3 you have filed.
Please.
So that may be treated as objections in the other matters?
Yeah, already. No, my lords, I need to file because
You need to
prayers
file.
are, yes, my lords. In the other matters, we need to file. I have filed in.
When will you file?
Within 1 week, we'll file.
What about you, Mr. Nagarajappa?
My lord, we will adopt, my lord, this state. If it is possible, my lord, I will also file my lord statement of objection. Primarily, the act is, my lord, done by the state. They are defending the action of the state.
This issue will be avoided and we can hear you and finish.
My lords, my only request would be to add that date, my lords. That's the only issue. It's with the memo. That demand notice has been.
Learned AGA seeks for and is granted 1 more week's time to file a statement of objection in all the other matters. In all the matters. Shri A. Nagarajappa also seeks for and is granted 10 days time to file his objections in all the matters. You file madbeka? The respective counsels for respective counsels for respondents seek for and are granted 10 days time to file their respective statement of objection, which shall be filed on or before 12th February, released on 18th February. Respondents are restrained from taking any coercive steps against the petitioner insofar as any of the pending in respect of any of the assessment years.
Please, just request to include that one date in 71.3, my lords. That's my only.
Assessment years Indian will. You got a better this one than what you're saying, so that there is no confusion.
Deeply obliged.
Obliged, my lord.
Serial number 72. Page number 22, number 74 to 78.
78, my lord. Copy has not served, my lord. The developer is.
The stay granted.
15th of February.
I'm getting for the respondent number 5.
18th.
This matter, 74. Yes.
12th is still fine.
I filed the Vakarat yesterday.
Yes. There's a demolition order. 74 released on 31st.
Serial number 75, my lord. Any short date may be given. For
75.
75, my lord.
Yarge ನೀವು?
For respondent.
ಯಾವ respondent?
Respondent number 1.
Shri Monish Kumar has entered appearance for respondent 1, 2, 3. Delete the name of Shri Pawan Kumar as that appearing for respondent 1, 2, 3. Released on 16th.
78, my lord.
Yes.
Copy, ma'am. Not you, my lord.
Mr. Venkatachalapati.
Serial number 80 also.
My lord, serial number 80, I am for the petitioners, my lords.
80. MS Devraj has entered appearance for 7 to 9. Delete the name of only in 8. Registry is directed correct the appearance to MS Devraj as that appearing for respondent 8 and 9. Yes.
My lord, serial number 80,
Copy.
my lords. My lords, I'll serve the copy also, my lords. My lords, this is the matter where the Gram Panchayats are to be merged into smaller urban areas. Panindra sir is to argue these matters. A
Give
short
him a
date
copy so that he'll.
I shall serve the copy, my lords.
Panindra will not be able to argue until he gets his copies.
Please, my lords, a small, short
Will
date.
you give him the copy?
My lords, by Monday, I shall serve him the copy.
Counsel for the petitioner undertakes to.
Other connected matters, my lord.
One nimsha. Counsel for the petitioner undertakes to furnish copies of the petition along with annexures to all the counsels for the respondent who have not been served.
Please, my lords.
They are granted a week's time to go through the same and make their submission. Connect with birth code.
10th, my lord. 10th of February, my lord.
Connect with
80.
number code.
Number ಗೊತ್ತಿಲ್ಲ ಅವತ್ತು ಅಪ್ಗ್ರೇಡೇಷನ್ ಪಂಚಾಯತ್ ಅಪ್ಗ್ರೇಡೇಷನ್ ಮ್ಯಾಟರ್ಸ್ ಇದೆ.
So released on 10th.
Please, my lords.
Petition copy ಕೊಟ್ಟು ನಾನು.
If copies are not furnished by end of day 2nd February, petition will be liable to be dismissed for non-prosecution.
Please, my lords.
It will be extended.
Page number 23, serial number 79 and 82. Page number 24, serial number 83 to 86.
86 interim order may kindly be extended, my lord.
It will be extended.
Page number
83 lordships.
Emergency.
Public roads, they have blocked it, lordships. Lordships, I have it on Monday, lordships.
Public road has been blocked by whom?
By the apartment association, lordships.
83 released on Monday 2nd.
I'm obliged.
Page number 25, serial number 87 to 89.
87 interim order may be.
Serial number 88. First matter. It's regarding construction in the parking lot. The petitioner was directed to remove it. He has demolished the small construction that is made. Debris are still there. Maybe having in the second list lot can be disposed.
You have removed it. So you have verified.
Yeah, verified.
You're verified.
They have demolished. The debris are still there. The debris are still there.
Debris ಯಾವಾಗ ತೆಗಿತೀರಾ? ತೋರಿಸಿ, ಫೋಟೋ ತೋರಿಸಿ. 1 week he'll remove it. We'll have it after a week. It has not been infructuous until you remove the debris. You can't leave the debris there. When will you? We're giving you a week's time to remove it, which is the connected matter.
It's connected.
88. Learned counsel for the petitioner submit that the demolition has been carried out, and within a week's time the debris would be removed. Relist on 9th February.
Second list is subject to. Second list if possible.
Second list. Yes.
Yes.
Page number 26, serial number 90 to 93.
Serial number 91, my lords.
Yes.
I'm appearing for respond number 5 to 8, my lords.
Yes, madam.
There is an urgency, my lords, because they're constructing the building without the permission of the BBMP, my lords. We have filed a IA also, my lords. Kindly, a date may be given, my lords.
Has the inspection been ordered?
Sorry, my lords.
Has the inspection of the property been ordered?
Yes, my lords, it's already ordered.
Is there?
They have filed the report also.
Apparently no mediation. Now, is there a violation?
Yes,
Then
my
what do you-
lords.
After that, what do you have to do? Have you stopped the construction?
No, my lords, they have not stopped the construction. Still they are
Other
constructing, my
problem.
lords.
91, learned counsel for respond number 1 to 4. Shri Karthikeyan
5
BS
to
is
8, my lords.
1 to 4. Delete the name of Shri Pawan Kumar as that appearing for respond number 1 to 4. Shri Karthikeyan submit that the construction has been stopped. However, the counsel for the petitioner dispute respond number 5 to
8.
You are appearing for
5
you
to
want
8, my lords.
Their petitioner is constructing.
Yes, my lords.
Respond number 5, counsel for respond number 5 to 8 submits that construction is still going on. If there be any violation in the construction, respond number 1 to 4, since there is already admitted violation of the construction, respond number 1 to 4 is directed to ensure that there is no construction which takes place. And if construction is not stopped by the petitioner, to seal the construction area. Yes.
104 serial.
16th.
Page number 27, serial number 95 and 96. Page number.
In all matters, it will be extended. Please don't mention it again.
Page number 28, serial number 97 to 99.
On 97, my lord, we had to file the memo.
Hmm.
That valley area.
Mysore.
Mysore.
When will you file? You are filing that. What about the other councils?
Vivekananda, but our.
You have filed your memo.
Tomorrow, but I not for signature of the
97 relist on Monday.
Monday. List 2, man. List 2.
List 2 ಅಲ್ಲ.
Great.
ಒಬ್ಬರಿಗೆ ಅಲೋ ಮಾಡಿದ್ರೆ ಎಲ್ಲರಿಗೂ ಅಲೋ ಮಾಡ್ಬೇಕು, ಅದು ಪ್ರಾಬ್ಲಮ್.
ಅಷ್ಟೇ ರಿಕ್ವೆಸ್ಟ್ ಅಷ್ಟೇ.
Yes. List 1 is already posted, so it will come
Lord, this
by
one I
default.
filed it in the registry.
No, you file it. The memo of instruction filed by the petitioner is taken on record.
Serial
It's
number
taken on
90.
record.
Record.
Yes.
Page number 29.
My lords, serial number 9098, accommodation may be fixed, my lords.
16th.
6.
Everything is 16th.
Okay.
Page number 29, serial number 100 to 103.
Serial number 101, my lord. For the petitioner, the lordship are given the specific direction to the Khata as well as city municipal whether it comes under commercial property and whether premises has 3 road access, my lord. The lordship may take it on next week.
Inspection has been carried out, my lord, on the date fixed by your lordships. That ADLR, my lord, will have to submit the report.
ರಿಪೋರ್ಟ್ ಬಂದಿದೆಯಾ ನಮ್ಮ 100 ಅಲ್ಲಿ
104.
100
101.
101
Please.
report has come. ನಿಮ್ಮ ಹತ್ರ ಬರಲ್ಲ ಅವ್ರ ಫೈಲ್ ಮಾಡ್ಬೇಕಲ್ಲ ನಿಮ್ಮ ಫೈಲ್ ಏನ್ ತೆಗಿಯಕ್ ಹೋಗ್ಬೋದು. ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಇನ್ಸ್ಪೆಕ್ಷನ್ report.
Inspection has been done. I have to file my report.
When inspection, Mr. Vivekananda also said
The ADLR Kolar, my lordship, he told him.
that all the councils submit that inspection has been carried out. And AGI seeks for a week's time to place the inspection report on record. Relist on 9th February.
Serial number 100, interim order to be extended.
Yes, madam.
Serial number 102, my lordship. I want to be extended. Serial number 102.
How many times do we say don't mention about interim order? It will be extended.
Okay.
Page number 30, serial number 104 and 106.
104, my lordship, in this case, writ petition copy has not mentioned. 104 ಅಲ್ಲಿ.
ಅವ್ರು ಇಲ್ಲ ಇಲ್ಲಿ.
Page number 31.
106, my lord. 106, my lord. Because I ಇದೆ interim order ಇದೆ.
ಏನಾಗಬೇಕು?
ಅದು ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ ಬಿಡಿ.
ಸರಿ.
Vacated.
Sorry, sorry.
Page number 32. Number 110 to 112.
Lord, serial number 111, my lord. 111, my lord. Serial number 111. Even in that matter, there was a direction by this honorable court, my lord, to
Report.
conduct.
It's ready, my lord.
It's ready.
Yes.
Copy ಕೊಟ್ಬಿಡಿ.
Yes.
And AGI has filed a inspection report. The same is taken on record. Copies are furnished to the counsel for the petitioner and the other respondents who seek for 10 days time to go through the same and make the submission. Relist on 16th February.
Lord, on 17th.
17th February.
Was conducted on 18th December itself.
Filing a memo.
3 occasions they were not extended.
Memo, lordship. 112.
Inspection report has been filed. Same is taken on record. Counsel for the petitioner seeks for a week's time to go through same and make a submission. Relist on 16th. 108. And then you file your objection. 16th ಬರುತ್ತೆ ಅದೆಲ್ಲ.
My lord, serial number 97, there was interim order, my lord, that is required.
How many times do we say interim order will be extended?
Please.
Serial number 54, my lord.
ಹೇಳಿ ಮಾ. Next.
Page number 33, serial number 114 to 117.
My lords, 115, my lords. Serial number 115, my lords.
You have to file an affidavit.
My lords, affidavit is ready, my lords. My lordship, I have it tomorrow. It's ready, my lords. I've kept it.
Counsel for the petitioner seeks for 2 days time to file the affidavit. Relist on Monday.
Grateful.
Page number
Lordship, serial number 117. It matters already been listed twice, your lordship, and it is not reached. Short accommodation will be granted.
Non-compliance of office objection. First, you comply with the office objection.
Put up a dispensation application, your lordship. We've complied with everything.
ಅಷ್ಟೇನಾ?
Page number 34.
The cancellation of Khata, my lord.
ಏನಾಗಬೇಕು?
Interim order is there, my lord, but plan is not mentioning.
Yes, 16th ಬರುತ್ತೆ ಅದು.
120, serial number 120, producing photo.
ಯಾವ್ದು?
Your lordship, 120, serial number.
Serial number?
120.
ಏನು?
Photo ತಾವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಲಿಕ್ಕೆ ಹೇಳಿದೆ, ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತಿದ್ದೇನೆ. Kindly have to next week.
120 memo has been filed with photograph. Same is taken on record.
Kindly have to next week, my lord.
16th ಬರುತ್ತೆ.
Yes.
Interim order.
ಅದು 16th ಎಲ್ಲ 16th. ಫೆಬ್ರವರಿ. ಎರಡೇ ವಾರ. ಎರಡೇ ವಾರ. ಅಲ್ಲ ಎಲ್ಲ ಒಂದೇ ಡೇಟ್ 16th 74 31st ಯಾವುದು 92 ನಾ ಸರ್ ಬರ್ಕೊಂಡಿದ್ದೀನಿ ಸರ್ ಹೇಳಿ
45
16 ಫೆಬ್ರವರಿ ಡೇಟ್ ಕೊಡಲ್ಲ, ಆರ್ಡರ್ ಬರದ್ಮೇಲೆ ನಿಮ್ಗೆ ಒಂದಿನ ಮುಂಚೆ ಗೊತ್ತಾಗುತ್ತೆ. ನೀವು ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್ ಅಲ್ಲಿ ನಂಬರ್ ಎಲ್ಲ ರಿಜಿಸ್ಟರ್ ಮಾಡಿಲ್ವಾ? ನಂಗೆ ಗೊತ್ತಿಲ್ಲಪ್ಪ, ನಿಮ್ಗೆ ಹೆಂಗ್ ಗೊತ್ತಾಗುತ್ತೆ ಅಲ್ಲಿ? ಇವತ್ ಕೇಸ್ ಇದೆ ಅಂತ ಹೆಂಗ್ ಗೊತ್ತಾಯ್ತು? ಯಾವ್ದು 31 ಮೇಡಮ್ 31
ಮೇಡಮ್ 111 ಸೀರಿಯಲ್ ನಂಬರ್
19th ಫೆಬ್ರವರಿ. ಅದೇ ಹೇಳಿದ್ರು ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು.
111 ನಲ್ಲಿ
63 ಡಿಸ್ಪೋಸ್ ಅವ್ರು ಮಾಡಿದ್ರು ಬಾಲಾಜಿ.
ಮೇಡಮ್ 11
7 ಅಲ್ಲಿ ರಿಸರ್ವ್ ಅಂತ ಬರ್ದಿದೀವಿ. ಡೇಟ್ ಕೊಡಲ್ಲ. ಇದು ಯಾವ ಎಷ್ಟನೇ ಸೀರಿಯಲ್ ನಂಬರು? 59 ಇಲ್ಲ, ಒಂದ್ ನಿಮಿಷ ಹೇಳ್ತೀನಿ. ನೀವು ಅದಕ್ಕೆ ಅಡ್ವೊಕೇಟ್ ನಿ ಎಂಗೇಜ್ ಮಾಡ್ಕೊಂಡ್ರೆ ಅವ್ರೆಲ್ಲ ನೋಡ್ಕೊಂತಾರೆ. ನೀವು ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್ ಅಂದ್ರೆ ಹಿಂಗೆ ಆಗೋದು. ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ ತಪ್ಪಿದೆಪ್ಪ, 59 ಅಲ್ಲ, ಗೊತ್ತಿಲ್ಲ. ಇಷ್ಟಿದೆ, ಹುಡುಕ್ಬೇಕು. ಇಷ್ಟಿರುತ್ತೆ ಲಿಸ್ಟು. 89 ಅಲ್ಲ, 89 ಅಲ್ಲ. ಒಂಚೂರು ಆಚೆ ಲಿಸ್ಟ್ ಇದೆ, ನೋಡ್ಕೊಂಬನ್ನಿ. ಇವ್ರಿಗೆಲ್ಲ ಉತ್ತರ ಕೊಡ್ತಾ ಇರ್ತೀನಿ. ಆಚೆ ಅಲ್ಲಿ ಲಿಸ್ಟ್ ಇರುತ್ತೆ.
ಮೇಡಮ್ 111 ನಲ್ಲಿ ಇದು ರಿಪೋರ್ಟ್ ಟೇಕನ್ ಆನ್ ರೆಕಾರ್ಡ್ ಅಂದ್ರು. ನಾನು ಇದ್ರಲ್ಲಿ ಕೌಂಟರ್ ಫೈಲ್ ಮಾಡ್ಲಾ ಇಲ್ಲ ನಾನು ಮೆಮೊ ಹಾಕ್ಬೇಕು?
ಟೇಕನ್ ಕೊಡ್ತೀನಿ, ಪೇಪರ್ ತಗೊಳ್ಳಿ.
ಮೇಡಮ್ ಟೈಪ್ ಮಾಡಿ
ದಿನ ಮಲ್ಕೊಳಕ್ ಮುಂಚೆ ಚೆಕ್ ಮಾಡಿ.
ಮೇಡಮ್ ಹ್ಯಾಂಡ್ ರಿಟನ್ ಟೈಪ್ ಮಾಡಕ್ಕೆ ಬೆಳಿಗ್ಗೆ ಕೊಡ್ಲಾ?
ಈಗ ಬರ್ಕೊಟ್ರೆ ಚಂದ. ಯಾಕೆ ಗೊತ್ತಾ, ಫೈಲ್ ನಾಳೆ ಸಿಗಲ್ಲ. ಸ್ಟೆನೋಗ್ರಾಫರ್ ಹತ್ರ ಇರುತ್ತೆ.
ಕೊಡಿ ಮೇಡಮ್.
ಯಾವ ಲಿಸ್ಟ್?
ಏರಿಯಾ ಇದು
68 16 ಫೆಬ್ರವರಿ ಎಲ್ಲ 16. ನಾಳೆ ಅಂದ್ರೆ ಫೈಲ್ ಸಿಗಲ್ಲ ಸರ್. ನಾಳೆ ಫೈಲ್ಸ್ ಅಲ್ಲಿ ಇರ್ತೀವಲ್ವಾ, ಅದಕ್ಕೆ ಚೇತನ್ ರಜಾ ಅಂತೆ. ಅದು ರಿಪೀಟ್ ಹೇಳಕ್ಕ
ಇಲ್ಲ ಅಂದ್ರೆ ಕೌಂಟರ್ ಫೈಲ್ ಮಾಡಿ ಅಂದ್ರೆ ನಾಳೆ
ಇಲ್ಲ.
ಮೇಡಮ್ 63 ಏನಾಯ್ತು?
63 ಇವ್ರ ಹೆಸರು ಹಾಕ್ಬಿಡಿ.
63 ಇವ್ರ ಹೆಸರು. ಯಾರ ಹೆಸರು ಹಾಕ್ದಿಯಪ್ಪ? 63 ಗೌರ್ಮೆಂಟ್. 63 ಗೌರ್ಮೆಂಟ್ ಯಾರು ಹಾಕಿದ್ರಿ?
ನಾನ್ ನಿಂತಿದ್ದೆ, ಆದ್ರೆ ಗೋಪಣ್ಣ ಸರ್.
ಬನ್ನಿ ಮೇಡಮ್, ಕೂತ್ಕೊಳ್ಳಿ, ಹೇಳಿ ಸ್ವಲ್ಪ. ಕೂತ್ಕೊಳ್ಳಿ ಒಂದ್ ನಿಮಿಷ. ಇದು ಮಾಂತೇಶ್, ಇದು ನಮ್ದು ಕಳಿಸ್ತೀವಿ. ಇದು ಮಾಂತೇಶ್, ಇದನ್ನ ಮಾತ್ರ ಮಾಂತೇಶ್.
ನಾಳೆ ಕೆಲವಾರು ಪೋಸ್ಟ್ ಆಗುತ್ತೆ.
ಏನ್ ಮೇಡಮ್?
ನಾಳೆ ಒಂದಷ್ಟು ಲಿಸ್ಟ್ ಆಗುತ್ತೆ. ಇವತ್ತು ಮೂವ್ ಮಾಡಿದ್ದು.
ಹೌದಾ ಮೇಡಮ್? ಸರ್ ನಾಳೆ ಫ್ರೆಶ್ ಮಾಡಿಟ್ಟಿರುತ್ತಂತೆ.
ಅಲ್ಲ, ಫ್ರೆಶ್ ಅಂದ್ರೆ ಆ ಫ್ರೆಶ್ ಅಲ್ಲಿ ಮೂವ್ ಮಾಡಿದವ್ ಮಾತ್ರ. ಯಾರಾದ್ರೂ ಡೆಮಾಲಿಷನ್
ಎಂಡ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ಅದಕ್ಕೆ ಪವನೇ ಬರ್ತದೆ.
ಅಲ್ಲ, BBMP ಆದ್ರೆ ಬೇರೆದಾದ್ರೆ
ನಾನು ಇರ್ತೀನಿ. ಕಂಪ್ನಿ ಮ್ಯಾಟರ್ಸ್ ನನ್ಗೆ ಹಾಕಿದ್ದಾರೆ.
ಹೌದಾ?
3 ಮ್ಯಾಟರ್ ಇದೆ ನಮ್ದು. ಅಡ್ವಾನ್ಸ್ ಲಿಸ್ಟ್ ಬಂತಲ್ಲ.
ಈ ಅಡ್ವಾನ್ಸ್ ಲಿಸ್ಟ್ ಹಾಕೋದು ಎಷ್ಟು
ಬರ್ಡನ್
ತೊಂದ್ರೆ ಆಗ್ತಿದೆ ಗೊತ್ತಾ? ಹೌದು, ನಿಮ್ಗೆ ಏನಾಗ್ತಿದ್ಯೋ ಗೊತ್ತಿಲ್ಲ.
ಅಯ್ಯೋ, ನಮ್ಗಂತೂ ಡಬಲ್.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಬಿ ಗ್ರೂಪ್ ಮ್ಯಾಟರ್ ಡೇಟ್ ಕೊಟ್ರ ಫಸ್ಟ್ ಲಿಸ್ಟ್?
16th ಫೆಬ್ರವರಿ
ಎಲ್ಲ ಮ್ಯಾಟರ್ ಮೇಡಮ್?
ಸರ್ ಎಲ್ಲಾನು
ಇಲ್ಲಿ ತನಕ 69 ರೀಚ್ ಆಗಿರಲ್ಲ ಮೇಡಮ್? 69?
ಇಲ್ಲ ಸರ್, ಇಲ್ಲ ಅಷ್ಟೆಲ್ಲ ಆಗ್ಲಿಲ್ಲ.
ಓಕೆ ಮೇಡಮ್, ಥ್ಯಾಂಕ್ ಯು.